Let the doors be opened.
Thank you very much. Il est de mon devoir de déposer.
It is my duty to lay before the House, pursuant to subsection 94.2 of the Access to Information Act and to subsection 72.2 of the Privacy Act, the reports of the Auditor General of Canada on the administration of these acts for the fiscal year ended March 31st, 2025. Pursuant to Standing Order 108.3H, these reports are deemed to have been permanently referred to the Standing Committee on Access to Information, Privacy, and Ethics.
It is my duty to lay before the House, pursuant to subsection 94.2 of the Access to Information Act and to subsection 72.2 of the Privacy Act, the reports of the Information Commissioner of Canada on the administration of these acts for the fiscal year ended March 31st, 2025. Pursuant to Order 108.3H, these reports are deemed to have been permanently referred to the Standing Committee on Access to Information, Privacy and Ethics. The Parliamentary Secretary to the Minister of Energy and Natural Resources.
Mr. Speaker, pursuant to Standing Order 32.2 and consistent with the policy on tabling of treaties in Parliament, I have the honour to table in both official languages the treaties entitled Agreement between the Government of Canada and the Government of the Republic of Poland on the Protection of Classified Information, done at Warsaw on January 16, 2025, and Agreement between Canada and the Portuguese Republic on the Mutual Protection of Classified Information, done at Lisbon on September 16, 2025.
Dépôt de projet de loi émanant du gouvernement.
Introduction of government bills.
Déclaration de ministres.
Statements by ministers.
Rapport de
Reports from interparliamentary delegations.
de
Presenting reports from committees. The Honourable Member for Davenport.
Mr. Speaker, I am here this morning to present in both official languages the first report of Standing Committee on Citizenship and Immigration in relation to the motion adopted on Tuesday, September 16, 2025, regarding Canada's immigration system.
The Honourable Member for Humber River, Black Creek.
Languages. The first report of the Liaison Committee, entitled Committee Activities and Expenditures from April 1st, 2024 to March 23, 2025. Thank you, Mr. Speaker.
The Honourable Member for Mississauga Lakeshore.
Mr. Speaker, I have the honour to present in both official languages the following two reports of the Standing Committee on National Defence. The first report, entitled Gaps to Fill Housing and Other Needed Supports for Canadian Armed Forces Members and Their Families. And the second report, entitled Rebuilding Trust, Transparency and Accountability in the Department of National Defence and the Canadian Armed Forces. Pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to each of these two reports.
Dépôt de projet de loi.
Introduction of private members' bills. The Honourable Member for Pierre Boucher, Les Patriotes Verchères. Thank you, Mr. Speaker. I am very proud to table a bill to withdraw Quebec from Canadian multiculturalism. Canadian multiculturalism is in direct opposition with the Quebec integration model, interculturalism. We do not subscribe to the Canadian vision, which is reductrist for Quebec. There is no right to integration, no recognition of the existence of the people, Quebec people. It can divide people, while the Quebec model encourages progressive convergence of cultures and discussions between newcomers and the welcoming society. The Quebec model is not about rejecting the other, but adding them to who we are. Canada treats Quebec like an administrative sub-entity, but we are ready to govern ourselves.
Barcelou.
Mr. Barcelou Duval, seconded by Mr. Champoux, moves that this bill, an act to amend the Canadian Multiculturalism Act, non-application in Quebec, be now read a first time. This motion is deemed adopted. Carried.
This bill, première lecture de ce projet de loi.
Quand ce projet...
When shall this bill be read a second time? At the next sitting of the House.
Ms. Thomas, seconded by Mr. Caputo, moves for leave to introduce a bill entitled An Act to Amend the Criminal Code, Consecutive Sentences for Sexual Offences. This motion is deemed adopted. The Honourable Member for Lethbridge.
Mr. Speaker, for over a decade, Liberal justice policies have increasingly favored criminals, therefore undermining the safety and dignity of victims and communities alike. Nowhere is this more painfully evident than in the cases of sexual assault. Sexual violence is one of the most devastating violations a person can suffer. It strips away their dignity, their safety, and their trust. Yet multiple sexual assaults are often treated as if they are one offense, therefore minimizing harm, weakening deterrence, and eroding public trust. Since 2015, sexual assaults have increased nearly 75%, and offenses against children by 120%. Liberal reforms have repeatedly prioritized repeat offenders, sending the wrong message that protecting predators matters more than protecting Canadians. Come on.
From the Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, you have commented in terms of brevity and introduction of private members' bills. We're finding that they're becoming more and more political. The statement that was just made is an excellent demonstration of that. I think we need to go back to the standing orders in providing comment on private members' bills and how they're supposed to be introduced.
Yes. Typically, I think we're aiming for interventions of about 60 seconds when introducing a private member's bill. And the Honourable Member hadn't reached the 60-second mark, so she has a little bit of time, not much more. Well, that... So would the member like to conclude and continue? Yes, Yes, the Honourable Member for Kamloops, Thompson Nicola.
Mr. Speaker, that member politicizes just about everything. So this member should be able to start from the top. That was a deliberate attempt, in my view. She was not able to say what she needed to say to the Canadian public in one stream of thought. She should be entitled to start again. Thank you.
I'll give her a little more time, but not from the top. Please go ahead.
Mr. Speaker, my point is clear that for over a decade, Liberal justice policies have increasingly favored criminals and undermined the safety and dignity of victims and communities alike. The bill that I'm bringing forward today seeks to put victims ahead of criminals, which is where we need to land as a country. Liberal reforms have repeatedly prioritized repeat offenders, sending the wrong message that protecting predators matters more than protecting Canadians. And this practice is wrong, and it must end. My bill amends the criminal code to require courts to impose consecutive sentences rather than concurrent ones for sentences for sexual offenses. With my bill, each crime will carry its own penalty, and each victim will receive the recognition they deserve. It's long overdue that we put victims ahead of criminals, and I hope I can count on all members of this place to agree with that.
Yeah.
The Honourable Member for Lethbridge, Mrs. Thomas, seconded by Mr. Caputo, moves that the bill be now read a first time and be printed. The motion is deemed adopted.
First reading of this bill, première lecture.
Order, please. Order. The motion is deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House.
First reading of Senate public bills. Motion.
Motions. Presenting petitions.
Honorable député de Rosemont.
The Honourable Member for Rosemont-la-Petite-Patrie, I believe. Yes, thank you, Madam Speaker. Thank you. I rise to table a petition signed by hundreds of people which says that people with disabilities obviously deserve to live in dignity. Unfortunately, the new Canadian Disability Benefit does not help them reduce their poverty significantly. And furthermore, this is tied to tax credits. The problem is that only 1.6 million people have tax credits. There's 8 million people living with disabilities. During COVID, we recognized a $2,000 threshold for people to live in dignity, and so we think that that's what it should be set for the Canada. It should be separated from the disability tax benefit to improve accessibility to people. Thank you, Madam Speaker.
For Courtney Alberni.
Madam Speaker, it's an honor to table this petition on behalf of petitioners from my riding of Courtney Alberni who are on the front line of wildfires this season. They highlight that the increasing intensity and cost of wildfires in Canada, not just in British Columbia but across the country, requires bold and timely action. Madam Speaker, without a national air taker fleet, each province must weigh the cost of purchasing or contracting aviation resources with no guarantee that resources will be available when and where they are needed most. Fighting wildfires and addressing the climate crisis demands a wartime level of effort and commitment. Other countries retrofit retired military aircraft for aerial firefighting and providing rapid response capability and national resilience. The conversion of Canada's retired 130 Hercules fleet into the state-of-the-art air tankers would protect communities' critical infrastructure and help meet climate commitments by reducing catastrophic carbon releases from wildfires. They cite that they're calling on the government to work in partnership, Madam Speaker, with the private sector in collaboration with potential First Nations partners to retrofit a portion of Canada's retired CC-130H Hercules fleet into large air tankers for wildfire suppression, deploy these aircraft as part of a strengthened national wildfire response capacity to be shared with provinces and territories, and where appropriate, available for international humanitarian and emergency response missions, and finally, prioritize this Made in Canada solution that leverages Canadian engineering, global expertise, and delivers clear benefits in protecting lives, communities, and the environment. Thank you, Madam Speaker.
Presenting petitions, the Honourable Member for Winnipeg North.
Thank you, Madam Speaker. It's with pleasure that I table a petition from residents that are genuinely concerned about health care, from everything dealing with credential recognition to the treatment that nurses and healthcare professionals get into facilities, to capital infrastructure, and so much more. And what they're asking for is a higher sense of cooperation between the different levels of government in order to be able to achieve the type of health care that Canadians expect to see. Thank you, Madam Speaker.
Presenting petitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Madam Speaker, I would ask that all questions be allowed to stand at this time, please.
Agreed. Agreed. I believe the Honourable Member for Brantford, Six Nations is rising on a point of order.
Thank you, Madam Speaker. Last Tuesday, a video was shot in a vacant committee room. I was involved in the video, as were my colleagues from the Justice Committee from the Conservative Party. In that video, we drew attention to the fact that although this was a regular day to hold a Justice Committee meeting, that there were no Liberals present at this particular meeting and no member from the Bloc Québécois. The truth of the matter is, opposition members do not set the schedule on Justice Committee. That is done by the Liberal Party. The video had unintended consequences to the Bloc Québécois, and in particular, my colleague and friend, the member from Rivière du Nord, for which I apologize. But the fact of the matter is, they control the agenda. We were ready to conduct a meeting on that particular day, and the Liberal Party did not appear. Thank you.
The Honourable Whip of the Bloc Québécois. Madam Speaker, well, first of all, I'll start by thanking my colleague. We appreciate that on September 16th, the member for Brantford Six Nations filmed a video in the committee room when the meeting had not been scheduled. We had discussions between the parties about this, and first of all, I would like to say, thank you for the recognition of the harm done. We have to be careful, and we need to protect parliamentary privilege, and we cannot mislead Canadians. as the committee had not been scheduled, the video might make people think that the people from the government and the Bloc Québécois were not at work, but we are at work. And obviously, if a committee is not scheduled, we won't be in attendance. We have a lot of things to do, and I think it's important in the House to show the shared values of respect for the work of all members and to be careful. Once again, we thank them, but let's be careful in the future. And I am sending this to people in the House. We are here to work for the common good. I invite us to not make personal attacks or denigration, but we need to focus on the substance, on our issues, our political positions, on which, of course, there will be disagreements, but on which we can also achieve consensus. We need to work for the common good in shared respect. Thank you for this undertaking, and we must be careful going forward.
The Honourable Parliament Secretary to the Government House. These are all the same point of order.
Same point, Madam Speaker. I think it's important to recognize that the meeting was actually scheduled for the Thursday, not the Tuesday. And even the manner in which the member apologized, and I appreciate and I thank him in terms of raising the profile of the incident, but in his concluding remarks, he still made a suggestion that the Liberals didn't show up.
That's right.
Well, the Liberals didn't show up because there was not a scheduled meeting. It wasn't till Thursday.
Ordre du jour.
Orders of the day.
Ordre émanant du gouvernement, travaux des...
Motion in the name of Mr. Fortin of Rivière-du-Nord. Constitutional powers of Quebec and the provinces. Mr. Fortin, seconded by Ms. Normandin, moves that the House, A, call on the government to fully withdraw from the legal challenge of Quebec's act respecting the laicity of the state before the Supreme Court. B, call on the government to withdraw its factum filed on September 17, 2025 with the Supreme Court contesting Quebec's right to invoke the notwithstanding clause. And C, denounce the government's willingness to use the Supreme Court to take constitutional powers away from Quebec and the provinces. The Honourable Member for Rivière-du-Nord.
Merci, Madame la Présidente.
Thank you, Madam Speaker. Before I start, I'd like to advise you that I'll be sharing my time with the member for Saint-Jean, the leader of the Bloc Québécois in the House of Commons. Madam Speaker, I'm very happy to rise today to speak to this motion, which I have the honour of moving on behalf of the Bloc Québécois. I will read it, just in case my honourable colleagues have not had the time to consult it, that the House call on the government to fully withdraw from the legal challenge of Quebec's act respecting the laicity of the state before the Supreme Court. B, call on the government to withdraw its factum filed on September 17, 2025, with the Supreme Court contesting Quebec's right to invoke the notwithstanding clause. And C, denounce the government's willingness to use the Supreme Court to take constitutional powers away from Quebec and the provinces. So there are three very clear points, Madam Speaker, that we'll have the opportunity to look at closely. But first, I'd like to make a few reminders that I think are important before we begin today's debate. First of all, the notwithstanding clause. It's hated by the current government, which sees this atrocity as a sword of Damocles hanging over the Canadian Charter of Rights and Freedoms. The notwithstanding clause is nothing less than the tool which allowed Pierre Elliott Trudeau's Liberal government to repatriate the Constitution without Quebec's consent. It was the knife that was used on the night of the Long Knives. Without the notwithstanding clause, there would have been no agreement with the provinces, no René Lévesque left alone in his corner. And why is that, you may ask? Well, Madam Speaker, this provision assures the provinces that the federal government and its charter are not a higher level of government, that the federal charter does not override the will of the provinces, and that the parliamentary sovereignty of the provinces is in no way called into question. The notwithstanding clause allows the governments of Quebec and the provinces, and the federal government, to pass laws notwithstanding Section 2 or Sections 7 to 15 of the Charter of Rights. I will read the section to you, Section 33, because I am far from certain that everyone in this House has read it. So, Madam Speaker, Section 33, 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be. Sorry, the Honourable Member for Rivière-du-Nord. Okay. I'll start that over, Madam Speaker. Section 33(1). Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of this Charter. 2. An act or a provision of an act, in respect of which a declaration made under this section is in effect, shall have such operation as it would have, but for the provision of this Charter referred to in the declaration. 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force, or on such earlier date as may be specified in the declaration. 4. Parliament or the legislature of a province may reenact a declaration made under subsection 1. And 5, subsection 3 applies in respect of a reenactment made under subsection 4. Nowhere, Madam Speaker, is there any mention of preemptive or non-preemptive use. And nowhere is there any mention of a limit on the number of times the notwithstanding clause may be renewed. It's just a tool. So that's my first reminder. The Government of Quebec has the right to use the notwithstanding clause as it sees fit, within the limits of its scope, obviously, and it's not up to Ottawa to impose its point of view. My second reminder is that since the 1960s, Madam Speaker, Quebec has made secularism a fundamental element of the way that its people live together. First, education was secularized with the creation of the Ministry of Education. Then, classical studies were replaced by cégeps, and teachers traded their priestly robes for pants and took off their nuns' caps and let their hair down. This secularization continued until a constitutional amendment put an end to denominational school boards, which were replaced by linguistic school boards. Over the last 20 years, there have been debates on reasonable accommodations. There was the Bouchard-Taylor Commission. There were public consultations on the Charter of Values. Those lasted for months and months. There was debate on Bill 21. And more recently, there was the Pelchat-Rousseau Commission on the limits of the Act respecting state secularism. For 60 years, Quebec has been thinking seriously about secularisms, and it's been laying the foundations for Quebec's social cohesion, separation of church and state, French as the common language, equality between women and men, and recognition of a common historical heritage. And for 60 years, Ottawa has been trying to sabotage Quebec's efforts by challenging our way of doing things. And you know, Madam Speaker, even today, and you know it, I'm sure, this House continues to begin its daily proceedings with a prayer. It's one thing for this government to remain completely inactive in protecting secularism, but what it's doing now is even worse. It's trying to weaken Quebec's state secularism. That is literally judging and condemning. It shows a lack of respect for Quebec's choices from a position of moral superiority that it has given to itself. Ottawa simply doesn't like the choices that Quebec society has made. So here we are today with this motion that asks 3 things of the federal government. 1, do not challenge Quebec's choices in the Supreme Court. 2, keep your thoughts to yourselves. And 3rd, it's a really bad idea to use this case to weaken Quebec and the province's power. When we drafted this motion, the Attorney General of Canada had not yet filed his brief. And what we knew at that time was that Ottawa was going to strictly challenge the use of the notwithstanding clause, but not the Secularism Act. Now, we found this absurd. You know, without the notwithstanding clause, laws on secularism and laws on the protection of the French language would inevitably end up in court. So for months, we were under the impression that Ottawa was going to the Supreme Court to weaken Quebec's state secularism, but we were wrong. The federal government is going to the Supreme Court to take away Quebec's tools for establishing rules and guidelines for its social cohesion. So, Madam Speaker, we're asking the government to withdraw its challenge to Bill 21. And I'll go further, Madam Speaker. When the Constitution was repatriated in 1982, In order to isolate Quebec, the Trudeau senior government inserted Section 33, the notwithstanding clause, into the Charter. And to ensure that nothing would change, it put in place a constitutional lock. If you want to amend the Constitution, don't forget, you need the support of this House, of the Senate, and the support of 7 provinces representing at least 50% of the population. What the Liberal government is doing today is taking power away from Parliament and elected representatives and giving it to a few judges that it has appointed itself. This is an attempt at a constitutional coup. If the government is uncomfortable with the notwithstanding clause, and that seems clearly to be the case, well, it should invite elected officials to a constitutional conference. This debate must take place in parliaments, in legislatures, not in the courts. It must be held between elected officials, not between judges and lawyers. The Liberals claim that they're defending the Charter of Rights and Freedoms. But by asking the Supreme Court to regulate and limit Section 33, they are bypassing the democratic process. By using Bill 21 as a pretext to ask the Supreme Court to amend the Constitution, the Liberals want to show the abuse of the notwithstanding clause. The government is saying the notwithstanding clause must be regulated, Your Honor. Look what those nasty Quebecers are doing with secularism. It's appalling. That's what this government is saying, Madam Speaker. Because it doesn't like Quebec's choices, it wants to take away the tools that allow Quebec to make those choices. This is a political battle. We are in the political arena, not the legal arena. It's here and in the provincial legislatures and in the National Assembly of Quebec that this debate must take place. One of the arguments in favor of the notwithstanding clause was that the provinces did not want a government of judges. To challenge this clause, the government is doing exactly the opposite. It's asking the Supreme Court to play politics and to change both the Constitution and the spirit of the Constitution. That's anti-democratic. The government must withdraw. It must withdraw its factum and give up on this terrible idea of using the courts to take power out of the hands of Quebec and the provinces. Thank you, Madam Speaker. Questions and comments? The Honourable Parliamentary Secretary. Thank you, Madam Speaker, and I listened closely to my colleague's speech, and he knows very well that there are a number of provinces and territories that make up Canada. In his perspective, should the provinces have any limits to the use of the notwithstanding clause? The Honourable Member for Rivière-du-Nord. Madam Speaker, unfortunately, I'm too young. Despite my grey hair, I didn't write the notwithstanding clause. The limits to the notwithstanding clause are in the Act that includes that clause, and there are no limits other than what the current government is per province. So do the provinces have any limits? No more than Quebec, no more than the federal government. Section 33 is there, it exists, and it can't be amended without legislative consent, not through a Supreme Court decision. Thank you, Madam Speaker. The Honourable Member for Lévis-Lobinière. Thank you, Madam Speaker. We are facing a Liberal government that is trying to create a crisis, and it's really, really disappointing. I'd like to ask a technical question to my colleague from the Bloc Québécois. The non-permanent nature of the notwithstanding clause, does it make it possible to protect the Constitution as a whole? The Honourable Member for Rivière-du-Nord. Well, thank you, Madam Speaker. I'd like to thank my colleague for that question. But there's a little bit of confusion there. Section 33, he's right. Section 33 allows the provinces and Quebec and the government to pass laws that go against or that don't take into account Sections 2 and 7 to 15 of the Charter. So it doesn't protect the Constitution. It protects the right of people and their leaders in the various legislatures to work in such a way as they wish, despite the restrictions of the Charter. The Honourable Member for Berthier-Maskinongé. I'd like to congratulate my honourable colleague for his very clear presentation. I'd like to hear his comments, Madam Speaker. Everyone knows that the Secularism Act in Quebec is what started this debate. I'd like to hear his comments on the hypocrisy of this government that is trying to limit the use of the notwithstanding clause. Thank you. The Honourable Member for Rivière-du-Nord. Madam Speaker, I'd like to thank my colleague for his excellent question. I said it quickly in my speech, but it's become obvious that it's not only the Secularism Act, but also all of Quebec's laws and all of the laws passed by the provinces that are threatened by the government's action here. They're saying that we need to limit the use of the notwithstanding clause. However, just in Quebec, without the notwithstanding clause, the charter of the French language would disappear. The ability of children to appear before the courts would go. There are a whole pile of laws that have been passed in Quebec because we can avoid certain sections of the charter. And this is the problem that we're seeing right now. Questions and comments? The Honourable Member for Rosemont-la-Petite-Patrie. Thank you very much, Madam Speaker. I'd like to thank my colleague from Rivière-du-Nord for his speech. And the notwithstanding clause is a tool that is constitutional, legal, and legitimate in many cases, such as he has named. But we've seen in recent years a number of times where the notwithstanding clause has been used in an abusive way, particularly when it's inserted in bills, because the provinces are saying, well, listen, I'm suspending the fundamental rights and freedoms of certain people, and there's nothing you can do to stop me from doing that. The courts can't do anything. And we're concerned about that. We've seen the Conservative government under Doug Ford suspend the rights of workers to in education to strike by using the notwithstanding clause. That's the sort of thing we don't want to see at the NDP. The Honourable Member for Rivière-du-Nord. Well, Madam Speaker, the Ontario government, what it does, I can't do anything about that, but that can be contested in the courts. I'd like to thank my colleague for his question. What you have to understand with preventative use of Section 33, well, that's how the Charter is made. And if there were no notwithstanding clause, the law would be in place until the Supreme Court would invalidate it. And in that case, the government would add the notwithstanding clause and it would become applied. So the act is going to apply no matter what. But the problem is that there are people who are going to spend hundreds of thousands of dollars to contest it, challenge it. There's going to be debates for years in the courts. It's going to create chaos in society to get to the same point. So in its wisdom, if there is wisdom, the government at the time had allowed the use of the notwithstanding clause from the beginning, and I think that we need to continue to be able to do that. And we need to resume debate. The Honourable Member for Saint-Jean. Thank you very much, Madam Speaker. I'm very happy to rise today to speak to this important motion, and I'd like to thank my colleague from Rivière-du-Nord for tabling it today so that we could have this debate. And I also thank him for his a very interesting speech. I'd like to reread the motion for the benefit of all and for the many people who are watching us at home this morning. So, that the House A, call on the government to fully withdraw from the legal challenge of Quebec's act respecting the laicity of the state before the Supreme Court. B, call on the government to withdraw its factum filed on September 17, 2025 with the Supreme Court contesting Quebec's right to invoke the notwithstanding clause. And C, denounce the government's willingness to use the Supreme Court to take constitutional powers away from Quebec and the provinces. Madam Speaker, the Attorney General of Canada tabled his factum contesting Bill 21 before the Supreme Court. He'll say that that's not the case, but it is the case. He is challenging Bill 21. He can claim that he's only challenging the preemptive use of the notwithstanding clause, but, you know, he's doing it in the context of the challenge to Bill 21. This is Quebec's State Secularism Act, and that's what's being challenged. Madam Speaker, the member for Belleuil-Chambly, the leader of the Bloc Québécois, says that the known consequence is part of the intention. So the Attorney General is doing indirectly what he won't do directly, challenging Bill 21. That bill has been in place since 2019, and if, peradventure, the Supreme Court were to accept the Attorney General's argument that the notwithstanding clause should only be used for a period of 5 years, the consequence would be that Bill 21 would no longer be protected by the notwithstanding clause. So the known consequence is part of the intention. and it is our opinion that it's part of the intention of the Attorney General to contest the state secularism bill, even if it's not specifically named in the factum. And that's something that you need to keep in mind when you read his factum. The Liberal government argues that the use of the notwithstanding clause is a step towards an end to freedoms. According to the government, the notwithstanding clause is an anti-democratic weapon that could end the right to unionize, the right to the freedom of press, and the right to freedom of expression. In the government's opinion, you could use the notwithstanding clause to close schools, shut down unions, and silence journalists. And Madam Speaker, you might think that I'm inventing this and that I'm exaggerating, and I would understand why you would say that. But let me quote page 13 of the Attorney General's factum. The loss of the right to exert a right could create consequences that go beyond any use of Section 33. Freedom of the press could disappear for a long period of time, and it would prevent independent media from doing their jobs. Freedom of religion, which is found in the Charter, could disappear if, for a long period of time, the use of places of worship was made illegal. It's the same thing for unions. Unions could be declared illegal for a period of time, and they could be prevented from exerting their rights over a long period of time. A dictatorship, Madam Speaker, that's what the notwithstanding clause could create, according to the Attorney General of Canada, as if Quebec had nothing better to do at night than think about all the ways that it could get away or get around Sections 2 and 7 to 15 of the Charter of Rights and Freedoms. The choice of examples used by the Attorney General is not anodyne. The Attorney General is using places of worship to send a very strange message. He's saying that Quebecers are so against religion that they could make it illegal to use churches, synagogues, and mosques. That's what's not so subtly being suggested by the Attorney General and the Government of Canada in this Liberal factum. However, you don't need the notwithstanding clause to weaken all these rights. The federal government is doing that without using the notwithstanding clause. The government is, in a hypocritical way, taking away the rights of federal workers with its excessive use of binding arbitration, and certain sections of the Labour Code are an example of that. Quebec put in place its own anti-scab legislation at the end of the 1960s, and it's taken the federal government about 45 years to catch up. And, I could talk about all the problems in that act, but it would take up all my time today. The Bloc Québécois has tabled 11 bills, 11 examples of anti-scab legislation, and they've all been voted down. But the government is now saying that the notwithstanding clause could be used to take away rights from unions. They're using they're talking about taking away freedom of press, but it's the federal government's actions that have caused the loss of regional newspapers across Quebec and Canada. The government is also doing nothing to crack down on hate speech that is hidden in religious speech. And they're using this factum to challenge one specific bill in Quebec. And this is what Quebecers need to be concerned about. Madam Speaker, the Attorney General's factum talks about execution and slavery. And again, to go back to the factum, a law which would use Section 33 to allow slavery or execution would go beyond constitutional limits. The Attorney General says that a law which would use the notwithstanding clause to allow public execution and slavery would go too long. Well, yes, but why put that in the factum unless it's to demonstrate that the use of the notwithstanding clause is necessarily against the values of society and democracy? If you read the factum, it's easy to forget that the notwithstanding clause has been in place for 45 years. How have we survived? Where are the gulags? How have we survived with this law being in place? The government is trying to impose its will on Quebec and the provinces. And this is a government that has just passed a bill that says that if the government is in favor of a project, no other laws apply. And does that respect the right of the Charter of Rights and Freedoms? Well, we can't say that the government is setting the right example. This is the same government that used the Emergency Measures Act in a very negligent way.
This is the same government that believes that 50% plus one is not enough. This is the same government that that does not believe that Quebec is a welcoming society and that believes that we are an authoritarian and xenophobic state. This is an insult, which says a lot about how the federal government perceives Quebec. We call on the government to withdraw from this court case and also withdraw its surrealist factum. We know the government doesn't like the notwithstanding clause, but if that's the case, they should amend the Constitution in collaboration with the provinces, including Quebec. But as my colleague said before me, this debate is not one that can be had in the courts. If the government wants to debate about the use of Section 33, we would be happy to participate in that debate. And we will not talk about dictatorships or slavery or executions. We would take this issue seriously. Madam Speaker, I would like to note something else about Section 33. The government says that this section should be used on a temporary basis rather than on a permanent basis. It tells us that the Charter, which is part of the Constitution, is not unconstitutional. Is not constitutional, rather, and shouldn't be. But we can question this notion of permanence. We are legislators. All laws can be changed, amended, repealed, if elected officials wish that to happen, and if that reflects the will of the population, which can always evolve. When the government talks about a permanent bill, they are talking about an esoteric notion entirely, because really any bill can be modified or changed even without the notwithstanding clause. The Attorney General doesn't seem to like the preemptive use of the notwithstanding clause. Well, then maybe he should run for office in Quebec like Pablo Rodriguez did. This debate should not be held in a courtroom. Thank you, Madam Speaker. Questions and comments?
Government House Leader.
Yes, thank you, Madam Speaker. And I think that we should have some concern and some thoughts in regards to it's not just a Quebec issue. This is an issue that affects many and all provinces. And I think it's reasonable for us to ask and pose the question, as my colleague did, in regards to, does the Bloc believe? Are there any situations where they believe that the notwithstanding clause should be used? I was very proud back in the 80s, Madam Speaker, when I witnessed and felt very good about our nation in the signing of the Charter of Rights and how the notwithstanding clause came about in the first place. But I am very much concerned in regards to ensuring that there's a sense of fairness. I am concerned as a provincial legislature. I was in the Manitoba legislature for almost 20 years. And I am what it is that the Bloc is saying we should or should not be able to do.
The Honourable Member for Saint Jean. Madam Speaker, 2 points there. First, the Honourable Parliamentary Secretary has just proved that the position of the Attorney General goes far beyond the question of Quebec secularism. What he wants to do is get rid of provincial autonomy that was hardly won during the constitutional negotiations of 1982. Regarding the preemptive and extreme use of the notwithstanding clause, well, he should address that with provincial legislatures. These legislatures are using a tool which, while flawed, is the best we've got. It's called democracy. If you want to overturn a government's decision, there should be an election. Thank you, Madam Speaker. I wonder if my Bloc colleague is in agreement that the Liberal Prime Minister is trying to create some sort of crisis to avoid talking about real crises affecting Canadians and Quebecers. I'm thinking of the crisis of crime, the economic crisis, and the immigration crisis. The Honourable Member for Saint Jean. I'd like to thank my colleague for that question in very wonderful French. I think that whenever the government has the opportunity to create a distraction, it takes it. But it is our role to hold the government accountable for all of its actions. And we can hold it accountable for a bunch of things at once. That is what we are trying to do today. We should talk about the need for provinces to be able to decide for themselves, and we can hold the government accountable for poor decisions having to do with housing and immigration and so on and so forth. As the saying goes, we can walk and chew gum at the same time. But in general, I do agree with my colleague. Whenever the government can, it tries to create distractions. The Honourable Member for Mount Royal. Madam Speaker, I'd like to thank my colleague for her speech. I have a question. I'm a little shocked that the Bloc motion is calling on the Attorney General of Canada to withdraw from the case, given that the case affects not just the provinces, but the government as well. The notwithstanding clause can be used by the Parliament, the House and the Senate. It was used by Saskatchewan and by Quebec. Does the Bloc believe that the Canadian government should not intervene when there is a conflict about the use of the notwithstanding clause? Should we not have intervened in the cases of Quebec and Saskatchewan in the past? Madam Speaker, we are not saying that the government isn't allowed to disagree with the notwithstanding clause. That is its prerogative. What we're opposed to is the use of the courts. If the government wants to get rid of the notwithstanding clause, they should hold constitutional negotiations. Instead, they are hiding behind the courts. That's why our leader accused them of cowardice. They're trying to avoid what could be a very interesting political debate. So, if the government wants to get rid of the Constitution of the notwithstanding clause, they should hold discussions with us. We'd be happy to take part. The Honourable Member. Getting rid of the temporary use of the notwithstanding clause would require all of Canada talks. Does my colleague not agree? I missed the beginning of that question, but I think I get the general gist of it. Discussions on the use of the notwithstanding clause should not be held in courtrooms. It's not that we don't want there to be discussions at all. We just think that the government has chosen the wrong forum. The Honourable Parliamentary Secretary, the Honourable Member for Rivière-du-Nord has a point of order. When I read my speech, Madam Speaker, you cut me off. But I set my timer, and I did not use the full 10 minutes. So you interrupted me. I don't think you are allowed to do that. It led to me losing time. So then I rose to ask questions to my colleague, and you gave the Conservatives 2 questions, the Liberals 2, and none for me. Is there an issue if I participate in this debate? Regarding the timing, I'm sorry, but I have a timer too, and I have to follow it. I cannot follow everyone's timer at once. As for the questions, the member rose, so I was able to recognize them. Unfortunately, I only saw you too late, which is why I gave the floor to the Conservatives. Now, the Honourable Parliamentary Secretary to the Minister of Agriculture and Agri-Food. Thank you. Madam Speaker, I rise in the House today to talk about why the Canadian Charter of Rights and Freedoms is so important for me. It is at the heart of my identity as a Quebecer and as a Canadian. I also want to talk about why the Charter needs to be protected. Like so many women before me, my mother and grandmother fought for equality under the law. I'll tell a little story. My grandmother was a Montreal entrepreneur who worked in newsstands. She ran a bunch of newsstands and she hired workers. But under the law, she was banned from having a bank account, so she had to use her husband's bank account. Nor did she have the right to vote at the time. with what we are seeing today. With our neighbors to the south, it is more important than ever before to protect the rights and freedoms granted to us by our Constitution and our Charter. We must not allow legislatures to limit our rights with no limits on those limits. And we need to examine whether current limits are justified. Otherwise, we will always be one political or economic or religious crisis away from seeing the rights of women questioned. We must remain vigilant when protecting our rights. So that is what I am doing today. I am rising now in this House to defend the rights and freedoms that my grandmother, that generations of Quebec women fought hard for and won. I would like to warn the government about the possibility of a hole opening up in the protections granted to us by our Charter of Rights and Freedoms. This could affect the rights of women, of course, but also the rights of women, and as my colleague noted, the rights of workers. I rise in the House today to support the important role played by the Attorney General of Canada when they appear through a lawyer before the country's courts, and more specifically before our highest court, the Supreme Court of Canada, in order to provide their legal opinion on constitutional issues, including, yes, the protection of rights and freedoms. This includes limits of the use of Section 33 of the Charter, the notwithstanding clause. Constitutional limits under Section 33 note that it cannot be used to modify or repeal Charter-guaranteed rights and freedoms, because a limitless use of the notwithstanding clause would basically mean that our rights and freedoms are nothing more than words on paper. The government and the courts must ensure that there is a limited and exceptional use of the notwithstanding clause. Our constitutional democracy is based on the notion of balance, and I will come back to that at various points throughout my speech, this question of balance. This balance is what is at the heart of our democracy. Parliament and provincial legislatures have substantial flexibility to pass laws that are in the public interest within their areas of jurisdiction, but they do not have absolute power. And that is more or less what we are debating today. The principle of parliamentary sovereignty has always been hemmed in by the Constitution, including the Charter of Rights and Freedoms. The notwithstanding clause does not remove the court's power to include, rather to rule on the constitutionality of Canadian laws and provincial laws. It is important to remember that our country is governed by the rule of law, and our Constitution is our highest law. Within our federal system, the Constitution is what gives legislative powers to Parliament and provincial legislatures. As the Supreme Court noted, the Constitution binds all governments. Indeed, their sole claim to exercise lawful authority rests in the powers allocated to them under the Constitution and can come from no other source. In our system, generally, federal, provincial, and territorial governments try to do the most good to the most Canadian citizens, as well as local societies and communities. At times, yes, it is possible that there could be disagreements about whether one level of government or another has gone beyond the limits of its authority under the Constitution. That is why the courts are there. They can rule on these disagreements based on legal principles. Our courts are sensitive to efforts to maintain and promote cooperation between the various levels of government, as well as the need to preserve, and I repeat, preserve provincial autonomy. This is one of the characteristics of our federal system. Indeed, the willingness to protect provincial autonomy is expressed in two different ways. First, through the concern to accommodate diversity within a single nation by granting significant powers to provincial governments. Second, through a larger constitutional concern for balancing unity on one hand and diversity on the other. Madam Speaker, we are united in our diversity. In my view, this value is at the heart of our democracy and our country, but also at the heart of our charter. Constitutional principles and values are constantly being questioned. On one hand, we have parliamentary sovereignty. On the other hand, we have the protection of minorities granted by the Charter of Rights and Freedoms. The Canadian Constitution has always reflected a concern about protecting minorities. That can be seen all throughout our history in provisions like the Constitution Act of 1867 and the Manitoba Act of 1870. Both of these pieces of legislation touch on language rights and denominational schools. With the arrival of the Canadian Charter of Rights and Freedoms, additional guarantees, including fundamental rights and freedoms, legal rights, rights to equality, and a broader sampling of linguistic rights, were added to our Constitution. The Attorney General of Canada has always played an important role, even before the Charter came into effect, in ensuring that principles like parliamentary sovereignty were balanced within the overall framework of the Constitution. This includes the protection of minority rights and other charter-protected guarantees. For example, the Attorney General appeared before the Supreme Court in the Blakey and Forrest cases of 1979 regarding the constitutional right to use both French and English in laws, legislatures, and courts of Quebec and Manitoba. What is more, in the Association of Quebec Protestant School Boards case of 1984 and in various cases following that, the Attorney General of Canada intervened to help the Supreme Court interpret minority language education rights. This right is now found within Section 23 of the Charter and applies in many provinces. As was noted by the late Chief Justice of the Quebec Superior Court, Jules Deschênes, when he was providing the Attorney General of Canada intervener status in the case of the Quebec Association of Protestant School Boards of 1982, the Canadian Charter of Rights and Freedoms is a constitutional instrument that applies Canada-wide. And it is obvious that the Attorney General of Canada has an interest in it based on a proper enforcement of the Charter on a Canada-wide basis. The Constitution provides all of us with a stable and balanced legal framework for democratic governance and the protection of all of our fundamental rights and freedoms. Parliament, as well as provincial legislatures, are sovereign within their respective areas of jurisdiction, as set out by the Constitution, so long as they do not reach beyond their mandates. Since 1982, the Charter has been an important part of the Constitution. It guarantees the rights and freedoms set out therein, subject to certain reasonable limits, including the rule of law. within a free and democratic society.
It is true that in the compromise struck with the provinces during the finalization of the patriation of the Constitution in November 1981, the notwithstanding clause was added to allow Parliament or a provincial legislature to exceptionally have the final word when it came to determining whether it should apply. So it is Section 33 preserves a minimum of parliamentary sovereignty in exceptional circumstances. However, the inherent balance struck within our constitutional framework would be thrown if the exception became the rule. If instead of we respected the idea that guides the Charter, which is a solemn Magna Carta destined to protect and constitutionally guarantee the rights and fundamental freedoms of Canadians, provincial legislatures would systematically have recourse to the notwithstanding clause as a means of setting aside the Charter and to refuse the courts any possibility of weighing in. That would not respect the structure that underpins our Constitution and the objective of having a Charter of Rights and Freedoms enshrined in our Constitution. The notwithstanding clause, which is found at the end of the Charter, guarantees the fundamental rights of the Charters against prevailing winds of local majorities. The growing temptation to have recourse to the notwithstanding clause and to try to prevent any judicial overview of legislative action taking into account the guarantees of the Charter threatens to undermine our Canadian values and the inherent balance struck between parliamentary sovereignty and other constitutional principles like the separation of power, the executive, judicial, and legislative powers. The fundamental principle of separation of powers gives us robust judicial oversight and underlines the legitimate role of the courts in the interpretation and application of provisions of the Constitution, including the Charter of Rights and Freedoms. This House has long respected the inherent rule of the Sub Judice Constitutional Convention. It has abstained from debating legal matters that are subject to proceedings before the courts, as the Supreme Court ruled in the Vade in 2005. It is a wise principle that the courts and Parliament try to respect the role of each in conducting public affairs. Parliament, for its part, abstains from commenting on affairs that are before the courts under the Sub Judice rule. The courts, for their part, try to not interfere in the functioning of Parliament or a provincial legislature. In the appeal made by the English Montreal School Board and other parties, the factum by the Attorney General of Canada as an intervener did not contest the validity of the Act respecting laicity in Quebec. On the contrary, in the light of growing use of the notwithstanding clause, that is, Section 33 of the Charter, the Attorney General invited the Supreme Court to clarify the constitutional limits of this power. And that's very important for our rights and freedoms for Quebecers and Canadians. This argument rests fundamentally on the principle by which the Constitution of Canada establishes a delicate balance between legislative jurisdiction and our fundamental rights. Although Parliament and the legislatures have a broad discretionary power to adopt legislation in their respective fields of jurisdiction, parliamentary sovereignty has always been subject to the Constitution, including, since 1982, the Charter. This appeal offers a timely occasion to reaffirm the balance that is at the heart of our constitutional democracy. The Supreme Court is the General Court of Appeal of Canada, and as the highest court in the land, it will be well served by the intervention of the Attorney General of Canada in examining the guarantees set out in the Charter and the use of the notwithstanding clause. Canadians and Quebecers expect nothing less. Thank you, Madam Speaker. Questions and comments? The Honourable Member for Patriot Verchères. Thank you, Madam Speaker. In her speech, my colleague across the way mentioned or claimed that she was defending their women's rights with the notwithstanding clause, but I think that's curious because we know that when we talk about the Act for Laicity in Quebec, it is written in black and white that women and men are equal, and that's non-negotiable. And she is indirectly questioning that. She also said that she wants to protect workers' rights when her own government has intervened many times to prevent workers from going on strike and to exercise their right to strike. And worst of all, she talked about the weakening of Bill 101 in Quebec by the Supreme Court. So I don't understand. What she's telling us is that she wants a constitutional amendment created by the Supreme Court, and that is what the government is claiming, to change the Constitution to weaken Quebec. But at the end of the day, what is she hiding? What is the Quebec legislation that she wants to challenge or that she doesn't like? The Honourable Parliamentary Secretary. Thank you to my colleague for his question, which allows me to reaffirm that it's so important. I am a Quebecer. I am proud to live in a province that supports women's rights. But I have fears as well, Madam Speaker. I see what's happening in the United States, and I want to ensure that our rights and freedoms, which are enshrined in the Constitution Act, in the Charter of Rights and Freedoms, are always respected. Of course, we can make exceptions in any legislature or parliament, but I don't want the use of the notwithstanding clause to create a breach in our fundamental rights and freedoms. And I want these rights, when we decide to be limited, there must be legal oversight, Madam Speaker.
Thank you, Madam Speaker. No party has divided Canadians more and created more polarization than the Liberal Party of Canada. Canadians are facing, a number of crises that this Liberal Party has created, this Liberal government has created, a food inflation crisis, an inflation crisis, a crime crisis, an immigration crisis. We're facing an unemployment crisis and a youth unemployment crisis at recessionary levels. And so my question is, why is this Liberal Prime Minister trying to distract Canadians and trying to create a national unity crisis when Canadians are expecting us to come together to solve the problems that they themselves have created?
The Honourable Parliamentary Secretary.
I'm very proud, Madam Speaker, to live in a country that is united in our diversity. And actually, this government has always been there to protect our Charter of Rights that is so dear. And as I said, Madam Speaker, that generation of Canadians have fought to have, and now this government is protecting. By protecting the Charter, we protect our unity. Now it's more important than ever as we live in a global and changing world where in other parts of this world our right and freedoms are eroded. It's even more important to be united and defend what is most dear to us. It's our Charter of Rights.
Questions and comments, the Honourable Member for Bayeux. Thank you, Madam Speaker. It's always a pleasure to rise to represent the Pays d'En. I am a proud Quebecer, and I am also concerned by the growing use of the notwithstanding clause. I'd like to ask my honourable colleague to describe how the participation of the Attorney General of Canada could help prevent the erosion of the Charter of Rights and Freedoms, which is enshrined in the Constitution. The Honourable Parliamentary Secretary, thank you to my colleague for his question. It is important for our government, for the Attorney General of Canada to intervene, because what we have seen increasingly, unfortunately, is legislatures invoking the notwithstanding clause to limit our rights, fundamental rights and freedoms. It's perhaps justified, but it is up to the court to conduct this review. So the participation of the Attorney General of Canada will prevent a breach in our fundamental rights. And at the end of the day, we don't want the exception of the notwithstanding clause to become the rule. We need to ensure that our fundamental rights and freedoms are protected. The Honourable Member for Shefford. Thank you to my colleague for her speech. I'm going to push back a bit on what my colleague from Verchères Les Patriotes said earlier in his question, or I'll continue along those lines. And she responded that there was a risk of what was happening in the United States happening. In the United States, we see a rise in religious influence on government, and that is why the principle of laicity is not attacking the rights of each individual to practice their religion, but rather to remind us that there cannot be a link between a religion and government. And furthermore, this challenging of this fundamental principle, we see that it's causing a lot of issues in the United States. This challenge is challenging something that was voted on in the National Assembly in Quebec. The Honourable Parliamentary Secretary, I'm glad to hear my colleague reaffirm that the situation is concerning. I would cite Simone de Beauvoir. We always need to remain vigilant. Our rights are never acquired. Our rights are protected by the Canadian Charter of Rights and Freedoms. And to not create a breach through the back door, we need to protect the Charter by passing legislation that covers the notwithstanding clause to never use judicial review. That means that those rights are injustifiably limited. So we agree with that. And the means of doing that is protecting the Charter and setting limits and guidelines when someone wants to fly in the face of the rights and freedoms enshrined in the Charter. Questions and comments?
Member for Elgin, St. Thomas, London South.
Thank you, Madam Speaker. You know, right now there is a wave of unity across the country. Canadians of all stripes from all regions realize the Liberal government has failed in reining in crime, has failed in allowing immigration to run rampant in a reckless way. They are in agreement, Canadians are, about the many problems that this government has caused on affordability. So my question is, when so many Canadians are agreed about these very real crises that Canada faces, why is this Liberal government trying to create division and create a national unity crisis?
Honourable Parliamentary Secretary.
Merci, Madame la Présidente.
Thank you, Madam Speaker. We agree with the fact that Canadians are more unified than ever to confront the impacts of tariffs by Donald Trump on our economy. We have seen the Buy Canada movement and its support. There's support for local organizations and businesses, support for Prime Minister Mark Carney and all of his efforts. Excuse me, the Honourable Member for Nepean. So yes, it's very important that there is unity behind our Prime Minister, because we are facing historic challenges, economic challenges, and I will cite Simone de Beauvoir. When there's an economic crisis, women's rights are questioned. So it's very important to stand united behind the Charter. The Honourable Member from Jonquière. Thank you very much, Madam Speaker. I see that my colleague has been citing Simone de Beauvoir abundantly. Congratulations. But she should be aware that women in Quebec have fought hard to get rid of religion in the 50s and 60s. They didn't have the same right as men, and they had to do a lot of work and fight hard to replace religion with something else. And now what my colleague is telling us is that we need to, that using these tools to get rid of religion in government are a step backwards, but I don't understand that the link she's trying to make with Simone de Beauvoir. She made a link between feminism and the notwithstanding clause. I don't understand. The Honourable Parliamentary Secretary. Thank you, Madam Speaker. You need to be a woman to really understand the feeling of insecurity and the importance to see their rights and freedoms respected in the Charter of Rights and Freedoms. Thank you.
Problem.
Questions and comments?
The Government House Leader.
Yes, thank you, Madam Speaker. I appreciate the many words that the member has put on the record. My concern has been the issue of using the notwithstanding clause in a preemptive fashion. And a good example of that at the national level, for the very first time in Canada's history, we have the Leader of the Official Opposition saying that he will use the notwithstanding clause in order to bring in and support legislation. And Canadians, I believe, have a great sense of pride in the Charter of Rights, and that we should not easily overlook the Charter of Rights. Therefore, we all have a responsibility, no matter what province one is from, to take the notwithstanding clause seriously.
Brief answer from the Honourable Parliamentary Secretary.
Oui, effectivement.
Yes, quite right. And the intervention by the Attorney General seeks to help the Supreme Court to interpret the notwithstanding clause so as to set guidelines and ensure that our rights and freedoms will not be, as I said earlier, just symbolic, that can be undone to the point that we no longer even recognize them and that they disappear over the long term. Thank you, Madam Speaker. Resuming debate, the Honourable Member for Mégantic-l'Érable. Thank you very much, Madam Speaker. Allow me to start by saying that, giving an excerpt by the Governor Attorney General of Canada in the case before us today, and I quote the first paragraph: in accordance with its role of intervener, the Attorney General of Canada will not make observations about the constitutional validity of the provisions on the Act on Laicity in Quebec on any basis. Nevertheless, although Section 33 of the Charter of Rights and Freedoms applies, it is timely to consider whether, in addition to the requirements set out in 4A, there are other use of this which is already recognized in this affair. I think that it's very important, Madam Speaker, that we speak about this situation. It's another crisis and that the Liberals are trying to create to avoid talking about the real crises that the Liberal Prime Minister have inflicted on Canadians after this ideological regime. Allow me to say, Madam Speaker, that I would like to thank all members of this House who have given me their support since last week on the opioids crisis. I think it is important to say it. Across the country, people were very kind about the experience that I had with my son. And so I would like to personally thank each person who took a few minutes to give me their support about this situation. But let's come back, Madam Speaker, to the crisis that this Liberal government has created and that the Prime Minister is desperately trying to sweep under the rug by creating another constitutional crisis this time to avoid talking about these results. The cost of living crisis. Everyone here knows very well that the cost of living inflation is rising at a staggering rate, and I remember the Prime Minister, what he said when he swore in his cabinet. He said, "You'll judge me by the price that you pay at the grocery store." Well, Madam Speaker, I think that the judgment is clear. The judgment is that the result, food inflation, is 70% higher than the basic targeted rate of the Bank of Canada, 70% higher. What does that mean, Madam Speaker? it means that food is more expensive. Vegetables are more expensive. Grocery baskets are more expensive than ever.
I was reading an article this week, Madam Speaker, that people are having to make really tough choices, at the grocery store. One woman in particular only is eating twice a day, and she doesn't remember the last time that she ate a steak, Madam Speaker. The Honourable Member for Jonquière. I appreciate my colleague quite a bit, and I understand that he might believe that the government is trying to avoid the crisis that is affecting people, the crisis of the cost of living. But I would politely ask him, I think this is an important issue for Quebecers, the question about the Secularism Act and it's being challenged. I would politely ask him to maybe come back to the motion that we tabled today. And I don't know if, through extension, there is a link between state secularism and the price of peas. The Honourable Member knows that members have a lot of latitude in the themes that they wish to raise in their speeches. I will, of course, remind the Honourable Member about the meaning of the motion before us today. The Honourable Member from Mégantic-L'Érable. Thank you very much, Madam Speaker. And Madam Speaker, the link is very clear. This Liberal Prime Minister has made so many promises to Canadians that he's trying today to divide people to avoid having to face his record. And the factum that was tabled at the Supreme Court is once again an effort to divide Canadians, to pit Canadians against one another. And the goal of that is to make Canadians forget the crises that they're facing, the promises that the Prime Minister made to get elected. And, the Prime Minister doesn't have answers to those crises, to those promises today. The crisis, Madam Speaker, the food crisis that Canadians and Quebecers are facing, and the lady that I was speaking about before I was interrupted by my colleague from the Bloc Québécois, well, that person needs to make very difficult choices. She's choosing not to eat, Madam Speaker. She says that she doesn't remember the last time that she ate a steak, Madam Speaker. And that's the reality, despite the promises made by this Liberal Prime Minister. His promises to do things differently, to end 10 years of chaos. He was going to be the person who was going to bring back order, who was going to bring down the cost of living. And yet that's not what's happened, Madam Speaker. And, examples like this, there's lots of examples that are just like this. An increase of 4 million people using food banks in Toronto alone, Madam Speaker. That's incredible. An increase in inflation that means that people are making very difficult choices. Families don't have the means to put appropriate lunches in their children's lunch boxes, Madam Speaker. That's the reality that people are facing, and that's what Canadians want to hear about. What are this government's solutions to end the Liberal cost of living crisis? And there's another crisis, Madam Speaker, and that's the debt crisis. Can you imagine, Madam Speaker, that this Liberal Prime Minister is spending more and more quickly than his predecessor, Justin Trudeau? No, listen, it's true. It's true. More and faster than his predecessor, Justin Trudeau. I don't think anyone would have thought that was possible. If you'd asked us, during the election, do you sincerely believe that a Prime Minister could spend more and more quickly than Justin Trudeau? I think it would have been difficult to say yes, but that's what's happening. We are facing a crisis that this government is desperately trying to sweep under the rug. And all that without having presented a budget. Imagine, people watching at home, imagine you're going to renovate your house, you're bringing in entrepreneurs, and you say, listen, I want to have a mansion. And they'll say, can you pay for it? And you'll say, I don't know, I'll see if I can pay for it later. What do you think is going to happen? Well, the mansion will be half built, and you're going to have creditors knocking at your door, and you're going to lose everything. Madam Speaker, that's the kind of crisis that the Prime Minister is creating right now. This Liberal Prime Minister, by refusing to table a budget to Canadians. He promised a spring budget, or rather not at the spring, but at the beginning of fall, and we've been waiting for it. And then he said, no, it's going to be in October. And now, finally, it's going to be November the 4th, the budget. November 4th, which is quite late because, we're almost at the end of the year. It won't be 6 months before the presentation of the next budget if we follow the usual rhythms. Point of order, the Honourable Member for Rivière-du-Nord. No. Oh. I appreciate my colleague, but I think he has the wrong speech. Oh, sorry, yes, go ahead. The Honourable Member for Louisville-Dunant. If you'd like to give the floor to somebody else, Madam Speaker. No. Madam Speaker, I think that, I have a lot of respect for my colleague as a person, but I think he's out of order here. We're talking about a debate on the Bloc Québécois Opposition Day, the Secularism Bill, Section 33 of the Charter of Rights and Freedoms, its constitutionality. And that's not what my colleague is speaking about today. And so I would appreciate it if he respected the orders of the day. I've taken note of the Honourable Member's point of order, and I mentioned it earlier. There's a lot of latitude in terms of what members can cover in their speeches. I will invite the Honourable Member for Mégantic L'Érable to use his last 3 minutes to maybe come back to the question in the motion. Madam Speaker, the federal government's intervention is clear. The Attorney General isn't commenting on the secularism bill in any way. That's the position that this government has taken before the Supreme Court, to avoid having to talk about the real issues that are affecting Canadians. They want to create a constitutional crisis to avoid talking about the opioid crisis, the inflation crisis, and the debt crisis. But allow me, Madam Speaker, to come back to the budget. How much of our money will this Prime Minister have spent before we've seen the budget? Nobody can say. Meanwhile, the interim parliamentary budget officer has said it very clearly. He said last week before committee that I don't know, as he said, if the government has any fiscal guardrails in its budget. He's saying very clearly the government doesn't know where it's going. At this point, it's impossible for us and for you as parliamentarians to evaluate the probability that the government will meet any particular budgetary objective. Wow. Another quote, you can be sure that we're going to be soon paying more to service the debt. That's the only certainty from the interim parliamentary budget officer's passage committee. He says we're going to be paying more to service the debt. And worse, Madam Speaker, is that the Liberal members of that committee claim that or rather they're maintaining that office, the PBO, in a state of crisis, a permanent state of crisis, because they're not, there's a point of order. The Honourable Member for Pierre Boucher, Les Patriotes Verchères. Thank you, Madam Speaker. Listen, this is really insulting. I'm quite angry. I think you'll need to call my colleague to order because we're talking about an issue that is crucial to Quebec. The federal government is attacking Quebec's power to make its own decisions, to make its own laws, and my Conservative colleague, who is himself from Quebec, doesn't seem to be interested in that issue, and he's not speaking to the motion of the day. We have only one day to talk about it, so when is my colleague going to speak to his position on the subject on the orders of the day? The Honourable Member knows that there are a number of ways for the Speaker to orient members' speeches. In this case, we're more or less within the frame. Madam Speaker, I'll be sharing my time with the Honourable Member for Regina Capel, but one thing is very clear. What I'm explaining right now is the reason why the Prime Minister is trying to turn Canadians' eyes away from the real issues that are facing them, the issues that are affecting their day-to-day lives, Madam Speaker. That's the reality. And it's not for nothing that in the preamble, the government says that they're not speaking to Bill 21. Their goal is to create a crisis so that we don't talk about these other Liberal crises that are affecting the country, that are affecting Canadians, and that have been affecting them for 10 years now. The Minister of Finance promised us a budget with investments, generational investments. But you know, what he's going to present, and I'm telling Canadians right now, it's a spending and debt budget that is going to affect many generations of Canadians. And, you know, our young people are going to be paying this for generations to come. Thank you, Madam Speaker. Questions and comments? The Honourable Member for Pierre Boucher, Les Patriotes Verchères. Thank you, Madam Speaker. If my colleague has the opportunity to ask this question, I would like to ask him why he's not defending the rights of his province. As a Conservative member from Quebec, he the Conservatives say that they're the least centralizing party in Canada. Well, here's an opportunity to show it, Madam Speaker. There's a Liberal government across the way that says that it's going to attack powers that are already in the Constitution, which allow the provinces to avoid certain federal limits or excesses. Why is he not defending that? Why is he not defending his province's powers to make its own laws? The Honourable Member for Mégantic-Lorable-Lobinière. Madam Speaker, I will never accept any claim that I'm not defending the rights of my province or that I'm not defending people from my riding. That's not true. That's not true, Madam Speaker. When I talk about that mother of a family who's not able to pay for lunches for her kids, when I talk about seniors who are having to make difficult choices, Madam Speaker, I am defending Quebecers who are having a hard time after 10 years of this Liberal regime. Madam Speaker, what I'm doing is I am defending people from my riding. I'm defending people from Beauce, from the Appalaches. And Madam Speaker, my colleague should wait to see tomorrow's vote before he makes all these claims without any basis. The Honourable Member for Regina Capel. Thank you very much, Madam Speaker. Just a quick question for my colleague. Is this the first time that the government has tried to distract Canadians from its terrible record on the cost of living, on crime? I've seen over the last 10 years under this government that every time that things have gotten worse in Canada, particularly when it comes to quality of life, the cost of living, things like that, the Liberal government finds ways to distract people. I would like to ask my colleague, does he agree that this is this government's modus operandi? The Honourable Member for Mégantic-Lorable-Lobinière. Well, Madam Speaker, maybe you might find certain examples as well, but I know that the question isn't for you. And this is indeed what this government has been doing for the last 10 years, sometimes accidentally. Sometimes we see Liberals tell the truth. We saw it this week with the Minister of Public Safety. Accidentally, and I have to say, unfortunately, when we see these moments of clarity, they're just accidental from this government, because usually what the Liberals want to do is sweep under the rug the crises that they've created. The Honourable Member for Les Pays d'en-Haut. Thank you, Madam Speaker. I would like to ask my colleague from across the way if he envisions a situation where the Conservative Party would use the notwithstanding clause in a preemptive way, as the provinces are doing right now. The Honourable Member for Mégantic-Lorable-Lobinière. Well, Madam Speaker, I'd like to know if my colleague agrees with his Prime Minister's efforts to camouflage what's happening, because what we've seen over the last 10 years is a government... the Honourable Member for Jonquière. Thank you. Point of order. The Honourable Member. Well, Madam Speaker, I wasn't asking a question. I was making a comment, and if you'd let me finish until the end, you would have heard that it was a comment that I was making and not a question. The Honourable Member. Thank you very much, Madam Speaker. So, Madam Speaker, I was wondering if that member is aware that for years now, the Liberal government has been camouflaging the real situation. And what I'd like to know, is if this member and all other members of the Liberal Party agree with the fact that this government is taking us in an unacceptable direction when it comes to a lack of control of the debt, the inflationary crisis, the crime crisis, Madam Speaker. The Honourable Member for Jonquière. Thank you very much, Madam Speaker. I agree with my colleague that the cost of living crisis is a very important issue, and it's definitely important to discuss it. But there's another question that's very important as well, and that is the survival over the long term of a minority nation. That's the possibility of Quebec to set its own laws, to put a framework around religion in its society. And my colleague hasn't spoken to that, so I'll ask him a very simple question. Does he believe, as a member from Quebec, like me, that Quebec has the full capacity to make its own laws and to put a framework around religion? Does he believe in that, yes or no? A brief answer, the Honourable Member for Mégantic-Lorable. Yes. Resuming debate, the Honourable Member for Regina Capel.
Thank you very much, Madam Speaker, and I'd like to thank my colleague for sharing his time with me today. This is another engineered distraction on the part of this Prime Minister. He's trying to distract from his terrible record, even though he's only been in the role of Prime Minister for a short time. He's got an abysmal record, and he's desperately trying to change the channel for that. So let me just explain how I know this. This is an engineered distraction because the Prime Minister has never expressed opposition to Bill 21 in Quebec, not once. And if we look at the official submission, I have here a copy of the factum of the intervener, of the Attorney General of Canada. So anyone watching this debate, anyone in the gallery, anybody at home, any of the press that are trying to decide how to frame this conversation, let me read the opening line. This is the Attorney General of Canada officially putting before the courts the Government of Canada, this Liberal government's position on Bill 21. Let me quote it. Part A, this is Part 1, Section A, Paragraph 1, Line 1. I just want to stress that because this is the opening statement, the thing that the government leads with in its court submission. And let me quote. In accordance with his role as intervener, the Attorney General of Canada takes no position on any basis whatsoever on the constitutional validity of the provisions of the Act respecting the laicity of the state. Takes no position on any basis whatsoever. That is the government's position. So, you might be left wondering, what is the purpose of this engineered distraction? Well, it is to distract. It's to distract from the terrible cost of living crisis that this Liberal government started creating 10 years ago. 10 years ago with tax hikes on hardworking Canadians, on small business owners, the massive layering of regulations on the productive parts of the Canadian economy, the barriers to investment, the barriers to getting things built, the ban on shipping Canadian energy to other countries while foreign oil and foreign resources come into our country. Let me just go through a few of these crises, Madam Speaker, so you can properly understand why the government is so desperate to have this debate instead of a conversation about the hardships that Canadians are facing. This Prime Minister famously said that he would be judged on the prices at the grocery store. That's what he said during the election campaign. What's happened to prices at the grocery store, Madam Speaker? Food inflation continues to rise. It's now 70% above target. Food prices are 40% higher since this Liberal government took office. The debt crisis. He's created he's making the Trudeau debt crisis even worse. Remember, Justin Trudeau racked up more debt in the short time that he was in office than all the other prime ministers combined. All the other prime ministers combined. I mean, consider that World War I, World War II, the Great Depression. We had all these crises that faced Canada, but it took Justin Trudeau to massively rack up that debt. Since this Prime Minister took office, federal spending is up 8.4%. Remember when he promised during the election campaign? I mean, he put in writing, in black and white, when he was going to voters for their vote, he made a written guarantee to them that he would cap the deficit at $63 billion. The spending's gone up by 8.4%, Madam Speaker. He had the King of Canada, the King of the United Kingdom, come all the way from London. The King graciously accommodated that request and came to the Senate and read the throne speech. And in that throne speech, they had a commitment to cap spending at 2%. Just 48 hours later, the government tabled its spending estimates, blew past that. I mean, what was the point of inviting His Majesty all the way across the ocean to come and read that speech if it wasn't even worth the paper it was printed on? I mean, that commitment, let me go down in history as the shortest-lived Liberal promise ever. 48 hours, new record, new world record. And I'm embarrassed on behalf of this government. I know they're not embarrassed because you have to have shame to be embarrassed, but I'm embarrassed for them that they had His Majesty come over and participate in that kind of bait and switch for Canadians. Let's talk about the take-home pay crisis, Madam Speaker. The first people who suffer when inflation rears its ugly head are people who live paycheck to paycheck, people who have shift work, people who have to have second jobs to make ends meet. You want to know why, Madam Speaker? Because, see, when the government creates an inflation crisis, there's some winners and there's a whole lot of losers. The winners are the people who get the new money first. The asset managers, the hedge fund operators, the big banks. See, they get the new money before anybody else does, so they can buy up assets before prices go up. But that hardworking person in a hotel, the plumber, the mechanic, the people whose wages don't keep up with inflation, they have to start paying all the increased prices before they're able to secure any kind of pay increase. And so their paychecks go further. They work harder and are able to buy less. Since this Prime Minister took office, there are now 86,000 fewer Canadians who even earn a paycheck. That's because 86,000 people have lost their job just since this Prime Minister took office. He promised the fastest growing economy in the G7. Canada has the fastest shrinking economy in the G7. Unemployment in the GTA is now 9%, with 365,000 people out of work. 53.6%, Madam Speaker. You know what that is? That is the youth employment rate. That is the lowest it's been in almost 3 decades. 53%. That means just about half of young people in the workforce who are looking for work don't have jobs. The youth employment rate is the lowest in almost 3 decades. Household debt, Canadian household debt, is the highest in the G7. Bankruptcies are rising at the fastest pace since 2008. It's not just the cost of living crisis that's causing so much hardship in Canada and that this government's trying to distract from. We have a crime crisis as well. We have a Liberal government that decided to instruct judges to give bail to some of the country's worst, most violent and repeat offenders. What does that mean? Well, that means that now when someone's being arrested for the 14th, 15th, 20th time, that when they get booked by the police, they get back out on the street, often the very same day. I've heard from police associations who say that they will arrest somebody at about 5 or 6 o'clock in the evening that they had already arrested earlier that morning. Those dangerous and repeat offenders have been let out by this federal government, and Canadians are sick and tired of it. But rather than take real action like adopt the Conservative 3 strikes and you're out policy, rather than apologize to Canadians for all the lives that have been shattered by the criminals that this government set free, rather than do that, they're blocking and obstructing legitimate attempts to fix the bail system and bring in tougher penalties for dangerous and repeat offenders. So, Madam Speaker, that's what the Liberals are doing with this. They have engineered a distraction from their terrible record on cost of living, their terrible broken promises on fiscal responsibility, their terrible record on public safety, letting crime and chaos reign in our streets by putting the rights of dangerous offenders ahead of the rights of law-abiding Canadians. Madam Speaker, it is shameful, but this Prime Minister is employing the same tactic of his predecessor, Justin Trudeau, dividing to distract, distracting from his terrible record, and he is proving to be just another Liberal.
Questions et commentaires, questions and comments. The Honourable Parliament Secretary to the Government House Leader.
Madam Speaker, it is a bit of a stretch, I must admit that, in terms of the speech and what we're supposed to be talking about today. But let me continue with that stretch. The member opposite is exceptionally biased, and I'm sure he'll acknowledge that. The reality is actually quite the opposite. We'd love to be able to talk more about the things in which we are actually doing. We could talk about the 22 million Canadians that benefited by the tax break. We could talk about the Build Canada legislation. not to mention the different projects, whether it's copper mines in BC and Saskatchewan, it's LNG in BC, it's the nuclear energy in Ontario, it's the Port of Montreal in the province of Quebec, it's the attention being given to Atlantic Canada, all regions, all areas of economic development while protecting the environment is something that is important to the government. But with respect to the motion that the Bloc have brought forward, I'm wondering if the member could give his thoughts on whether it's the federal government or parliaments or legislatures using preemptive statements related to using the notwithstanding clause.
Honourable member for Regina Capel.
Madam Speaker, the member makes an unfounded allegation that I could be biased when all I did was read stats. Math has no bias. Numbers have no prejudice. They come into the world because of calculations. And let me look at some of those calculations. Spending on consultants has gone up 37%, from $19 billion to $26 billion. Spending on bureaucrats by this Liberal government is up 6%, from $59 billion to $63 billion. There's no bias in that. Those are just numbers that we take from departmental websites and estimates and things like the Parliamentary Budget Officer doing dispassionate, independent analysis of government spending. The government talks about how many Canadians are being affected by their policy. How about every single Canadian being affected by the inflation crisis that this government caused?
Thank you, Madam Speaker. I would like to thank my colleague from Regina Capel for his speech, but I am going to bring him back to the subject of the day, because since this morning, it has been hard to get the Conservatives to give their actual opinion on the debate. As my colleague from Saint Jean said this morning, I think that we can walk and chew gum at the same time. It's all very well and good to address the cost of living crisis, but the Conservatives could also defend the rights of Saskatchewan and Quebec to put in place their own bills without being challenged. So I'd like my colleague to talk about Parliament's capacity to both address the cost of living crisis and defend the rights of Quebec to introduce its own bills without being challenged by the feds. The honourable member for Regina Capel. But we already did provide our opinion on the Liberal strategy to create distractions so that Canadians do not consider their terrible record. I don't have the text in French, so I'm sorry, but I will say that the government's position is clear.
Canada takes no position on any basis whatsoever on the constitutional validity of the provisions of the Act respecting the laicity of the state. Alors, c'est clair. On doit parler.
So, it's all very clear. We are dealing with a distraction here. Part of a Liberal strategy of distractions. The motivation for the strategy is because the Prime Minister does not want Canadians sitting around the dinner table and talking about the cost of living crisis, the inflation crisis, the crime crisis. So, Conservatives are here to highlight the motivations of the Liberal government. The honourable member for Mégantic-L'Érable-Lotbinière. Thank you, Madam Speaker. Madam Speaker, the government is currently covering up a number of major crises by creating a division among Canadians. Among them is the debt crisis. I heard the Minister of Finance say that this would be a generational budget. Imagine that. Imagine a budget that even Justin Trudeau would not dare to introduce. I would like to hear my colleague talk about this particular Liberal cover-up operation. The honourable colleague, member for Regina Capel.
2, generational. This will have generational impacts. That means that generations of Canadians into the future will be paying back the debt that this government's racking up, including the interest on the debt which goes to bankers and bondholders. That's not what Conservatives want to see happen.
Resuming debate, the honourable member for Beloeil-Chambly.
Merci, madame.
Thank you, Madam Speaker. I would like to begin by asking what has gotten into everyone? Have they hit their heads or something? If you look at the factum from the Attorney General, you will find comments that would shock even the most radical people south of the border. To put it politely, the government has embarrassed itself. This is a demonstration of the profound cultural, traditional, and historical differences between Canada and Quebec. The government has done nothing but highlight the differences of opinion, the divergences between the models of Quebec and Canada, Canada with its multicultural model, and Quebec with our own model. Canada with its conquering model, one that wishes to paper over all of the various differences of the conquered people who did not want to assimilate into the conqueror society. Yet they are doing so under a constitution that reflects the will of the legislators at the time it was written, Trudeau Sr. I think it's fairly insulting to say, no, these people didn't understand their own constitution. It's either wrong or it's incompetent, which I wouldn't put past the government. No, the Constitution reflects the will of the people who wrote it. It is not appropriate to speculate and confabulate and make up things about what the intention of the legislators at the time were. Nor is it appropriate to ask judges to do so. The intention of this Constitution was written down, black and white. It was signed, and it was imposed upon Quebec. A Quebec that has never, to this day, signed that Constitution. Let us talk a little bit about the history. For about 200 years, the French of New France were cut off from the French of Europe. But they shared a dream of one day restoring contact with French once again. Canadians at the time were considered Quebecers at the time were considered French Canadians who worked for English bosses. They had very little control over their own economy on their land. They were also subjected to ancient rule by the English and the Church. Then came the Quiet Revolution. During the Quiet Revolution, French Canadians, who would go on to become Quebecers, took the reins of their own fate. Here we could talk about the nationalization of hydroelectricity by René Lévesque under the Jean Lesage government, one of the first great acts of reappropriation. But there were other acts as well. Bill 101, the Charter of the French Language. The education system, which is fundamental to Quebec history. École polyvalente and cégeps, a university network which is today not just the pride of Quebec, but an institution which allows Quebecers to access education as good as any in the West, whereas back in the day, we were at the bottom of the pack. The role of the state is different in Quebec. And it is worth noting the role of Guy Rocher in a number of these measures, including the creation of the university network and the putting in place of protections for the French language. The late Guy Rocher was there for many of the measures that created modern Quebec, including state secularism. All of these measures are what made us Quebecers. You can come after us and try to erode our will, but we are nothing other than what we are. We are proudly Quebecois. The Canadian government strategy has been the same for a while now, and I don't believe it is likely to change. They are taking advantage of the benevolent nature of Quebec society. To make us an increasingly weakened minority within Canada, using immigration as a tool to do so. They are also using the tool of fiscal imbalance to hold in thrall not just Quebec, but all the provinces. They are using centralizing measures like the despicable Bill C-5. But of course, if there were no fiscal imbalance, there would be no C-5. C-5 is an embodiment of Ottawa's centralizing tendencies. An essential part of our own emancipation was secularism. Canada, as a multiculturalistic state, wants to impose its vision and is doing so through the Supreme Court. In fact, they are funding those who would challenge Quebec secularism before the Supreme Court. But religion is a threat to multiculturalism. Church and state must remain separate. Many parties agree on that. The government would impose an immigration model upon us, one that simply does not work in Quebec. These discussions were not held during the foundation of our values, but they are being debated today and debated for liberal electoral purposes all too often. Under liberalism and neoliberalism, people, immigrants, are used as both producers and consumers. As such, immigrants are being integrated into the government's vision of what the country is. Quebec has always welcomed immigrants, Irish, Scottish, immigration occurring over many waves. But the Canadian vision doesn't take into account the French language. Instead, it imposes the English language. Canada claims it will defend the rights of everyone, but by defending equality for all, they are defending intolerance, intolerant views, including ones that would deny gender equality. What is more, in the government strategy, unfortunately, Quebecers are being described as xenophobic and hostile to outsiders, when nothing could be further from the truth. Yet the government is not willing to confront Quebecers directly, especially with a sovereigntist government no doubt coming into power in Quebec in the near future. And so, instead of that, the government is simply asking the Supreme Court to limit the use of the notwithstanding clause. They're saying all sorts of things about the preemptive use of the clause. Well, there's nothing about that in the Constitution. No, the people who put the notwithstanding clause in the Constitution just decided it was a good idea, patted each other on the back and did it. The notwithstanding clause also has to be renewed every 5 years. There's no morality attached to this. There's no great ethical questions. No, it's a simple measure to protect the provincial sovereignty of Quebec and the provinces, because parliamentary sovereignty must reign supreme. But there's a bonus. If the government does manage to limit the use of the notwithstanding clause, and if it succeeds in attacking Quebec secularism, they could then go after the French language, Bill 96, and everything else.
And that's occurred in legislation related to unions in other provinces. The notwithstanding clause has been renewed 100 times in Quebec. It's the most powerful tool since 1982. But the effect could be the contrary of what they're hoping for, because, as I said, perhaps they have fallen into a trap. The use of the notwithstanding clause could, in theory, allow the Quebec government to authorize summary executions, the use of forced labor, elimination of freedom of press, freedom of assembly. But what exactly is... This is the most progressive society in the continent we're talking about. There's something that just doesn't add up here. So if I understand correctly, I am the state, Quebec state. I pass a bill that allows summary execution of someone, let's say, or forced labor, slavery. We abolish the freedom of the press. It doesn't say that they say that I have the right to do so until 5 years. So their reasoning is that a province could authorize summary execution for 5 years. But I don't know who thought of that, but that's serious. And they need to go back to college. They need to go to school, because that is just tomfoolery. Who thinks that Quebecers will accept that? As an aside, Robert Bourassa and Jean Charest, I looked, but I didn't find any PQ membership cards, but they use the notwithstanding clause. And all of the governments of Quebec have renewed, in most cases, the notwithstanding clause. This government has done things that are very similar to what previous governments have done. The lowest common denominator, use of a type of spin that you would find on social networks that have just about anything about information in most cases. So in comparison, I would propose you the Pelchat-Rousseau report, an excellent piece of summary, but has not been read enough and not been spoken about enough. And it paints a picture of the value of secularism throughout Quebec society since the Quiet Revolution. You can really see the line drawn. It's a serious analysis. It's intelligent. It's respectful of the reader's intelligence. And I repeat, the intention of Pierre Trudeau is enshrined in the Constitution. Any other interpretation, including those of his son or the government, is an insult to injury. There are two prime ministers who suspended fundamental freedoms in history. Pierre Elliott Trudeau in 1970 and Justin Trudeau in 2021. And Bill C-5 contains also the suspension of any federal legislation that the minister decides to suspend. When we are being ridiculed, the government of judges and populism will not be that of Quebec. We are the most hostile to populism in Quebec, to demagogy, to extremism in all its forms. Quebecers are so tolerant that sometimes we wonder if it's too much, and then we realize that it's wisdom, and that is the strength and the value of this extraordinary Quebec nation. So I say to the government, have the courage to fight the issues of secularism, language, immigration. To date, this government is no more brave than the previous one. The Prime Minister responded last week that one of the responsibilities of the government is to defend the Charter of Rights and Freedoms. That's not the responsibility of the court. It's the responsibility of the government, he said. So one pushes the spine of the other to flesh things out a bit. You say, I would like to have a conversation on the Constitution. Well, invite me. I'll tell you all my opinions. Let's go. But let's not hide behind the legal system. So I thank the government for demonstrating how it works and how it thinks. But I would remind us all that everything will work better when we are good neighbors with affinities, with shared challenges, with differences that define us and that define us freely, each doing their own way, doing things their own way. In the end, everything comes back to this opposition between individual rights and collective rights. Imposing the supremacy of individual rights to an unreasonable extent is breaking society apart. It is making it based on individual rights to the detriment of collective rights. And it's even more surprising because we represent 80% of the population, and where we are rich, why resort to division? It is the doctrine of the weak. So I invite us to discuss nation to nation, between equals, who will be tied by treaty. So at the end of the day, Mr. Speaker, long live a free Quebec.
Questions and comments. Questions et commentaires. L'honorable député.
The Honourable Member for Hull-Aylmer. Thank you very much, Mr. Speaker, and I'd like to thank the Honourable Member from Belle-Île-Chambly for his speech. It was very interesting to hear it as a Quebecer as well. I am a very proud Quebecer, and I listened to his speech attentively. I would like to ask him a question. It is tied to the debate here, but it's a bit of a theoretical one. Is it important to ensure that rights are always rights not only in Quebec but throughout Canada? The Honourable Member for Belle-Île-Chambly. I know that that is not my colleague's intention, who is a true gentleman, but there is such a thing as collective rights. If throughout a process of solidarity, if Quebecers and French Canadians hadn't sought out the collective rights without treading on individual rights, there would be nothing today of the national society as we know it. Questions and comments?
Leader.
Yes, thank you, Mr. Speaker. And when I hear the leader of the Bloc speak, I often like to be able to refer to my roots, ancestral roots to the province of Quebec. And I am very proud of the fact that Quebec is such a distinct, and I'll use the word distinct, society in the way in which it has contributed to making Canada the best country in the world, from my perspective. Having said that, as a parliamentarian who has served in the Manitoba legislature for just under 20 years, having been able to observe what provincial jurisdictions have done, if you take a look at the federal government, if, for example, the current leader of the Conservative Party was to materialize and bring forward using notwithstanding clause on a crime bill, I suspect provincial legislatures would have something to say on it. As a parliamentarian...
I must give a bit of time for the answer. The Honourable Leader of the Bloc. In the attitude of a Liberal government, there is the assumption and the claim that they are irrevocably morally superior. I am a Canadian Liberal. You are worth less. And if I control the federal parliament, obviously the provinces are suspicious. They are of lesser integrity than a Liberal federal government. And we've lived with that for so many years. And we are so tired of it, Mr. Speaker. We apply the Constitution. We have the right, and that's it. The Honourable Member for Mirabel. Thank you, Mr. Speaker. I'd like us to come back to the issue at hand. The leader of the Bloc Québécois said that the notwithstanding clause had been used for 43 years, over 100 times. So it was designed to be used preemptively. So how is it in 43 years, never a single time before the act respecting laicity, was there this idea that the notwithstanding clause could not be used preemptively? How is it after 43 years and over 100 uses? Why is it today, with Bill 21, that there is this new opinion? The Honourable Member for Belleuil-Chambly. Because they're not thinking things through. For a certain number of years, there was a desire to oppose two visions. And that wasn't such a bad idea because it pays off to do politics by attacking Quebec values, but that doesn't work. The next government of Quebec very likely will be a sovereigntist government. The current Premier of Quebec was at one time a sovereigntist. So perhaps they're saying, well, let's kill two birds with one stone. We'll attack secularism and at the same time the protection of the French language by centralizing at the outset permanently the power between the moral superiority of the federal government, of course. Questions and comments? The Honourable Member for Mont-Royal. Thank you very much, and thank you to the Leader of the Bloc for his speech. I'd like to note that the issue of whether the notwithstanding clause can be used preemptively is not even in the government's factum. It wasn't used. I'd like to ask a question to the Bloc leader. The Bloc is asking us to withdraw the factum before the Supreme Court, but there is a very important question that needs to be addressed. There are decisions by the Quebec Superior Court and the Saskatchewan Supreme Court that is different from the Quebec Superior Court. Does the Bloc Québécois not recognize that the Supreme Court needs to clarify the law for all Canadians? The Honourable Member for Belleuil-Chambly. Well, I would say it's the job of judges or the job of the government who will pay to hire attorneys general and draft a document that should embarrass them a lot. The notions of summary execution, for example, freedom of the press, and other issues. There's all kinds of craziness in there. But if there are people who want to resort to the Supreme Court, I have nothing against that. That's what it's there for. But the federal government is not supposed to take an ideological position and fund the adversaries of a bill that was duly voted on by Quebec and the provinces. Questions and comments? The Honourable Member from Lévis-Lotbinière. Thank you, Mr. Speaker. I feel like I'm seeing a Liberal government that has fabricated a crisis to draw attention away from an inflationary crisis, a debt crisis. There's a crime crisis that we're not talking about. Can my Bloc colleague, has he fallen into playing the Liberal game instead of talking about Canadians' reality? And we're talking all week about this topic. The Honourable Member for Belleuil-Chambly. If my esteemed colleague has fallen in the multiculturalism basket for Quebecers. Questions and comments. The Honourable Member for London West. Thank you, Mr. Speaker, and I appreciate the speech by our colleague from the Bloc Québécois. What we're discussing today is secularism, but I'm wondering, since he wants the federal government to stay outside of a situation that is directly tied to the federal government, what would he think if other provinces started using this? Perhaps if there were attacks on French language outside of Quebec, what would he say if that were the case? The Honourable Member for Belleuil-Chambly. The federal government is somewhat of a referee here. They say, I am in charge of the Constitution. I fund the opponents. I participate in the exercise with these attorneys general, and I disseminate political propaganda. Yes, you're saying, but there's a lot of people on the other side of the room talking about preemptive use as if it's one of the 7 cardinal sins. So the government is trying to reach a point of no return before Quebec has the good idea of becoming independent. Questions or comments? The Honourable Member for Rivière-du-Nord. Thank you, Mr. Speaker. Thank you to my colleague and leader for his speech, which I really appreciated. I have a question for him. Mr. Speaker, Section 33 is a tool that allows us to shelter some legislation from charter provisions. And if the government of Quebec or another province passes a law that allowed for slavery, for example, in his opinion, thanks to Section 33, would this government, what would be the consequences of the adoption of such a bill? The Honourable Member for Belleuil-Chambly. Well, there's some reading to be done on the precise application of Section 33, but I would thank my dear colleague and friend that there are, throughout the world, a large number of free and democratic societies that, without having the moral supremacy of Canada, do not use the death penalty or attack freedom of the press and so on and so forth. Resuming debate, the Honourable Member for Hull-Aylmer. Thank you very much, Mr. Speaker. It's a great pleasure to rise in this House to participate in this debate. And I'd like to indicate at the outset that I will be sharing my time with my honourable colleague from Mont-Royal. Mr. Speaker, I think that it's very important in this debate to remember how we came to this point. Why are we here? We're here to talk about a motion from our honourable colleagues from the Bloc Québécois, and I quote the motion that has 3 components, that the House call on the government to fully withdraw from the legal challenge of Quebec's act respecting the laicity of the state before the Supreme Court. But, Mr. Speaker, I can tell you quite simply that when we read the document submitted to the Supreme Court by the Attorney General of Canada, it is not contesting the well-foundedness of this legislation. B, the Bloc is calling on the government to withdraw its factum filed on September 17, 2025, with the Supreme Court contesting Quebec's right to invoke the notwithstanding clause. Once again, Mr. Speaker, we see in the factum that was tabled with the Supreme Court that the Attorney General of Canada is not contesting the use by a province of the notwithstanding clause. And C, the Bloc is asking the government to denounce the government's willingness to use the Supreme Court to take constitutional powers away from Quebec and the provinces. Mr. Speaker, I would conclude that the answer is no, but I will give a bit of nuance to the subject.
Le contraire.
The opposite course is the course that the federal government is taking. The government isn't trying to eliminate the use of the notwithstanding clause, because it's useful. It's useful to have this clause when there is a conflict between fundamental rights and a bill that has been passed by the National Assembly or another provincial legislature, or, if it were to happen, even by this Parliament. It creates the possibility that what's at the heart of this is that it creates a possibility where it might be important that the notwithstanding clause be used. Its use might be challenged by some or by others. There are some who might say that it shouldn't exist, but no, I think that it's a very useful clause in a case where there's, for example, a Supreme Court judgment that might say that a certain law goes against fundamental rights. It gives the legislature the opportunity to find a solution or to look for a way to either amend the law to respect the decision, or perhaps to find a compromise to ensure that the act can continue to exist, but not on a permanent basis. And this really takes us to the heart of this issue, to the heart of the factum that was tabled at the Supreme Court. You know, we have a situation here where there are provinces, not only my beautiful province of Quebec, and I'm, very strongly attached to Quebec. It's my home. It is my heritage. It's the place where I chose to raise my family, my children, and my grandchildren. As you know, Mr. Speaker, it's perhaps obvious with my accent that I am I'm an Anglophone. English is my mother tongue, but I made the choice to integrate Quebec society to make sure that I spoke the language fluently. I am a proud Francophile. And I think it's very important to highlight that because, Quebec is the place to which I feel the most attached. And, Mr. Speaker, when we have fundamental rights and fundamental rights that are in conflict with a bill, well, Quebecers and Canadians, if it were to happen in another province, as was recently the case in Saskatchewan or in Ontario, where there were bills that were put forward that used the notwithstanding clause in a preemptive way, well, I have the right to challenge that before the courts. And I think that it's perfectly normal that people would do that. Quebecers, there are people who disagree with certain bills. So they have that right. The government has decided to protect itself from challenges by using the notwithstanding clause. All right? And I can understand that. But if it's done repeatedly, it raises a very legitimate question. What is the notwithstanding clause for? What is the Charter of Rights for? Why do we have a Charter of Rights if we're constantly sidestepping rights that are guaranteed in that document? And what's happening is if the notwithstanding clause were to be used indefinitely, if every 5 years Section 33 is used, we'll find ourselves in a situation where there are no longer any rights. And, Mr. Speaker, I think that it's absolutely legitimate and reasonable to review that. And that's the heart of the factum that was tabled at the Supreme Court. And I hope that the Supreme Court justices will take note of that point of view and that they will offer a roadmap for Canadians and for the government in terms of how the use of the notwithstanding clause should be framed or limited. Because I think that there are some rights that have been given to all Canadians by the Charter of Rights and Freedoms, and these are rights that are very important. They are fundamental rights. They are rights that ensure that we can live in a constitutional democracy where we can make decisions, where the majority can propose laws, but where minorities are still protected from laws that would go too far in going against their interests. And for me, that's what's most important. That's why I understand why the Attorney General of Canada has put forward this factum. So, in summary, Mr. Speaker, I think that the Bloc Québécois motion, within it, I think for 2 of the 3 points, the answer is clearly that it just doesn't apply. And on the third point, what we're doing is we're attempting to prevent constitutional changes through the back door, through the use of the notwithstanding clause on an infinite or indefinite basis. I think that it's very important in a democracy that, and you know, we might have to be careful with using this word, but it's important in a democracy to find compromise. And that's what we do every day here in the House of Commons. We seek compromises to put forward laws that protect everyone and that will stand the test of time. Thank you, Mr. Speaker. Questions and comments? The Honourable Member for Pierre Boucher, Les Patriotes Verchères. Thank you very much, Mr. Speaker. You know, Mr. Speaker, we're having this debate today, and this is what my colleague didn't say in his speech, because Quebec decided to use the notwithstanding clause to put in place its State Secularism Act, to have secularism in Quebec. Quebec has also used the notwithstanding clause to protect the French language in Quebec. You know, it's funny. The Liberals across the way and all the governments before them have never said that the notwithstanding clause shouldn't be used until Quebec decided to use it to protect French and secularism, Mr. Speaker. So it's incredible hypocrisy, but they won't call it that. So, Mr. Speaker, and, you know, what's happening at the end of the day is that the Liberals have realized that the notwithstanding clause is a problem for them. They don't like it, but the reality is that it was imposed by the other provinces, not only by Quebec. It was imposed by the other provinces back when the Constitution was signed. So, since the member is saying that he doesn't like the Constitution, is he admitting that the Constitution isn't that great, the Constitution of Canada, and at the end of the day, because they can't amend it unilaterally, that they're asking the Supreme Court to play a political role? The Honourable Member for Hall-Aylmer. Well, Mr. Speaker, I'd like to thank my colleague from the bloc for his question. I don't want to contribute to raising the temperature on this. I'll simply answer his question. I think that the premise of his question was simply false. The Government of Canada firmly believes that the Government of Quebec has the right, the responsibility as government to protect the French language. But when we see that there are other provinces as well, Ontario, Saskatchewan, among others, who are using the notwithstanding clause to take away constitutional rights guaranteed by the Charter, and that's a problem. And it comes back to the question: do rights exist if we use the notwithstanding clause? Questions and comments. The Honourable Parliamentary Secretary to the Minister of Agriculture. Thank you, Mr. Speaker. I'd like to put a question to my colleague. He lives in Quebec. I live in Quebec as well. We're proud Quebecers, and many of my constituents are concerned about the impact on women's rights. Women's rights around the world are being taken away. If any legislature were to use the notwithstanding clause as the rule instead of as the exception, does that make our rights vulnerable? Thank you. The Honourable Member for Hall-Aylmer. Well, I'd like to thank my colleague for her question, but I can't specifically answer that question. But what I can say is that in theory, the problem with the preemptive use and the eternal reuse of the notwithstanding clause, well, the risk is that, yes, it could take away fundamental rights from people who need those rights. And that you can't do that. That goes against rights in a permanent way, and that effectively means that the Constitution has been amended through the back door. Questions and comments? The Honourable Member for Sherwood Park, Fort Saskatchewan.
Mr. Speaker, the FACTIB that we're discussing today from the federal government is notable in that it explicitly says that it is not about Bill 21, that it is rather about Section 33, that the government chose to intervene solely on the issue of its arguments with respect to Section 33. I wonder if the member could explain why the federal government made that choice.
The Honourable Member for Hall-Aylmer.
Well, Mr. Speaker, I'm very pleased to see that the official opposition, for once, has asked a question relevant to the debate that we're having today and not ducking it on other issues. So I thank the Honourable Member from Fort Saskatchewan, Sherwood Park, for asking this question. It goes right back to my whole speech, which is that the use of the notwithstanding clause is a legitimate use. The adoption of various laws in different provinces are also very legitimate. We're not contesting that. What we are contesting is that if you use it in a preventative fashion and you keep renewing the use of Section 33, then the question that you're left with, do those rights exist anymore that were supposed to be guaranteed by the Charter? And my answer would be, my reflection would be, that no, effectively you're doing a backdoor constitutional change that is eliminating rights which people should enjoy. There are opportunities for provincial legislatures and the federal parliament to take a look at these laws, take a look at the decisions from the courts, and to try to come up with a compromise that can work this thing out.
Resuming debate.
The Honourable Parliamentary Secretary to the Minister of Emergencies. Thank you, Mr. Speaker, and I'd like to thank my colleagues from the Bloc Québécois for proposing this subject for this Opposition Day. It's a pleasure for me to speak as a Quebecer here in the House of Commons because it's very important to recognize that Quebecers have many different perspectives on, for example, Bill 21 and on the issue of the preemptive use of the notwithstanding clause. The Bloc Québécois doesn't have a monopoly on speaking on behalf of Quebecers in this House of Commons. Most of the members from Quebec in this House are Federalist members on this side of the House. I'll just remind everyone of that in starting this debate. Second, the question of the federal government's factum at the Supreme Court. Well, this isn't a debate about Bill 21. Yes, Bill 21 is before the Supreme Court, but this is the first time that the notwithstanding clause and the way that the notwithstanding clause is used has been challenged at the Supreme Court for over 35 years. And so it's necessary for the Attorney General of Canada to be present in court at the Supreme Court to protect the Constitution and to protect the Charter of Rights and Freedoms. We have a Charter of Rights and Freedoms because we believed as a country that it was important to protect minority rights. And even if the majority in the country or in a province want to do something. And it's important to note that the notwithstanding clause can be used by the Parliament of Canada or by the provinces. So this debate is important for us as federal legislators as well. And we chose to have a charter because we've said that there are some rights that are so important that we need to protect them, even if the majority doesn't agree that it's important to protect these minority rights. And in our charter as well, we have Section 1. And it's, there's a limit. We say that legislatures can pass bills that go against a right if they do it in a way that is reasonable in a free and democratic society. So, when Section 33 is invoked, there's an inherent admission that it's not reasonable in a democratic and free society to limit rights in that way. The federal document makes three important arguments. And the first, and I'm saying it's an argument that's necessary because there are courts in Quebec, the Court of Appeals of Quebec, for example, which took a position which goes against positions taken by the Superior Court of Quebec and the Appeals Court of Saskatchewan. The number one job of the Attorney General of Canada is to make sure that there isn't a conflict of laws across Canada. That there aren't conflicting decisions amongst Canadian courts. That's why this clause has come before the Supreme Court of Canada, because the Supreme Court of Canada has to say what the law is. It's up to them to determine if the decisions of the Saskatchewan Appeals Court or the Quebec Superior Court stand, or is it the Court of Appeal of Quebec decision that stands, that says that no, the court can't look at whether or not rights were affected according to Section 1 because the notwithstanding clause was invoked. So the Government of Canada, the Attorney General of Canada, is there before the court because the Attorney General of Canada has to bring forward arguments to say yes or no. Do we follow the Appeals Court of Saskatchewan or the Appeals Court of Quebec? And what I find surprising is that the Bloc Québécois is saying that the Government of Canada shouldn't be present at the Supreme Court of Canada, but they're not saying anything about any of the other provinces that have intervened in this case. Should we take a position that all the provinces should be able to intervene, but not the Government of Canada? It's the role of the Government of Canada to protect everyone's rights, including the rights of Quebecers. And the government has to take a position to protect all minorities across the country. And we can't say that the Government of Canada should be there when you're happy with what's happening and shouldn't be there when you're not happy with what's happening. So I'd like to talk about the three arguments that the Government of Canada has made before the Supreme Court.
The government is making is that even if you use the notwithstanding clause, a court has the ability to declare that the law violates the Charter, Sections 2 or Sections 7 to 15, because those are the only Charter clauses that you can use the notwithstanding clause on, in a way that is unreasonable and free in a free and democratic society. And why is that important, Mr. Speaker? It's important so that the residents of that province know what their government has done.
When you use the notwithstanding clause in a preemptive way, and you're saying, well, there's no right that's really being violated, you're not giving all the information to the population. And if you're going to be re-elected, if you're going to run for re-election, it's important for the population to know if the Charter has been violated in a reasonable way, yes or no. And so that's an argument that's before the court right now.
Speaker, that the federal government is making is that if you violate a right that is other than 2 or 7 to 15, so for example, you violate freedom of expression under Section 2, but you violate also a right under Section 3 of the Charter, democratic rights, you do not have the right to use the notwithstanding clause to violate a right that is other than 2 or 7 to 15. Il y a des fois, Monsieur le Président.
Sometimes, Mr. Speaker, there is a law that is challenged not under just one section of the Charter, but under several sections of the Charter. And it's important that if you're going to use the notwithstanding clause, you can't violate one of the sections that is not subject to the notwithstanding clause. That's an important argument, and it's important that be clarified, that we make sure that other rights aren't affected because somebody has used the notwithstanding clause just according to certain sections.
Mr. Speaker, is the most important of the arguments the federal government is making in this case. It's that a right cannot be turned off in a way that you can't turn it back on just as brightly. Just like a light bulb, if you turn it off, when it comes back on, it shines just as bright. You cannot take a right under the Charter and utterly obliterate it so that when you say, oh, we're no longer using the notwithstanding clause, the people affected no longer have the ability to do what they were doing before. And that could happen either because of constant successive uses of the notwithstanding clause, or because the right that is obliterated is done in a way that is so unreasonable that it will ultimately deprive people of the permanent ability to exercise those rights. So when arguments are used before the court to illustrate what those may be, nobody is talking about these being the Quebec government doing them. They're talking about any government, including the federal government, that could do those things. We're simply saying that there are more than procedural grounds for nullifying an exercise of Section 33. Et finalement, Monsieur le Président.
And lastly, Mr. Speaker, I will just say that the argument that we just shouldn't talk about this and that the government should not submit a factum to the Supreme Court because there are other forums out there, well, that's true and all.
We're not doing things that they should have been doing by doing this factum. Nobody is talking about the people in housing or economics doing this factum. So the arguments that conservatives are using today is just beyond belief. And merci, Monsieur le Président.
So thank you, Mr. Speaker. The Honourable Member for Drummond. Thank you, Mr. Speaker. First, Shana Tova to my colleague from Mount Royal and all of the Jewish community of Quebec and Canada who are celebrating their New Year. Mr. Speaker, I recognize that me and my colleague across the way will probably never agree on the issue at hand. I know my colleague well. I've worked with him in the past, and I appreciate his openness to intelligent debate. Regarding the factum submitted to the Supreme Court, some people have said some inappropriate things. When my colleague says that the examples in the factum are just examples, well, this is... The things being talked about are removing women's rights, slavery, executions. This is all part of the rhetoric of fear. This is something that could be used to alienate part of the public. And I'd like to hear my colleague respond. The Honourable Member from Mount Royal. Thank you. And thank you to my colleague for his kind words. I would also like to say Shana Tova to the entire Canadian Jewish community. Mr. Speaker, I respect my colleague, but when you submit a factum to the Supreme Court, you are talking to justices, not to the broader public. What we're asking the court is, should there be limits on Section 33 beyond what is procedural? Then examples are used to highlight what could theoretically happen if Section 33 was used in a way that would utterly obliterate a right in a way that it could not be brought back. It's not a claim that the Quebec government will do anything like this. It's saying that there are things that no government should do by using Section 33.
Thank you, Mr. Speaker. I'd like to put something to my honourable friend and get his feedback on it. So I think all of us agree in this House that human rights are important. And we also agree that ideas about human rights are contestable. They're a matter of public debate. So things that member sees as being the implications of a belief in human rights might be different than what I or other members see as the implications of human rights. The reason why our Constitution has Section 33 is to affirm that the ultimate arbiter of questions that are contestable in the domain of human rights should be the elected legislature. And this is what preserves the essential nature of a parliamentary democracy, that it is Parliament, not courts, that have the ultimate say on where we should go in terms of defending human rights. The problem with...
I do have to give time for response. Now, member for Mount Royal.
Well, Mr. Speaker, I didn't really get a question in there, but let me just say again, I think it's really important, and I appreciate the substantive question I'm sure my colleague was coming to. The government's factum doesn't contest the ability of a province or the federal parliament to use the notwithstanding clause, although personally, my position has always been we should not do so. The factum sets out three specific arguments that I illustrated, and I think those arguments are very important that we have made.
The Honourable Parliamentary Secretary to the Minister of Agriculture. Thank you, Mr. Speaker. A question for my colleague. We have been talking a lot about the rights guaranteed by the Charter and how they need to be protected. But in order to protect these rights, is it necessary to say that when a legislator invokes the notwithstanding clause, it should be done on an exceptional basis and subject to certain limits, including judicial review? That's an important question. Without these limits, could the exception not become the rule? That is, could legislatures find themselves simply not respecting the Charter? The Honourable Member for Mount Royal, 45 seconds. I entirely agree with my colleague. It is very important that even if the notwithstanding clause is used in a legitimate way, courts should be able to inform the public of whether a right was violated in a way it shouldn't be. In the factum, we set out that courts should be able to examine the use of the notwithstanding clause. They should also assess whether a right is being violated not just for a 5-year period, but in a permanent way. The Honourable Member for Drummond. Thank you, Mr. Speaker. First, I would like to say I am sharing my time with my honourable colleague for Gaspésie, Les Îles de la Madeleine, Listagouge. I want to take you on a journey with my speech today. I think it would be beneficial for colleagues here who often hear Quebecers describe our woes but who are not familiar with Quebec history to understand our journey, which culturally is so different from Canada's journey. So together, let us talk about the history of Quebec values from their emergence to their affirmation, while also talking about the resistance they provoked. From the Parent Commission to Bill 21, including Bill 101 and its various updates, including most recently Bill 96. Starting in the 1960s, Quebec has undergone a vast process of emancipation, a major change that was not without obstacles, which one could only expect given the transformative nature of this change. All throughout this process, Quebec has been met with opposition from Canada, whose multiculturalism model is simply incompatible with the legitimate aspirations of Quebec. So let's go back to the early 60s. At that time, Quebec was a fairly traditional, mostly rural society, still dominated by the Catholic Church. Education was faith-based, unequal, also run by the Church, and hard to access for the average person. In that context, the Jean Lesage government set up the Parent Commission. That commission was tasked with reforming the education system. I would note that the commission included sociologist Guy Rocher, who passed away recently, and whose insights led to a consensus that few expected at the time: the need to remove religion from the education system and from the healthcare system. As such, the Parent Commission kicked off what we now call the Quiet Revolution, which, with audacious reforms like the creation of an education ministry, the CEGEP system, and, crucially, access to higher education for everyone. Because what we wanted to do at the time was get Quebec out of the dark ages. Let our young people aspire to the same heights that the Anglophones and the wealthy could dream of. Basically, we wanted to give equal chances to everyone at a time when Quebecers believe themselves to be, as the saying goes, destined for small things. But it wasn't just reforms. Values were changing. For the first time, Quebec began to affirm principles still new to us at the time, like secularism, equality of opportunity, the importance of knowledge. And to turn these principles into a reality, the state took over from the church. The future of Quebec society would be based on values that we chose and defined. The Quiet Revolution never really ended, but some say it reached its peak in the 1970s, when Quebec was gripped by nationalist fervor. Quebecers cast off their shame, electing for the first time in their history a sovereigntist government. On November 15, 1976, René Lévesque became the Premier of Quebec, and his party elected 71 members of the National Assembly. In 1977, the Lévesque government passed Bill 101, the Charter of the French Language. Once again, Guy Rocher fed into this important measure. Written in part by Camille Lorraine, that law would made French the official language of Quebec at a time when the French language was threatened by the English language throughout the continent. Bill 101 became the pillar of Quebec identity. It affirmed that French is not just a language, but it is a transmitter of culture, solidarity, and societal cohesion. One would expect this beautiful full moment to be met with support from our neighbors, but that was not the case, quite the opposite. Quebec's efforts to affirm our identity ran up against a Canadian wall. It wasn't long before the Canadian Supreme Court got rid of parts of the bill, including those concerning unilingual French language signage. The federal government has a bilingual model, yeah, right, and a multicultural model. And it believed that Bill 101 was an attack on Anglophone rights. This shows the wide differences between the two respective visions of societal cohesion. Quebec believes in a common language. Canada believes in throwing together various languages and cultures in sort of a tossed salad. We are worlds apart. Because my colleagues have already talked about this, I will skip forward a few years. I will not talk about the sorry episode of the constitutional repatriation, Jean Chrétien's betrayal, Pierre Elliott Trudeau's arrogance, and I will note here that Pierre Trudeau never managed to crush Quebecers under his boot. I will not talk about the constitutional crises that led up to the stolen referendum of 1995. I will resume in 2019, the year when the Quebec National Assembly passed the Act Respecting the Laicity of the State, Bill 21. Bill 21 is part of the secularization tradition that began during the Quiet Revolution. It aims to guarantee the neutrality of the state and preserve a true common public space with no visible religious expressions. This is based on the societal model that Quebecers believe in. But again, Canada opposed this measure. The federal government described the bill as discriminatory. Advocacy groups challenged the bill before the courts. Quebec was expecting that. That's why we invoked the notwithstanding clause. What does this demonstrate? An ideological fracture. Quebec believes in active secularism, where the state imposes rules on the public space. Canada believes in permissive secularism, where religious freedom trumps neutrality. Over the decades, Canada and Quebec developed increasingly divergent societal models. The Quebec model is based on the French language as to cement society together, and secularism of state institutions. We believe in interculturalism based around common values, French, gender equality, secularism. And we believe in political and cultural autonomy. The Canadian model likes to think of itself as bilingualism, even though it is widely English-dominated. It also believes in multiculturalism, centralization, and a focus on individual rights instead of collective values. These are not just theories here. These are differences that have had made a real difference in terms of immigration, justice, and citizenship. These differences are what are causing all the tensions between Quebec and Canada. At the end of the day, Canada thinks Quebec is one province among others, but Quebec knows that we are a culture unto ourselves, a unique people with a unique future. Canada often views Quebec values as exclusionary or backwards, but we are proud of our identity. We are not aiming to exclude anyone. We are aiming to gather everyone around a common goal. From the Parent Commission to Bill 21, Quebec underwent a quiet but important revolution. We redefined our values, affirmed our identity, and built a society that we could be proud of. And all throughout this path, we were met with opposition from the Canadian government. Canadian multiculturalism is just not compatible with Quebec aspirations, but that didn't stop us. In fact, it fed our desire to define ourselves. The story of Quebec values is the story of a nation that aimed to be in control of itself. If you believe Quebec is going too far, I would refer you to studies showing that we are not going far enough. In fact, Quebec needs to be defended even more. Section 33 is one tool that we use to protect the Quebec legislature from federal maneuvers that would undo our emancipation process. The Quiet Revolution never really ended, but some believe it will reach its peak at some time after fall of 2026, when Quebecers will complete the story that so many contributed to: Lévesque, Lorraine, Perron, Parizeau, Marois, and so many others, including Guy Rocher. I had the incredible privilege of meeting Guy Rocher in April, and he told me that despite all the obstacles, despite all the years that have passed, despite the ups and downs of fate, our fundamental values will always continue to exist. They are worth fighting for, and they are worth protecting as long as there are those out there who would challenge them. Thank you.
Parliamentary, the honourable member for Scarborough Centre, Don Valley East.
Thank you, Mr. Speaker. Through you, I would like to ask the honourable member that if Bill 21 was the law of land here in Canada, I would not be sitting here in this place because I wear a hijab. And and I would not have been able to be a teacher because I wear a hijab. There are a lot of young girls who are aspiring to be lawmakers, who are aspiring to be bus drivers or school teachers. So what would the honourable member like to say about the rights of those young girls who are aspiring to be sitting here?
Honourable Deputy Drummond.
The honourable member for Drummond. An excellent example of misinformation and a lack of understanding about what Bill 21 is. Bill 21 doesn't prevent anyone from running for elections or sitting in Parliament. And I would say we should stop thinking that Bill 21 is what stops people who wear religious symbols, including people who wear the hijab, from doing anything. If your religion prevents you from doing a certain job, maybe you should question your religion. Bill 21 is a crucial bill to protecting Quebec values. It promotes equity, equality, and neutrality throughout the public sphere. I think it is logical and legitimate. Questions and comments? The honourable member. Thank you, Mr. Speaker. I listened to my colleague's speech with great interest. Montmorency Charlevoix is where everything started. It's very important to Quebec and Canadian history. We are linked to both Francophone and Anglophone identity. How could my colleague suggest that Quebec identity could influence Canada? Could perhaps we help Canada define itself? Could we help perhaps define Canadian values and put a stop to this unbridled immigration? The honourable member for Drummond. I'm happy that my colleague from Montmorency Charlevoix believes that Quebec has a lot to contribute. I don't think it would be useful for us to demonstrate anything to Canada. Certainly, we can be good neighbours, and we could work with Canada on any number of issues, for example, trade. I understand that my colleague is speaking from a federalist viewpoint, and he seems to think that Quebec could teach Canadians to be better citizens. But I think things will be better in Quebec when we have all the tools in our toolbox to do, that is, full independence. The honourable member for Pierre-Boucher, Les Patriotes Verchères. Thank you, Mr. Speaker. Since it was mentioned earlier today, but I'd like to come back to it, looking at the tone of the factum submitted by the Attorney General of Canada to the Supreme Court when challenging Bill 21, we observe that there's kind of a moralizing tone. They're assuming bad faith on the part of the provinces, especially Quebec. They're saying those people, ooh, they're dangerous. And yet the federal government, saintly as it is, will come and protect the rights of everyone, including Quebecers. Does my colleague not agree? Also, if you look over the story of the past 150 years, does that view hold any water? The Honourable Member for Drummond. Thank you. I was shocked when I read the factum, which implied that some governments would be willing to bring back summary executions or get rid of freedom of the press. I heard my colleague from Pontiac saying that gender equality was at risk. Mr. Speaker, as my colleague noted, Quebec is the most progressive society in all of North America. We would certainly not go down such a dark road. And even if these are just examples of extreme cases, they are a type of fear-mongering. You know, people are now worried. We could fearmonger too. We could say that the Canadian Army will invade one day, but that's not the sort of people we are.
Resuming debate, the Honourable Member for Gaspésie, Les Îles-la-Madeleine, Bisserouge. As far back as we can see, Quebec has wanted a space of freedom, the ability to express its difference and the ability to make its own choices. This desire for freedom and democracy is the backdrop that led to the Patriots movement and the Quiet Revolution of the 1970s. It's this desire for freedom and democracy that pushed significant reforms by the René Lévesque government starting in 1976, and more recently, Bill 21 on laicity and Bill 96 to strengthen the protection of French. Quebec is a people, a language, and a territory with its own colors, a nation with its own values. For some like me, the only space of freedom that we would want is a country. We want to be an independent Francophone state in North America that would give Quebec full power to determine its own destiny. A Quebec free to negotiate treaties itself that it would negotiate with other countries. A Quebec free to decide its own development democratically and to protect its language and economy. For others, Quebec might want to stay in Canada, but there would be enough space in the Canadian ensemble for the Quebec difference. For those people, the notwithstanding clause is the evidence that Canada can allow Quebec to affirm its difference on occasion. The notwithstanding clause is an section of the Constitution that allows a province and even the federal government to pass a bill without allowing judges to review it. We talk about a parliamentary sovereignty clause because it allows the parliament to democratically vote in a bill that would not be deemed invalid by judges. The clause is limited. It can only derogate some individual rights of the Canadian Charter and is valid for only 5 years at a time. The Quebec government has invoked the parliamentary sovereignty clause to protect against any challenge the Laicity Act. Since 1982, Quebec has used this clause on a number of occasions to protect bills voted on by the National Assembly in Quebec. It was used to protect the French language and the national identity of Quebec. But more broadly speaking, Quebec has used this clause also to promote collective rights and societal objectives. For example, to give advantages to agricultural renewal, to encourage employment by the government of people from underrepresented communities, to improve access to justice with the small credit court, to protect the identity of youth in the before the youth courts. All of these social advances, which were desired by Quebec, could not have been put forward without under the Canadian Charter of Rights and Freedoms. This parliamentary sovereignty clause is a small amount of freedom that allows us to express Quebec democracy. It is a way to resist the effect of uniformization of the Canadian courts. For René Lévesque, who was subjected to the Night of the Long Lives during the patriation of the Constitution, this was not enough. That is why he said that Quebec never signed the 1982 Constitution. But for a number of Canadian provinces, this is a compromise that made the Constitution acceptable. And that is why the Liberal government wants to reduce this small space of democratic freedom. It is inviting the Supreme Court to limit the use, which could... and it doesn't have the courage to propose a negotiation with the province. It is asking the judges to do its work for them. It is saying that without new limits, Quebec could commit dangerous measures. It is such a condescending view of Quebec, and it is nothing new. It's a target against Quebecers because if the Liberal government were truly concerned by the principle of the notwithstanding clause for fundamental rights, it would start cleaning up its own legislation because most of the charters contain a notwithstanding clause. Quebec's has one, Alberta's has one, and Saskatchewan's has one too. And even the Canadian Declaration of Rights contains one. The Canadian Declaration of Rights is a charter of rights that applies to fields of federal jurisdiction. It was adopted in 1960 under the leadership of Mr. Diefenbaker, and Section 2 is a notwithstanding clause. If the federal government were so concerned about the possibility that it were applied, it should start changing by this legislation itself in this House. But no, what concerns it is not notwithstanding clauses in general. It's rather that Quebec might try to express its different opinions, and that's why it just wants to establish guidelines for Quebec. Let's look back. In 1981, during the debates around the adoption of the Parliamentary Sovereignty Clause, the Liberal Justice Minister of the time, Jean Chrétien, rose in this House. It was November 20th, 1981, and I quote, "The notwithstanding clause is to give flexibility to legislative assemblies so that they have the last word instead of judges about issues of public interest. The history of use of the notwithstanding clause and the need for giving us a pressure valve," these are Mr. Chrétien's word, "to correct absurd situations without having to obtain constitutional amendments led three defenders of civil rights to encourage the insertion of the notwithstanding clause in the Charter of Rights and Freedoms. He concluded by saying, "It is understood that the compromise between the Prime Minister and the 9 premiers," at the time Quebec did not sign, "this compromise includes the insertion into the Charter of Rights and Freedoms. No right guaranteed in the original version of the Charter is excluded from the compromise." The Charter was improved. Those are Jean Chrétien's words. The Constitution was improved with the addition of the notwithstanding clause because it could correct unpredictable situations without amending the Constitution. So Mr. Chrétien was perhaps addressing those who are forming the Liberal government today, and I would remind you that the price of the freedom is eternal vigilance. In April 2019, nearly 40 years later, the former Prime Minister still did not change his opinion, and he said to CBC, "I supported the notwithstanding clause because I thought we needed it. We can't rely uniquely on the courts. That is why I'm happy that we have a notwithstanding clause. When they write their rulings, judges know that governments can refuse one of their judgments." And now I'll read comments by Pierre Elliott Trudeau, who was comfortable with the notwithstanding clause, and here's what he said. "I must frankly admit that I don't really fear the notwithstanding clause. It may be abused like anything, but you just need to look at the Canadian Declaration on Rights adopted by Diefenbaker in 1960. It includes a notwithstanding clause which did not trigger a large scandal. I think that we, politicians, have the final word. Mr. Speaker, when I think that we have to quote the former Prime Ministers Trudeau and Chrétien to defend the autonomy of the provinces, things are really going badly. We need to take stock of what's happening. This clause was not sufficient to convince Quebec to sign the Constitution in 1982, and now it's too broad for Ottawa to tolerate it. This space of democratic freedom for Quebec is now a historic error that the federal government wishes to correct. The more things change, the more they're the same. It gives a real view of the situation. Canada is working against Quebec's difference, and it will always go farther, and it will never stop. But Quebec is a people, a language, a land with its own colors, a nation with its own values. And one day, I'm certain, a majority of Quebecers will agree that the only space for freedom that belongs to us is a country that belongs to us. Questions and comments? The Honourable Parliamentary Secretary to the Minister of the Agriculture. Thank you very much. I like the sentence that the price of freedom is eternal vigilance. That's exactly why I am rising to ask him a question today. The Charter of Rights and Freedoms protects a number of rights, including women's rights. We're in the Canadian Parliament, and if a Canadian government decided to limit these rights by invoking the notwithstanding clause, would my colleague feel that there would be circumstances in which the legal power could review that and establish guidelines? The Honourable Member for Gaspésie, Les Îles de la Madeleine, Ristigouche. Thank you to my colleague for her question. I took the time to read Jean Chrétien's comments because he was addressing my colleague by saying that the notwithstanding clause is a compromise with which Mr. Chrétien agreed and Mr. Trudeau agreed. And he said to those people who are concerned, who think that it is too broad, know that we're always vigilant, and there are people watching what goes on in the political sphere. What is happening here, Mr. Speaker, is quite scandalous. There is a notwithstanding clause that is used very judiciously in a very restricted way, and this government goes farther than any other Liberal government to once again close the space to Quebec.
Nanaimo, Lady Smith.
I want to thank the honourable member for his remarks. I particularly appreciate the depth of the historical references and the research that he's done. Turning to the situation and the serious challenges that we are facing today, including things like failure to get a trade deal, mounting federal debt, runaway costs, and serious crime in our communities, I'm wondering if the honourable member agrees that the Prime Minister's decision to intervene here really risks creating a constitutional distraction at the very moment when we most need the federal government to be focused on more urgent day-to-day concerns. Thank you.
The Honourable Member. Thank you, Mr. Speaker. Thank you to my colleague for her question. And I must inform her, she must know already, but Alberta wants to use the notwithstanding clause currently. It's thinking about it. So what the government is doing here in this debate is far from being a distraction. We are discussing to what point the provinces will be able to decide for themselves how they want to live, how they wish to behave. And if this debate continues to be hijacked by the Liberal government, and if the Supreme Court gives reason to their argument that provinces will be less well equipped to face all of the challenges of our times, including economic crisis. The Honourable Member for Shefford. Thank you very much, Mr. Speaker. Thank you to my colleague for his speech. I would like to hear from him on the hypocritical aspect of the Liberals in this debate, because the Liberals are saying that they didn't want to touch the issue of secularism and they want to be the great defenders of Quebec, but behind the scenes, Mr. Speaker, by the fact that they are challenging the notwithstanding clause, we understand that with this clause we could somehow harm the liberty of the press. They saying that we're not protecting local media enough. Well, it's pure hypocrisy, and that I hear the member from Pontiac who's saying that Bill 21 is a bad thing for women. Once again, Mr. Speaker, this is hypocrisy. The Honourable Member for Gaspésie-les-Îles-de-Gauche. Thank you very much, Mr. Speaker. Thank you to my colleague for her question. Obviously, this government has it out for the Secularism Act, and the route that it is taking, it's not attacking it head on. What it decided is that there are a number of interveners at the Supreme Court who will do so, and by attacking the notwithstanding clause, which is perhaps a way for them to not add oil to the fire, because they're attacking not only our democratic decision in Quebec on living together, but they're also attacking all of the powers of Quebec and the provinces within the broader Canada. Resuming debate, the Honourable Member for Beauport-Limoilou. Thank you, Mr. Speaker. I will be sharing my time with the member from Les Pays d'en Haut. Mr. Speaker, I rise today to speak in response to a motion asking the government to withdraw completely from the case concerning Bill C-21. It says that the Government of Canada, the government of all Canadians from one ocean to the other, should not participate in one of the constitutional appeals of the greatest importance in recent times. It directly concerns Quebec legislation, of course, but the legal issues that they raise and that the Attorney General of Canada has to address are of essential interest and deal with the role and importance of the Charter in our modern system of governance. The Supreme Court must determine what it means to use Section 33 of the Charter by a parliamentary provincial legislature. Section 33 of the Charter, which is known as the Notwithstanding Clause, has never been used federally. Today, I would like to speak a bit more about some of the ways, the better understood ways, the Charter favors good governance and the improvement of policies and bills. And I would like to highlight the well thought out practices that could be threatened if use of Section 33 becomes more common. What I will say today is that the Charter imposes essential discipline on the drafting of policy and bills by government. A discipline that could be lost if Section 33 and its use become normalized. Allow me to explain. The Charter is part of the Constitution, and the Constitution is the reigning legislation of our country. That means that every act and every action by the government must comply with the Charter. As a country based on principles that include the rule of law, governments must ensure that the measures that they take and the bills that they propose comply with the Charter. And there's no doubt that the governments before 1982 were aware of the fundamental values of a free and democratic Canada that needed to be enshrined in the rights and freedoms guaranteed by the Charter. But after 1982, respecting these values became an imperative constitutional matter. To be clear, respecting rights and freedoms does not mean that they can never be limited. The rights and freedoms enshrined by the Charter are not absolute. Section 1 of the Charters expressly sets out limits, which are very important, and which guarantee the rights and freedoms under reserve of reasonable limits set out by the rule of law, the justification of which can be demonstrated in the context of a free and democratic society. What are these reasonable limits that can be imposed on the rights and freedoms of Canadians? It can be summarized in a series of questions that seem simple. Is the objective of the government sufficiently important to justify the limitation of a right? Is the limit a rational means of achieving this objective? In seeking to attain this objective, does the law use the option that causes the least harm to the person whose right is limited? And finally, if the answer to each of these questions is yes, the overall harm caused to the right, is it worth it when it is set in the context of the advantages of the limiting measure? If that is the case, in Canada, we feel that this limit is reasonable, and we assume that the government is properly equipped with evidence, logic, and reason that underpins this justified action.
When potential impacts on rights and freedoms guaranteed by the Charter are identified in the context of the policy-making process, governments have to carefully assess whether the limitations on rights and freedoms are reasonable and whether or not they can be justified in a free and democratic society, the society that we have in Canada. As I noted earlier, this requires asking a series of questions that ultimately address the reasonableness of what is being considered. So let's look at the first question. Is the government's objective in proposing new legislation sufficiently important to justify limiting a right or a freedom? This could prevent governments from proposing trivial or merely symbolic laws that would limit rights and freedoms. The second question is whether or not the proposed means of achieving the government's objective is rational, or in other words, whether the government's put in place the right tool for the job. This helps avoid relying, for example, on quote-unquote common sense that may or may not be well-founded or well-informed. Simply saying that public safety will be improved by doing such and such a thing doesn't make it so, especially if the weight of evidence shows that this is not the case. If we're to be honest with ourselves, evidence-based solutions to certain problems are often counterintuitive, and governing in accordance with the rights and freedoms guaranteed by the Charter helps us to recognize this and to propose better and more effective approaches. The third question seeks to determine whether there's another effective way to achieve an important objective while causing less harm to a right or a freedom. In order to meet this standard, we have to do our homework on the various options available to advance an objective, and it's important to choose the most reasonable way forward, the way that causes the least harm to Canada's fundamental values and to Canadians whose rights or freedoms will be limited. And finally, the last question concerns whether the benefits of a proposed law in achieving an important objective outweigh the harm caused to the exercise and enjoyment of the right or the freedom in question. This is the ultimate assessment of costs and benefits, and this assessment must be objective. This element of Section 1 prevents the enactment of laws that have marginal benefits and that have real impacts on the rights and freedoms of Canadians. It does not tolerate laws that disregard the rights and freedoms of individuals, rights and freedoms that might be unpopular, or individuals who might be unpopular, such as those accused or punished for a crime, or laws that disregard the negative effects on members of a minority group who have limited political power and little or fleeting public sympathy. I think everyone agrees that the questions the Charter requires us to ask when considering new legislation are good and appropriate questions. These questions, and the answers to them, are asked and evaluated throughout the policy-making process, from the initial discussion within a department of the options available for solving a problem, up to the Cabinet's review of the options, to the drafting of a bill, and finally, the most important stage, the debate and the passage of the bill by Parliament. Weak answers to any of these questions should raise alarm bells and lead to further scrutiny and to consideration of alternatives. Having good answers to the questions that the Charter requires us all to ask leads to more thoughtful and considered policies. It leads to better laws for all Canadians. The absence of good answers and weak arguments and evidence in support of poorly drafted legislation should lead the government to be held accountable for its choices. So that's what we need to worry about if the use of Section 33 becomes normalized in Canada. Instead of carefully considered, well-reasoned, logical, and evidence-based laws that limit rights and freedoms and are subject to strong checks and balances in the form of judicial review before the courts, the use of Section 33 eliminates this disciplined approach to lawmaking. The use of Section 33 can amount to a crude assertion of power over the rights and freedoms of individuals in Canada that directly contradicts the way federal governments has functioned for more than 40 years. Although Canada is one of the best countries in the world to live in, we are far from perfect. We've made serious mistakes in the past. Prejudices, blind spots, and bias are all inherent to human beings and the institutions that we create and operate. And here's a few examples from the past of mistakes from the past. Imposing an entrance tax on Chinese immigrants, forcing generations of Indigenous children into residential schools. In 1939, turning away Jewish refugees from Germany aboard the MS St. Louis. There may be some who unfortunately continue to believe in the correctness of some or of all of those decisions, but in general, as a nation, we've come to regret them and apologize for them. The discipline that the Charter imposes on the government in the decision-making and legislative process helps prevent such tragedies from happening again in Canada. Thank you, Mr. Speaker.
Comments, questions et commentaires.
The Honourable Member for Pierre Boucher, Les Patriotes Verchères. Thank you, Mr. Speaker. The Liberals have never hid their intention. They've always questioned Quebec's secularism laws. Quebec's laws to protect French are problems for them as well. And Quebec is using Section 32 to defend its language, defend its identity, to defend secularism. And now all of a sudden, the government is stuck with this situation, and they're trying to find a solution when it comes to the notwithstanding clause. And so now they're asking the Supreme Court to find the solution by inventing new law around the notwithstanding clause, because they know that they won't be able to amend the Constitution to get rid of it because they can never get the support they need from the provinces. So because they know that they're not able to amend the Constitution, they're asking the Supreme Court to do it for them. Doesn't my colleague find that that's a lack of courage from the federal government? The Honourable Member for Beauport-Limoilou. Well, I'd like to thank my colleague from Quebec for the question. I'm a proud Quebecer. I come from a family in the Lower St. Lawrence. I was raised by proud parents on a dairy farm, and that doesn't make me any less Canadian. And what we're talking about today are prejudices that could cause harm in the future. The past is never a guarantee of the future. What happens today, there are things happening today that are affecting the Charter of Rights and Freedoms that's been protecting us for over 40 years. Nobody knows what's going to happen in 10, 15, 20 years. We're seeing what's happening to the South. And we need to continue to protect the Charter, which has been protecting us for 43 years. We need to protect it for all future generations, Mr. Speaker. The Honourable Member for Jonquière. Thank you very much, Mr. Speaker. My colleague said something similar to what the member for Pontiac said this morning, as if it was irreconcilable on the one hand to put in place a policy that would put a framework around religion, and at the same time, on the other hand, the motion which allows Quebec to follow its own policies. I find that surprising. If you're even remotely familiar with Quebec's history, you'll realize that Quebec had to separate itself from religion. Quebec had to become a secular society to modernize its society. So how is it that the notwithstanding clause is becoming a threat to, for example, the rights of women, as the member for Pontiac said earlier? The Honourable Member for Beauport-Limoilou. Well, thank you, Mr. Speaker. I'd like to thank my colleague for his question. And indeed, there's a couple of points that I'd like to clarify for my colleague. The Bloc wants us to talk about Bill 21, state secularism. Well, when I was a kid, every Sunday we went to church. every Sunday. I was raised in not the industry, but in religious faith. I have, aunts who are in that faith. And today I'm standing here before you to speak about protecting the Charter of Rights and Freedoms. The Bloc wants us to talk about Bill 21, and they want to start a fight on that. And, I'm a Quebecer like my colleague, and, there are twice as many Liberal MPs from Quebec as there are members from the Bloc Québécois, and we know that Quebecers are sick and tired of all these fights. They don't want any of these fights. They want a responsible government that's going to protect their rights. Questions and comments?
And Fanshawe. Yes, Mr. Speaker. The Liberal government is trying to create a crisis to ignore from the real crisis Canadians are faced with. Canadians are thinking about the inflation crisis. Food inflation continues to rise. Can I continue? All right, 70% above target. Food prices are 40% higher than the Liberal government took office. The Liberals are creating a new crisis to distract from the problems they have created. Will the Liberal government please tell Canadians, including the constituents of London Fanshawe, how they will solve the ongoing inflation crisis?
The Honourable Member for Beauport-Limoilou. Well, thank you, Mr. Speaker, and I thank my colleague for the question. We're not trying to create a crisis, quite the contrary. We're not trying to fight a fight, as I was saying earlier. People, what they want, the people who elected us with a clear mandate, people want to be protected, and that's what we're doing right now. As we say, we're, standing up every day, and we're doing the work that has to be done, for our constituents from coast to coast. Yes, I'm a Quebecer, but I'm also a proud Canadian, like my colleagues from Ontario, from Yukon, who are standing up and who want to protect the Charter of Rights and Freedoms, and that's why I'm here today. The Honourable Member for Les Pays d'en Haut. Thank you very much, Mr. Speaker. Today, I'm pleased to have the opportunity to speak on the motion moved by the member for Rivière-du-Nord, who is my riding neighbour. I'd like to begin by reminding this House that the issue raised by these motions is not trivial. It touches on one of the pillars of our democracy, the Canadian Charter of Rights and Freedoms, which applies to all Canadians. It also raises fundamental issues related to the interpretation and use of the Notwithstanding Clause, which is an exceptional section of our Constitution. Our presence before the Supreme Court is not intended to reopen old debates. It's in no way intended to pit Canada against the provinces or to question the legislative powers of the provinces. Our participation in this appeal is intended to fulfill an important constitutional duty of the federal government: to defend the rule of law, ensure the consistency of our Constitution, and protect the rights and freedoms we all share as citizens of this country. There's nothing unusual or unexpected when it comes to Canada's participation in the appeal brought by the Montreal English School Board. By supporting the Supreme Court in this case, the government is simply doing what it has always done and will always do, which is to defend all Canadians. That's our responsibility and our privilege. Before getting into the details of the case at hand, I'd like to go over the institutional framework within which the federal government intervenes before the Supreme Court. When constitutional and charter issues are brought before the court, the rules require that notice be given to the Attorney General of Canada and to the Attorneys General of the provinces. And in those circumstances, the federal and provincial Attorneys General have the power to intervene as of right. The Attorney General of Canada is frequently called upon to act as an intervener before the Supreme Court. And this should come as no surprise. In order to defend the public interest, the Attorney General must be able to participate in cases that raise important constitutional issues. The goal being to ensure that the constitutionality of laws is fully and properly debated before the court. This role helps to uphold the rule of law. It ensures that government actions respect the limits set out by the Constitution and the Charter, and it ultimately ensures that the rights and interests of all Canadians are protected. I'd like to emphasize the unique role of an intervener before the Supreme Court. As an intervener, Canada's primary objective is to make a meaningful contribution to the resolution of complex legal issues that have significant consequences for all Canadians. The government does not seek to argue for a particular outcome or take a position on the validity of the provincial law at issue. Rather, it aims to support the court by offering a useful and distinct perspective on the legal issues under consideration, based on its constitutional responsibilities and its ability to provide a national and federal perspective on the issues that are before the court. For example, as a national government, Canada has a significant interest in ensuring that the Constitution, the supreme law of the land, is interpreted and applied consistently across the country. As a national government, Canada also has an interest in promoting and protecting national unity, and that's a role based on the principle of federalism. Furthermore, as a national government, we have a clear interest in the rights and freedoms of all citizens, regardless of where they live. The Attorney General of Canada has an important role to play in ensuring that minority rights are respected consistently throughout the Federation. The Supreme Court of Canada has made it clear, particularly in the reference RE secession, that respect for minorities is one of the underlying principles of the Canadian Constitution. This principle, along with federalism, democracy, constitutionalism, and the rule of law, forms the foundation of Canada's constitutional framework. As we know, this government has demonstrated an unwavering commitment to defending the rights of linguistic minorities across Canada. I would now like to illustrate how these principles apply in practice to the case that's before us today, namely the case involving the English Montreal School Board and other appellants. We've always indicated that, given the issues of national importance raised by this case, we would be there before the Supreme Court of Canada to defend the Charter. And that's exactly what we're doing today. To be clear, many questions about how the Constitution is interpreted or applied are at stake in this case. In addition, several provinces other than Quebec, as well as some 40 organizations, are already involved in this case, each presenting its own arguments on these issues. In my view, this is the best proof that this is a debate of major importance for our country and our federation. That is why this government indicated its intention to intervene in this case last March and submitted its factum to the Supreme Court on September 17th. In so doing, we are making the voice of the Government of Canada heard in a debate that directly affects the interpretation and the future of the Charter. This case is not limited to the immediate issues before the court. It touches on fundamental freedoms and rights, as well as the interpretation and application of the Charter. In this regard, I'd like to clarify that the representations made by the Attorney General of Canada do not relate to the Secularism Act in Quebec. They relate exclusively to the proper interpretation of the Charter. The Supreme Court's decision will determine how the federal and provincial governments may invoke the notwithstanding clause in the years to come. The Attorney General of Canada is firmly committed to participating in these important national discussions which could have an impact on all Canadians. For this reason, the government will not withdraw from this debate before the Supreme Court. To do so would be to fail in its duty to defend the Charter and contribute to maintaining a clear and consistent constitutional framework for the entire country. It is in the interest of the court, the public, and the Constitution that the government contribute to this debate, particularly in regard to the interpretation of Section 33. As it is already stated, this government is very concerned about the increased use of the notwithstanding clause, Section 33 of the Charter. The first word should not be the last in the dialogue between legislatures and courts. We're seeing, Mr. Speaker, across the country, increasingly frequent use of the notwithstanding clause by legislatures. We have heard Canadians express their concerns about whether or not it's appropriate to see the notwithstanding clause be used this way. And I'll repeat it. Our role is to provide the court with useful observations on the interpretation of a provision of the Constitution, in this case, the notwithstanding clause. This contribution is intended to strengthen the debate and not to target a province or to challenge its ability to legislate in its own jurisdiction. We respect the jurisdictions of the provinces, including those of Quebec, but respect does not mean sit back in silence. When an issue concerns the interpretation of the Charter, it's normal, even essential, that the Government of Canada make its voice heard. And on that, I will thank you, Mr. Speaker. Questions and comments? The Honourable Member for Lac-Saint-Jean. Mr. Speaker, thank you. The real question here in today's debate is the following, and I'll ask it to my colleague. If the government's invention in the Supreme Court through its factum ends with the result that Bill 21 is invalidated, would my colleague be happy with that result? Thank you, Mr. Speaker. The Honourable Member for Les Pays d'en-Haut. Well, thank you, Mr. Speaker, and I'd like to thank my colleague for his question. The debate isn't there. Bill 21 is not at question before the Supreme Court. Here, it's a question only that affects the use of the notwithstanding clause, and I think it's important to defend the rights of all Canadians. Thank you, Mr. Speaker.
Questions and comments to the Honourable Secretary.
The Honourable Parliamentary Secretary to the Minister of Agriculture. Thank you. My colleague and I are friends and proud representatives of Quebec that elected twice the number of Liberals as the number of bloquistes. We are excited to take part in this important debate. My colleague mentioned the importance of how people are calling on us as MPs to protect them against the erosion of their fundamental rights. How will this court intervention fulfill that mandate? The duty to protect the rights of all Canadians, including Quebecers.
Honourable Deputy.
The Honourable Member for Les Pays d'en-Haut. Thank you, Mr. Speaker, and I'd like to thank my colleague for her question. I think that the notwithstanding clause and the Charter are both necessary, but repeated use of the notwithstanding clause can harm the fundamental rights of Canadians. This trial at the Supreme Court will ensure that the notwithstanding clause is used in a way that Charter-protected rights remain protected at all times.
Burnaby South, Richmond Hill South.
Thank you, Mr. Speaker. The Liberal Party of Canada is the party of national division. At a time when Canadians are facing an immigration crisis, a cost of living crisis, a debt crisis, a crime crisis, and a housing crisis that was intentionally perpetuated by this Liberal government, I'm wondering why this Liberal Prime Minister is so keen on distracting Canadians by creating a national unity crisis at this time.
Honourable Member for Waterloo on a point of order.
Mr. Speaker, I think we have to respect within this chamber that there are rules and opposition parties are able to raise their opposition day motions, and the Conservatives are not giving value to the debate that is on the floor of the House of Commons, so I would ask relevance on this matter.
As the member knows, as a former government House leader, there is a broad latitude for relevance in these questions and comments. L'Honourable Député de Les Pays d'en-Haut.
The Honourable Member for Les Pays d'en-Haut. Thank you, Mr. Speaker. I find it shocking that Conservatives are talking about everything except the motion tabled by our colleagues across the way. This is an important issue and one that should be debated. The fundamental rights of Canadians must be respected through the Charter, and I think that today's debate is more important than the various issues raised by my colleague across the way. The Honourable Member for Jonquière. Thank you, Mr. Speaker. I understand my colleague's answer. He's saying that today's debate is only regarding the notwithstanding clause, not Bill 21. So I have a very clear question for him. As an MP from Quebec, does he support Bill 21, a bill that would limit religious expression in the Quebec public sphere? Does he support the bill? That's my question for my colleague. The Honourable Member for Les Pays d'en-Haut. Thank you, Mr. Speaker, and I'd like to thank my colleague for his question. I think Bloc Québécois members are trying to create division here. Today we are debating the notwithstanding clause. I don't think it's a matter to do with Bill 21, so I'd like him to stick to the matter at hand. The Honourable Member for Lac-Saint-Jean. Yes, Mr. Speaker. Could he explain why Bill 21 is not the matter at hand? Because if the government's intervention worked, Bill 21 might be invalidated. Does my colleague realize how crucial it is to today's debate? Success of the federal government's intervention would mean invalidation of Bill 21. Is my colleague willing to explain that to his constituents, that the federal government is trying to invalidate a Quebec bill? I'd like to thank my colleague for his question. I'm not going to respond to hypotheticals. That's not what we're here for. Today's debate is about the use of the notwithstanding clause, how that clause should be interpreted by the Supreme Court. I believe the Attorney General has done his job well, and that he should be able to intervene before the court. The Honourable Member for Côte-Nord, Kawashikamash Natasanan. Thank you, Mr. Speaker. It is my true pleasure to rise today on this Opposition Day, because when you get into politics, it is because you want to defend certain values. We want to defend our constituents, and as a proud Bloc Québécois MP, I want to defend Quebec. And that is what we are talking about today. Crucially, just to go back over the motion, the Bloc is asking the House to call on the government to fully withdraw from the legal challenge of Quebec's Act respecting the laicity of the state before the Supreme Court. Also, call on the government to withdraw its factum filed on September 17, 2025 with the Supreme Court, contesting Quebec's right to invoke the notwithstanding clause, and denounce the government's willingness to use the Supreme Court to take constitutional powers away from Quebec and the provinces. Thank you. Mr. Speaker, I forgot to mention that I will be sharing my time with my colleague from Jonquière. I wanted to reread the motion because I have been listening to speeches all morning, and people seem to think that this topic isn't important. It's a mere footnote. Other things should be talked about instead. But we are here discussing the very concept of the Quebec nation, which is currently under attack. Earlier, my colleague said, no, we are not attacking Bill 21 itself. We are only discussing the notwithstanding clause. But no, Quebec itself is under attack. Just to remind my colleague, this is not the first time that Quebec has invoked the notwithstanding clause. We have invoked it on a number of different occasions. I believe roughly 40 times, 41 to be precise. In all these years, no one has challenged the use of the notwithstanding clause. Yet, today, we find ourselves discussing state secularism and the very identity of the Quebec nation. Suddenly, people are asking questions about the legitimacy, validity, and intention behind the use of the notwithstanding clause to protect a bill that was duly adopted by the Quebec National Assembly. This is a full frontal assault. It is an ideological assault. This is the same strategy used by Trudeau Sr., the previous Prime Minister, and the current Prime Minister are using. The government claims that everything is different now, but their agenda is the same. So we are seeing a repetition of Trudeau Sr.'s desires. We are seeing a repetition of Trudeau Jr.'s agenda. Really, nothing has changed under this current government. I spoke just now about identity. The Quebec government has invoked the notwithstanding clause to legislate on language and culture and everything that makes us different from Canada. After all, we are different, we are ourselves, and we want to pass bills that reflect us. as a nation. And yes, identity is at play here, but not just identity. Our very democracy is under discussion today. We are faced with a moralizing federal government looking down on us from on high and deciding what makes sense or does not make sense for Quebec. Quebec, a province that is sovereign and able to pass its own laws on language and culture, like Bill 96 and Bill 21, which has to do with secularism. I don't think Quebec is the only one who should be worried. Certainly, I am here to defend Quebec, but I'm talking about the very notion of democracy. That is what we are standing up for today. There are certain Canadian provinces that are intervening on behalf of Quebec because they too are worried about the sovereignty of their parliamentary assemblies. They see themselves under threat from a Canadian government that thinks it knows what is best for all the provinces. In brief, this goes far beyond secularism. Sure, on paper, this is an attack on Quebec, but in practice, it is an attack on democracy, the workings of the Constitution, and all the provinces. This great fear by the federal government, and I just want to look up how far along I am because I don't want to use up all my time. At any rate, the federal government fears, as expressed through the Attorney General's factum, are leading to some inappropriate behaviors, which we have already called out. The government right now is not directly attacking Bill 21. They're going in through the back door. And I think that's despicable, really. I find it shocking and offensive that Quebec taxpayer dollars are being used against Quebecers. Bill 21 was passed by the Quebec National Assembly, and now I am witnessing Quebec MPs, like my colleague who spoke earlier, and who was not willing to state whether or not he supported Bill 21, stating that his own National Assembly was not legitimate, is not able to pass its own laws. Another MP on the government side said that there are more Liberal Quebec MPs than Bloc Québécois MPs. But that shouldn't have to mean anything. Liberals can also defend Quebec values. If the Liberal Quebec MPs suddenly believe that their National Assembly is illegitimate, then we have a problem here. At this point in the debate, we have already spoken as Quebecers a number of times, but you don't have to be a Quebecer to defend Quebec. Despite this, we can see that the Bloc Québécois is the only party willing to defend Quebec tooth and nail. I wish that my colleagues across the way would speak up. Maybe one day they will defend Quebec, but that is not what I have been witnessing since this debate got started. To conclude, Mr. Speaker, I would like the government to open its eyes a little bit. This government claims to be multicultural, post-national, open-hearted. But that's not what we are seeing. When it comes to the notwithstanding clause and other tools that the provinces can use, we see that the government is being closed-minded. We also see this with the content of what they are doing. The European Union has a similar mechanism that its member states have used. And yet over here, we are seeing the federal government questioning its own constitution before the courts. Other countries have something similar to the notwithstanding clause. Not all of them, but some. The same can be said for Bill 21. There are other countries in the world, like Germany, the Netherlands, and others, have measures limiting religious expression, but the federal government is not saying that they are being anti-democratic, that they will be bringing back summary executions or reinstating slavery. If the Liberal government believes that that's what Bill 21 is, they should say so to the entire world. They should be willing to back up their opinions on Bill 21 and the notwithstanding clause. The Honourable Parliamentary Secretary to the Minister of Agriculture. Thank you, Mr. Speaker. The Bloc is currently arguing that all governments, federal, provincial, and territorial, can invoke the notwithstanding clause under charter limits. If the federal government decided to invoke the notwithstanding clause to limit, for example, gender equality, would my colleague still agree that there should be no limits on this power? The Honourable Member. Mr. Speaker, I find that an amusing question because she is getting it exactly backwards. The notwithstanding clause is there to protect Quebec and the provinces. So her logic doesn't make any sense. She's writing fiction and turning to hypotheticals, but we should leave those to the courts. On our end, we know that there are provincial assemblies that renew every 4 years anyway. So all bills are subject and measures are subject to change. All of this is being discussed. The member's question makes no sense.
Thank you, Mr. Speaker, and I thank my honourable Bloc member for her speech. I apologize, I will not be speaking en français. I am working on that, and one day soon, maybe I'll be able to do that. I noticed in her speech she said this statement, nothing has changed in this current government. I know we hear a lot of talk from the opposite side about this being a so-called new government. I wondered if she'd like to expand on that.
L'honorable député.
The honourable member for Côte-Nord, Kawashikamash Natasanan. Thank you, Mr. Speaker. I would even say I don't understand what this new government's priorities are. It looks like they're just recycling their old priorities. We talked about the notwithstanding clause back in 2023. Nothing new under the sun, apparently. Maybe they have something new, but I haven't seen it. Time will tell. And the Bloc Québécois will be there to hold the government accountable.
Questions and comments. Questions and comments. The honourable député de.
The honourable member for Shefford. Thank you, Mr. Speaker. I would like to thank my colleague for her speech. She noted that the notwithstanding clause was already discussed back in the days of Mr. Lametti. I have some numbers for you. Since 2016, 41 bills passed by the Quebec National Assembly, including 11 that are still in effect, have been passed with the notwithstanding clause, yet no one is going after freedom of the press or trying to bring back executions. Can my colleague talk about these various bills passed legitimately by the Quebec National Assembly? Thank you, Mr. Speaker. I would like to thank my colleague from Shefford for that question. It really highlights the paternalistic, arrogant, scornful attitude that the federal government has towards Quebec. Like my colleague said, Quebec passed 41 bills using the notwithstanding clause. These laws have been progressive. They have improved the lives of Quebecers. Again, the federal government is showing scorn and arrogance, and this is an assault on the Quebec nation. We have time for a very short question with a very short answer. I'm thinking 15 or 20 seconds. The Honourable Member for Pontiac. My colleague still hasn't answered my question. Would she agree with a federal government using the notwithstanding clause to limit women's rights with no legal review or no restraints? The Honourable Member. I already answered that question. I wonder if my colleague will say whether she is willing to defend Quebec and whether she is supportive of Bill 21, which was legitimately passed by the Quebec National Assembly. She, as a Quebec member, seems to be saying that Quebec does not have the ability to pass its own laws.
Déclaration des députés. The Honourable Member for Scarborough Centre, Don Valley East.
Thank you, Mr. Speaker. Mr. Speaker, yesterday, Canada took an important and historic step, formally recognizing the sovereign state of Palestine. I would like to thank the Prime Minister, the Minister of Foreign Affairs, and the millions of Canadians who told their government how important this is to them. All people have the right of self-determination, and Palestine deserves to take its place among the nations of the world. This is an important advancement of Canada's long-standing support for a two-state solution, where a free and democratic Palestine lives alongside a free and democratic Israel in peace and security. We must not lose sight of the genocide happening in Gaza and illegal occupation of West Bank. There must be a ceasefire. Humanitarian aid must reach those in need. Hostages and prisoners must be freed. There must be two-way arms embargo. All those responsible for war crimes, including genocide, must...
The Honourable Member for Prince Albert.
Mr. Speaker, the riding of Prince Albert and the people of Saskatchewan have an esteemed agricultural history. Our farmers are proud exporters who help feed the world and improve food security for all. Unfortunately, the punitive actions taken by the Chinese Communist Party has unfairly targeted Canadian canola. And in response to this unjust unilateral behavior, the Prime Minister sent a parliamentary secretary to Beijing. When the Conservative Party was in government, we sent the Minister of Agriculture because we recognize the importance of the canola industry to the Canadian economy. This Liberal government, Mr. Speaker, fails to properly understand the significant negative impacts of this Chinese trade action will have on Saskatchewan, our farmers, and the Canadian economy. It is about time that our Prime Minister recognizes the challenge at hand and shows Canada that our farmers and our jobs are worth fighting for. Mr. Speaker, will the Prime Minister show the resolve needed to defend our farmers and work to end the stalemate in Beijing? Or will he just continue to roll over to China and sacrifice Western Canadian farmers?
Well done. The Honourable Member for Brampton South.
Mr. Speaker, September marks Ovarian Cancer Awareness Month. Ovarian cancer often goes undetected until late stages. Our government takes women's health seriously. In the last election, we committed to stronger data collection and advanced research, including the use of artificial intelligence to close long-standing gaps in women's and seniors' health care. Better data means better outcomes. In Brampton, many are leading by examples, from the Canadian Cancer Society's Run for the Cure to the Lavender Fire Truck campaign in Brampton. I also recognize local organizations like Cancer Warriors and Walnut Foundation and others for their dedication for raising awareness for cancer. Mr. Speaker, I urge all Canadians to prioritize early screening. Early detection can save lives, and it gives families the best chance for successful treatment. Thank you, Mr. Speaker.
The Honourable Member for Oshawa.
Mr. Speaker, I rise today with pride on behalf of Oshawa to celebrate a landmark moment for our community. The relocation of the Firewolves franchise to Oshawa is about more than a National Lacrosse League team. It's about investing in youth, local culture, and our city's economic future. And while many assume hockey is Canada's national sport, sorry hockey fans, lacrosse fans know the truth. Lacrosse is actually our national sport. Oshawa's lacrosse roots run deep from the legendary Green Gaels and their 7 straight Minto Cups to today's Firewolves calling the Tribute Community Centre home. Starting in the 2025-26 season, we'll see new jobs, more tourism, and inspiration for young players. Mr. Speaker, I invite all colleagues to join me in congratulating the Oshawa Firewolves, their players, staff, and fans as we begin this exciting new chapter.
Here, here. The honourable member for Winnipeg Centre. Please, there's a bit of confusion. It's okay. There's been a change on the order. There was something missing, and the order remains the same, but we're going to go back to the member for Winnipeg Centre.
Mr. Speaker, too often governments choose expediency over principle, chasing short-term wins instead of building a just, sustainable future. People and the planet pay the price. Like in Canada, wrecking Palestine as a state, but refusing to use its power to stop this genocide, or even allow the entrance of Palestinian Canadians back into the country. They are human beings. They matter. I remember when my grandmother, a Holocaust survivor, finally let us open the family photo albums. My grandfather had forbidden it. The pain was too great. Page after page, I saw children, cousins, nieces, nephews, whose lives were stolen. I grew up without a family because of genocide, Mr. Speaker. Today, I think of Palestinian families facing this devastation, children robbed of futures, parents and grandparents, lonely. Recognition is not enough. We must act now.
The honourable member for Madawaska-Restigouche. Mr. Speaker, I often say my riding of Madawaska-Restigouche is brimming with talent, and today I'd like to draw attention to an exceptional young woman, Mikencia Charlie Francois, a teenager of Haitian origin who now lives in Edmundston, where she's attending high school at Cité des Jeunes à Sormagny. Last July, she published her very first book entitled The Canadian Summer Through My Eyes. In this touching work, she shares her experience of her very first summer in Canada as a newcomer. With sensitivity and authenticity, she recounts the moments of joy, the moments of doubt, and the emotions that marked her journey. In addition to being a promising author with a mastery of our beautiful French language, Carly is actively involved in her community. She generously gives her time to several community events, acts as an ambassador for Francophone youth at various levels, and actively contributes to the local music, poetry, and literary scene. Congratulations, Carly. You're a true source of pride for our region.
Centre. Mr. Speaker, our Constitution is the highest law in Canada. Every other law must conform to it. The Charter of Rights and Freedoms is a cornerstone of our Constitution, and the notwithstanding clause is central to it, a deliberate and essential part of the 1982 compromise that made the Charter possible. It reflects the will of Canadians to allow elected legislatures, not courts alone, to make final decisions in exceptional cases. Yet this government is asking the court to rewrite our Constitution. This is a reckless overreach with grave consequences, or perhaps a calculated distraction. Distraction from what? Real challenges facing Canadians: high inflation, escalating debt, ever-increasing crime, economic and trade uncertainty. Instead of addressing these mounting issues, the Prime Minister is wedging Canadians and creating an aimless diversion. Canadians deserve solutions, not more distractions.
The honourable member for Compton-Stanstead. Thank you, Mr. Speaker. On this occasion of Gender Equality Week, I want to highlight the key and often invisible role of women in agriculture. For generations, women have played key roles on farms, be it in the field, barn, or office, and their work has remained in the shadows without formal recognition. They run agricultural businesses, are active on associations and institutions, and I salute the exceptional work of Women Farmers of Quebec, which supports, trains, and promotes women in all spheres of agriculture. It's also with sadness that I note the recent tragic passing of its president, Valérie Fortier. Her passion, leadership, and commitment left their mark on the entire agricultural community. My deepest thoughts are with her 3 children, her father, and her partner, and all the women farmers in Quebec. I pay tribute to her memory and to the resilience of women farmers here and all those who continue her fight. Thanks to them, the future of agriculture is stronger, more inclusive, and more equitable. Thank you, Mr. Speaker.
The honourable member for Selkirk, Interlake, Eastman.
Mr. Speaker, today is Army Day on the Hill, when we celebrate and honour the brave women and men in our Canadian Army. Their dedication and sacrifice for Canada is unquestionable. I want to recognize the over 2,000 members currently serving in the Canadian-led multinational brigade group in Latvia, as well as our troops training Ukrainian soldiers under Operation Unifier, and those contributing to the NATO deterrence mission in Europe against Russian aggression under Operation Reassurance. And this summer, we saw our soldiers deployed to assist wildfire efforts in Manitoba and across Canada as part of Operation Lennis. Our troops cannot do all of this without the support of our military families, who are the backbone of our members as they endure long deployments away from home. Conservatives will always support our women and men in uniform and will continue to press for them to get all the kit they need to carry out the important missions we ask of them. Thank you to all our Army heroes for your amazing service, and a shout out to all those who are joining us on Parliament Hill today.
The honourable member for Pierre Boucher, Les Patriotes Verchères. Mr. Speaker, municipal elections are underway in Quebec. On November 2nd, Quebecers will go to the polls in over 1,000 municipalities. It will be an evening of high hopes for all the candidates, but it will also mark the end of an era for our elected officials who've chosen not to run for re-election. On behalf of the Bloc, I'd like to thank all the mayors and councillors who've served the public during the last term. You've taken on a role that is often difficult, sometimes rewarding, but always essential, with heart and determination. I'd also like to wish the best of luck to all those who have the courage to put their face on a sign and run for office. Quebecers will make their choice, but there are only winners when thousands of people offer to dedicate their energy and intellect to the well-being of their fellow Quebecers. Finally, Quebecers, get out and vote on November 2nd. The future is in your hands. The honourable member for Dorval, Lachine, LaSalle. Mr. Speaker, today 52 students and 3 teachers from Collège Sainte-Anne in Lachine visited Parliament. Founded in 1861 by the Sisters of Sainte-Anne, this institution is one of the oldest schools in Quebec. For nearly 165 years, it has educated students who have contributed, among many other things, innovation, entrepreneurship, and remarkable scientific achievements that have had an impact not only in Quebec and Canada, but all around the world. The teachers at Sainte-Anne teach with dedication and energy, preparing students with the knowledge and skills they'll need to succeed in their chosen careers. I'm delighted to welcome them here so that they can observe democracy in action up close. Perhaps among these students are tomorrow's members of Parliament. Whatever paths they choose, I wish them every success and happiness in life.
The honourable member for Flamborough, Glanbrook, Brant North.
Mr. Speaker, the Prime Minister promised the fastest growing economy in the G7. Instead, we have the fastest shrinking, with higher unemployment, record household debt, and the most expensive housing. Another Liberal broken promise. Wow. He told Canadians to judge him by grocery prices. Well, they're rising even faster today. Another Liberal broken promise. He promised to build, baby, build. Instead, it's block, baby, block. Housing starts are projected to drop 13%, another Liberal broken promise. He promised elbows up tariffs against the U.S., then remove them without a deal, another Liberal broken promise. He promised to spend less and invest more. While spending is way up, the deficit is doubling, and $63 billion in investment has fled Canada, another Liberal broken promise. Broken promises, Mr. Speaker. That's all this Prime Minister has delivered.
Way to go, Dan!
The honourable member for Mississauga, Erin Mills.
Mr. Speaker, cricket has come to Ottawa. Today we're joined by Canadians representing over 300,000 women and men that play cricket across our country and millions that watch and cheer the sport. Today is the third annual cricket match between Canadian parliamentarians and the Commonwealth diplomats, where we square off and we pitch for peace. Today is more than about just sports. It's about building friendships across the world, celebrating cricket's growth here in Canada. For many MPs and senators and diplomats, today will be their first time playing cricket, but it will not be their last. I want to thank all the representatives of cricket who have joined us from coast to coast to coast, and thank you, Hassan Mirza, President of the Canadian College Cricket, for his leadership in helping put this together. Mr. Speaker, Canada needs to invest in our young cricketers representing us all over the world, and we're hopeful that we can continue to pitch for peace to build a stronger nation. Thank you.
The honourable member for Hastings, Lennox and Addington, Tyendinaga.
The Prime Minister claims to be pro-resource development, but mere months ago he was praising the authoritarian government in Beijing for understanding, quote, engineering solutions to issues around emissions, end quote, and their willingness to, quote, engage in the global commons in and around the climate, end quote. He happily gives the ambitious leadership of the Chinese Communist Party this high praise while they were doing the exact opposite of responsible environmental stewardship, constructing several new coal power plants. But, as we are increasingly seeing with this Prime Minister, he prefers platitudes over planning and progress. Coupled with his personal connections to Brookfield, securing a $250 million loan to the Chinese state-owned bank, Canadians are increasingly realizing that this Prime Minister is not only a walking conflict of interest, he is an anti-energy leader in Canada, and his behaviour proves it.
Way to go, Shelby!
The honourable member for Beauport-Limoilou. Thank you, Mr. Speaker. I had the privilege this summer of meeting with the Ukrainian Alliance of Quebec, an organization that plays a vital role for its members and our entire community. The meeting was a chance to hear about their realities, needs, and aspirations, but above all, to see once again the strength and resilience of the Ukrainian community here. As the member for Beauport-Limoilou, I strongly believe Canada has a moral and political responsibility to support the Ukrainian people, both on the international stage and right here in our communities. My government has already taken concrete steps to welcome displaced families, strengthen cultural partnerships, and provide ongoing humanitarian and military aid. But beyond official gestures, it's human connections and local initiatives like the activities of the Alliance that give real meaning to our solidarity. I'd like to reaffirm that I will be an ally in this cause, as will our government.
The honourable member for North Island, Powell River.
Well, Mr. Speaker, it looks like the Minister of Public Safety accidentally told the truth. Yesterday, we learned in leaked audio that the minister privately acknowledged what Conservatives have been saying publicly for years, that their attacks on law-abiding firearm owners and their gun confiscation scheme is politically motivated, will do nothing for public safety, is completely unenforceable, and is a giant waste of nearly $1 billion of taxpayer money. This at a time when violent crime has surged, and gun crime in particular, under this Liberal government, is up 130%. Wow. Now, we already know that the minister doesn't know what an RPAL is, that he doesn't know his own government decriminalized hard drugs in BC. How many more failures, scandals, and embarrassing moments does one man need to have before Canadians get a new Minister of Public Safety?
The honourable member for Bay of Quinte.
Mr. Speaker, this summer, an extraordinary business in my riding of Bay of Quinte achieved a fantastic milestone. Sprague Foods hit 100 years of operation. Founded in 1925 as a seasonal cannery in Prince Edward County, the company has grown through 5 generations into the only remaining cannery in the region. From preserving local vegetables and producing soups now found on shelves across Canada, Sprague Foods has stayed true to simple, natural ingredients while adapting to changing markets. In a time when buying Canadian-made products is more important than ever, Sprague Foods is a key partner in supporting our local economy with good jobs and food security. So on behalf of myself and this entire House, congratulations to Sprague Foods on the past century and cheers to 100 more. And Mr. Speaker, I would also like to acknowledge the Canadian Armed Forces we have here today for Army Appreciation Day. Thank you for all your service.
Oral questions. Questions, questions orales. The Honourable Leader of the Opposition.
Mr. Speaker, I must admit that I've never seen this before. On Monday, a minister said that his own program would not work. He was caught on recording saying that. Then on Tuesday, he announced that he would go forward with the program. He was right on Monday. It's a waste of $750 million, which will be taken away from our border and police services. It will be used to go after hunters and sports shooters. Will the Prime Minister sack this minister?
The Honourable Minister of Public Safety.
Merci pour la question.
Thank you for the question.
Let me just take this opportunity to talk about the compensation program that we launched today. The pilot will take place in Cape Breton. There are roughly, yes, I want to thank the colleagues from Cape Breton for their support, but I also want to thank the police chief, as well as those who are going to step forward and apply for the rebate, Mr. Speaker. This is smart policy. We're moving forward on it, and I fully believe that we will be able to implement this throughout the country over the next year.
The Honourable Leader of the Opposition.
But he said the exact opposite in the recording, Mr. Speaker. He admitted that confiscating $750 million worth of our arms will not work. And he even made a promise to his renter. He promised to hire 1,000 border agents. Meanwhile, 400% of firearm crimes are from firearms that come up from the border. He lost 600 dangerous criminals somewhere on our streets, and he doesn't even know how to define a firearm or what's a dangerous firearm. So he's not capable of doing his job. Will the Prime Minister sack him?
Mr. Speaker, public safety are not binary choices. You could do both, Mr. Speaker. We can ensure that guns are off our streets by ensuring that people who are able to turn in their firearms are able to get compensated for those prohibited weapons. That is what we're doing with the launch of our gun buyback program today. We will continue to make smart criminal justice reforms to ensure that criminals are off our streets and bail is tougher for repeat violent offenders, Mr. Speaker.
The Honourable Leader of the Opposition.
Well, I have to admit, Mr. Speaker, in all my years here, I've not seen this before. On Monday, a minister says that his program won't work. On Tuesday, he says he's going ahead with the program, a program that will take $750 million away from frontline border and police services to go after Grandpa Joe's hunting rifle, a waste of money that police say they won't implement and that the minister was caught on recording saying they will never implement. He even promised to bail his tenant out of jail if he breaks the law. When will the Prime Minister fire this minister?
The Honourable Minister of Public Safety.
Mr. Speaker, let's be clear. If Grandpa Joe is using AR-15s to go hunting, I think we have to have a much more serious conversation about hunting. What we're going forward, Mr. Speaker, are 2,500 prohibited weapons, AR-15s that are killing people around the world, including those in mass casualty incidents in Canada, Mr. Speaker. If the Leader of the Opposition wants to have a real conversation about crime, he also has to have a real conversation about guns, Mr. Speaker.
The Honourable Leader of the Opposition.
Mr. Speaker, that minister did have a real conversation about guns. He was caught on tape admitting that his program won't work because it will go after legitimate hunters and sport shooters rather than after the 80% of guns that are used in crime which come illegally across the border. He admits that his $750 million program won't work. He offered to bail his tenant out of jail if he breaks the rules. He lost track of 6,000 foreign criminals in our country. He admits he doesn't know what a gun license is. More than half of Canadians don't feel safe under his watch. Will the Prime Minister do the only thing that will secure our country and fire this incompetent minister?
The Honourable Minister of Public Safety.
Mr. Speaker, you can't be serious about public safety if you're not serious about gun crime. My honourable colleague on the other side of the House raises concerns about the illegal flow of guns across the border. When he was in government, he made cuts that made it easier for illegal guns to come across the border. Mr. Speaker, we're going to be adding 1,000 officers at the border. He also has campaigned on a commitment to legalize assault-style weapons and claims they're used for hunting. There are hunters in my community I'd love to introduce him to. They don't shoot deer with AR-15s.
The Honourable Leader of the Opposition.
Mr. Speaker, it seems the Liberal strategy is to say that the public safety minister is not incompetent enough to be fired because they have, by comparison, an even more incompetent Minister of Justice. I guess everything is relative, Mr. Speaker. And I'm glad that to prove his incompetence, I'm glad he brought up the issue of border security, because we asked the government in an order paper question last week whether they'd keep their promise on 1,000 new border guards. They got back saying not only have they not hired the 1,000 more, they have no plans to do so. More incompetence from this public safety minister. When will the Prime Minister fire him?
The Honourable Minister of Justice.
Mr. Speaker, with respect to the commitment to hire 1,000 officers at the border, I would point my honourable colleague opposite to the election campaign platform that Canadians across the country, including of the riding of Carleton, supported to make sure that we would defend our border against the flow of illegal guns and drugs into Canada. Mr. Speaker, for years I have watched Conservatives brush away gun crime as something that's completely unserious, pretending that it's only law-abiding people who shoot guns in this country. The fact is there are criminals who shot innocent people. We are going to do something about it.
The Honourable Leader of the Opposition.
Mr. Speaker, it is incredible. Only that minister who ruined the immigration system, that ruined the housing market, could simultaneously repeat a promise while breaking it.
Right.
It was last week that the Liberal promise of another, yes, that's right, a Liberal promise is a prop.
The Honourable Member knows that he can't use props. Yeah. Okay, the Honourable Member has 15 seconds left, so we'll start the clock again.
Mr. Speaker, it was just last week that the minister's own department revealed that they are breaking their promise on 1,000 new border guards. They say they are not only have they not hired the 1,000, but they haven't even developed the plan to do so. That is the responsibility of the public safety minister. He's broken the promise. Will he be fired?
The Honourable Minister of Public Safety.
Mr. Speaker, on April the 28th, Canadians gave this government a mandate to do many things, including hiring a new 1,000 CBSA and 1,000 RCMP officers. I'm sorry, Mr. Speaker. It's obvious that the Leader of the Opposition doesn't understand the hiring process, nor the plan and the work that goes into hiring these 1,000 exceptional men and women who are going to serve this country. I want to take this opportunity, Mr. Speaker, to welcome the Leader back into the House, but also ask him, maybe this is time for him to take his security clearances so he can actually do his job properly.
The Honourable Member for Saint-Jean. Mr. Speaker, The Liberals' involvement in the legal challenge to Bill 21 is a constitutional power grab. That's clear from their speeches today. What we are hearing today is that what they're upset about goes beyond secularism. Their concern is that Quebec could use the notwithstanding clause to pass laws that Ottawa disagrees with. So they want to weaken the clause, which is Quebec's only tool to avoid being subordinated to Ottawa and to its courts. They want to turn Ottawa into a superior government and Quebec into an inferior government. Will the Liberals withdraw from the challenge and put an end to this constitutional power grab? The Honourable Minister of Justice. Mr. Speaker, this shouldn't come as a surprise. We've had the same stance for several years now. When there are cases at the Supreme Court of Canada, we participate. As the member knows full well, the case is at the Supreme Court of Canada. When a case makes it to the Supreme Court of Canada, the government weighs in. The Honourable Member for Saint-Jean. Mr. Speaker, the Liberals are doing more than just challenging Bill 21. They want to ensure that they have a say in all of Quebec's laws. What their factum suggests is that Quebecers do not have a good enough judgment to be allowed to pass our own laws without supervision from Ottawa. And to prove their point, they rely on completely apocalyptic examples, such as the possibility that Quebec could use the notwithstanding clause to legalize slavery or arbitrary executions. Mr. Speaker, exaggeration is the argument people make when they have no other argument. Since their factum doesn't contain any real arguments, why don't they withdraw it? The Honourable Minister of Identity and Canadian Culture. Mr. Speaker, my colleague talks about exaggeration. Well, she's the one exaggerating. She's laying it on pretty thick. And the answer to her question, well, she already answered it. Courts cannot change the Constitution. We're not weighing in to guarantee that the courts can change the Constitution. As we said yesterday, the only body that can change the Constitution is the Parliament. We are weighing in to protect the Canadian Charter of Rights and Freedoms. The Honourable Member for Jonquière. Mr. Speaker, if the Liberals want to amend the Constitution and Section 33 on the notwithstanding clause, then let them launch a round of constitutional negotiations. Let them reopen the Constitution if they want to change the rules. Let them treat Quebec and the provinces as equal partners in a public debate rather than going through the courts. Let the Liberals respect their own federation and behave democratically, Mr. Speaker. Will the Liberals withdraw their insulting factum? It insults Quebecers. And will they withdraw from the challenge to Bill 21? The Honourable Minister of Justice. Mr. Speaker, quite the contrary. We do not want to change the Constitution. We want an opportunity for the court to clarify the Constitution. Now, the case has made it before the Supreme Court, and the Supreme Court is the appropriate forum for making arguments, not here in the House of Commons.
Mr. Speaker, gun crime is up 130% under this Liberal government. And what's their answer? Targeting law-abiding hunters and sports shooters. This minister was caught on leaked audio accidentally telling the truth about the Liberal gun buyback scheme. He admitted it's not worth the money, that it will go over budget, that it's politically motivated, all for optics, but worst of all, that it's not even going to work. Yet this Prime Minister is telling the minister full steam ahead. He's actively trying to sell a program that he admits will waste $750 million and not improve public safety. Why won't the Prime Minister just fire this minister?
The Honourable Secretary of State. Mr. Speaker, I'd like to start by setting the record straight. The program, which was announced at noon today, will buy back assault weapons. This will not affect hunters. I repeat, this will not affect hunters. All reasonable hunters do not need to use assault-style weapons, which will be bought back. That's what we announced today. All Canadians are looking forward to this program. We've been talking about this since 1999, since the terrible feminicide. The needs are the same today, and we're going to get this done. Thank you.
Mr. Speaker, it was the public safety minister who set the record straight when he was caught on tape saying that this program won't do a thing for public safety. They're not taking guns away from criminals, they're letting criminals out on the street. And now they're diverting $750 million that could actually go to things that would protect Canadians. That's money being diverted away from the border where illegal guns and drugs could be stopped. It's $750 million that's not going to new border agents to deport foreign criminals. Mr. Speaker, why won't this Prime Minister just do the right thing and fire this incompetent public safety minister?
The Honourable Secretary of State. Thank you, Mr. Speaker.
Will understand a bit more. That program is to remove in the hands of Canadians firearms that are designed to kill people, not for hunting. And it is not a waste of money because Canadian wants those firearms out of the street. They voted for us. We said we will do that. We will do that.
The honourable member for Leeds, Grenville, Thousand Islands, Rideau Lakes.
In a leaked audio recording, the Liberal Public Safety Minister said that their gun buyback program won't keep Canadians safe and that it's a waste of money. Well, we agree on both counts, but he's pressing ahead. And he launched an assault on licensed law-abiding gun owners today. But gun crime is up 130% under these Liberals, that Liberal minister and that Prime Minister. The minister's job is to keep Canadians safe, and he's saying himself that this $750 million program won't do that. Will the Prime Minister fire his minister?
The Honourable Minister of Public Safety.
Thank you, Mr. Speaker. This opportunity, I appreciate the opportunity to be able to clarify what we're doing, Mr. Speaker. First and foremost, whatever the member opposite said is factually incorrect. I support this policy, Mr. Speaker. That's why I brought this forward today at 12:30 this afternoon. I, along with several of my colleagues here, as well as Police Chief of Cape Breton, as well as the Deputy Commissioner of the RCMP, announced the compensation program as a pilot first in Nova Scotia, and we will be expanding it across Canada, Mr. Speaker. I invite the party opposite to get on board and to ensure that guns are off our streets.
The Honourable Member for Lethbridge. Oh, sorry, my mistake. Leeds, Grenville, Thousand Islands, Rideau Lakes.
Well, Mr. Speaker, you'll have to accept my apologies if I don't take the Public Safety Minister at his word today, if instead we take him at his word from Monday when he said that the program was a waste of money, it wasn't going to keep Canadians safe, and if it's such a good idea and it's not going to target people who are not breaking the law, why was he offering to bail his buddy out of jail? How could his friend be targeted unless, of course, this was going to target licensed, law-abiding firearms owners? The OPP have said no, they won't participate. A Crown Corporation Canada Post won't participate. It's $750 million that could hire cops to keep Canadians safe. That's not what they're focused on. Will the PM fire the minister?
The Honourable Minister of Public Safety.
Mr. Speaker, this afternoon we were able to launch the assault-style firearms compensation program. It starts first off in Cape Breton, Nova Scotia, with a pilot. It'll last for 5 to 7 weeks, Mr. Speaker. From there, we will expand it across Canada. This is what Canadians voted for on April the 28th. They gave us a mandate to implement this program, Mr. Speaker, and we will be implementing this program. We will ensure that those prohibited weapons, including AR-15s, are off our streets, Mr. Speaker.
Honourable Member for Lethbridge.
Well, Mr. Speaker, the reality is that after releasing violent offenders and targeting law-abiding citizens of this country, such as sports shooters or hunters, gun crime has actually surged by 130% under this Liberal government. The Public Safety Minister admits that it's simply a gun grab rather than accomplishing anything good for Canadians. He has confessed that he doesn't know what an RPEL is, and he has sponsored a bill that undermines civil liberties. He is mired in conflict of interest concerns, so would the Prime Minister finally do the right thing and fire this incompetent minister?
The Honourable Secretary of State for Rural Development.
Thank you very much, Mr. Speaker. My colleague spoke in French, and then she spoke
in English, and the Tories still didn't get it, so I will speak slow, Mr. Speaker. This is not about hunting. This is not about infringing upon people that are out there legally hunting, Mr. Speaker. And I got a lot of people from rural Saskatchewan and northern Saskatchewan that enjoy hunting. This is not about hunting. It is about stopping the violence, stopping the AK-47s from crossing our border, and keeping...
L'honorable député de Bellechasse.
The Honourable Member for Bellechasse, Les Etchemins, Lévis. The Minister of Public Safety was caught in leaked audio admitting in a recording that the Liberal gun confiscation program is not worth the $750 million he's about to spend on it. Mr. Speaker, he knows it, we know it. This program will accomplish nothing other than inconveniencing law-abiding Canadians like hunters. The program will not reduce gun crime, which is increased by 130% under these Liberals. Canadians do not trust this minister to implement a policy that he himself acknowledges is ineffective. The only option is for the minister to resign. Will he do so? The Honourable Secretary of State. I thank my colleague for her question in French. You know, and she knows as well, that the tragedy at Polytechnique set things in motion in Canada so that we could remove assault weapons from our streets in Canada and in Quebec. It's incredibly important. Now, we have a gun registry with different types of guns. What we're doing today through our program will not affect hunters who are using reasonable hunting weapons. This will only prevent weapons which can kill people. The Honourable Member. Here's the situation, Mr. Speaker. The Liberals have increased gun crime by 130%. That's a fact. The Minister of Public Safety admitted that the Liberal gun confiscation program is political. That's a fact. He also admitted that it will be ineffective. So the government is heading for disaster with this gun program. It won't make our streets safer. Will the Prime Minister demand the minister's resignation? The Honourable Secretary of State for Nature. Mr. Speaker, 35 years ago, I was in a hospital bed and I did not understand what was going on. I did not understand that something like that could happen to me in Canada. I was at the first press conference with fellow students. We all called for the removal of assault-style weapons from our streets. I will continue to advocate for that and fight for that. What's most important is to do what Canadians want and what Canadians voted for. Mr. Speaker, we will go all the way. We will go forward with our program, and hunters will be able to continue to hunt. The Honourable Member for Rivière-du-Nord. Mr. Speaker, the Liberals' challenge to Bill 21 is about so much more than state secularism. In the Liberals' factum, what they're saying is, we've seen where Quebecers are headed with their secularism. At this point, who knows? They might even be capable of closing churches or shutting down newspapers if Ottawa didn't stop them. The Liberals want to weaken the notwithstanding clause so that the federal government and, of course, federally appointed judges have the final say on every law Quebec passes. In Quebec, that's what we would call guardianship. In Canada, what exactly would it be called? Maybe the minister can tell us. The Honourable Minister of Identity and Canadian Culture. Mr. Speaker, what my colleague said is false. Our intervention, our factum to the Supreme Court is to defend rights and freedoms. We are the Charter Party. We have always and will always defend the CCRF. Now, someone recently announced that they would use in one province the notwithstanding clause 3 times. 3 times. We want courts to be able to tell citizens of provinces, your rights are being violated. That's what we want to be able to still be the case. The Honourable Member for Rivière-du-Nord. This is not defending the Charter. Mr. Speaker, the Liberals want Bill 21 on state secularism to be reversed. That is crystal clear. But they want more than that. They want the final say. They want to ensure that they and their appointed judges have the final say. They want to decide everything for everyone in their Liberal Canada. This is unacceptable for Quebecers, and sometimes I wonder what we're still doing here. The Honourable Minister of Identity and Canadian Culture. Mr. Speaker, I'd like to remind my colleague that during the last federal election, Quebecers elected 2 times more Liberals than Bloc Québécois members. 2 times more. And why did Quebecers do so? They know that we're here for them, that we stand up for their rights, and that we work well with provinces and territories. Just last week, I met with 2 representatives of the Government of Quebec to announce a project for 20 million housing units, 10 million at market price. Mr. Speaker, we can work with provinces and territories, all while defending the Canadian Charter of Rights and Freedoms.
The public safety minister's #1 job is to keep Canadians safe. Instead, he's blowing taxpayer dollars on a gun buyback program he knows will fail. The Toronto Police Association has slammed it as useless, and they're right. Almost every gun used in Toronto crime last year was smuggled, the overwhelming majority from the U.S. Yet this minister is attacking law-abiding Canadians knowing full well his program will not work. The minister has failed to do his job. Will the Prime Minister fire this incompetent minister?
That's a good question. L'honorable ministre.
The Honourable Public Safety Minister.
Against getting our guns off our streets. I'm puzzled why AR-15s are required for hunting. I'm not a hunter, Mr. Speaker, but I've spoken to many hunters, and many of those will say that AR-15s do not belong on our streets, in our communities. That's what we're doing here today, Mr. Speaker, with the plan that we launched today in Cape Breton and will be spread across Canada. We are getting serious guns off our streets, and we'll make sure our communities are safer.
The Honourable Member for Brantford, Brant South, Six Nations.
Mr. Speaker, the truth came out a few days ago. He knows the gun grab will fail. He was caught on tape admitting it will blow the budget and that it'd be better to lock up criminals committing the crimes. Sorry, Minister, your words were not misguided. They were the truth. But today he's blindly plowing ahead, not to protect Canadians, but because the Prime Minister wants a political stunt. If he knows it'll fail, admits it'll waste millions, and says it's all about politics, why is he still in charge of public safety?
That's a good question. The Honourable Minister of Public Safety.
Mr. Speaker, I recognize the member opposite is a lawyer, and I know he knows what defamation is, and I invite him to say the exact same words outside in the House, Mr. Speaker. What I will say, Mr. Speaker, is that the program that we launched today is one that will make our community safer. It will ensure that guns such as...
I couldn't hear it now. I'm trying my best, but it's very hard sometimes. So if the Honourable Minister could start from the top, because I really didn't catch anything he was saying.
Mr. Speaker, I realize that the member opposite who just asked that question is a lawyer, and I know that he knows defamation law, and I invite him to say those exact same words outside of the House, Mr. Speaker. What I will say is we have launched a program today that will ensure the safety and security of Canadians. We will compensate those who are willing to bring forward their prohibited weapons and collect remuneration for that, Mr. Speaker. We will ensure that we have greater bail reform laws, Mr. Speaker, that will keep serious violent criminals off our streets. We could do both.
The Honourable Member for Bowmanville, Oshawa North.
Mr. Speaker, gun crime is up 130%, and Toronto police report that 88% of the illegal guns they seize have been smuggled north across our southern border. The Liberal Public Safety Minister does nothing to keep our communities in the Toronto area safe. Instead, he focuses on banning legal hunting rifles in rural Canada.
Hear, hear.
When will the Prime Minister take action and actually hold this minister accountable and fire him? He's done nothing to keep Toronto safe, and that is his job.
The Honourable Secretary of State for Combating Crime.
Mr. Speaker, this government has put historic investments into our borders to be able to keep illegal guns off our streets and Canadians safe. We're going to continue to bring further legislation that will tighten our sentencing and bail system. But, Mr. Speaker, mass shootings are a crime. And we have several examples of mass shootings that have taken place in Canada and the United States. We should learn that lesson and get these assault-style rifles off our streets.
The Honourable Member for Charlesbourg, Haut-Saint-Charles. Mr. Speaker, with this Minister of Public Safety, it's failure after failure. A significant rise in firearms crimes, and he has been caught talking about how worried he is about the gun buyback program. And now he's leaving African mafioso groups enter our country. When will the Prime Minister make this minister resign? The Honourable Parliamentary Secretary. Mr. Speaker, sorry. It's important for us to finish this action. Canadians expect this of us. It's important for us to respect the commitments we've made, and this program will allow us to do this. And I think that all Quebecers, all Canadians expect this of us. It's not the only thing we have to do to fight crime, but it is part of the set of measures that we are going to take to do so. Thank you. The Honourable Member for Charlesbourg, Haut-Saint-Charles. And with all due respect, my question is for the Minister of Public Safety. He doesn't need the Secretary of State to respond. If we're talking about borders, we're talking about crimes and African mafia groups. Will this minister... Well, this is a major issue for Canada, and we need to control African mafia groups. Will the Prime Minister fire his Minister of Public Safety?
Thank you, Mr. Speaker. And I do want to caution this member that he is really treading lightly in the language he's using, describing a particular group that he's concerned about, Mr. Speaker. It is borderline racism, and I do caution him to take note of his language. But let me be very clear, Mr. Speaker, and we're investing in our border. We are bringing forward. We have already invested $1.3 billion in securing our border, Mr. Speaker. We are hiring 1,000 new RCMP officers, and we're also hiring 1,000 new CBSA officers, Mr. Speaker. We will ensure that our borders are safe and secure.
The honourable member for Guelph.
Mr. Speaker, even with Canada's success in negotiating new trade deals around the world, efforts to secure a new agreement with the U.S., and launching major projects, these unjustified U.S. tariffs on steel, aluminum, and autos are hurting businesses of all sizes, including manufacturing and food in my riding of Guelph. Will the minister responsible for FedDev please outline which new programs are available to support them in these difficult times and how to access them?
The Honourable Minister for Artificial Intelligence and Digital Innovation.
Mr. Speaker, I want to thank my honourable colleague from Guelph for her important question and the tireless work on behalf of her constituents and local businesses. Southern Ontario, as we all know, has been among the hardest hit by tariffs, home to the steel and auto industries and industries that employ more than 8 million workers. This summer, I spoke with businesses like Laval Tools in Windsor and organizations like the Niagara Economic Development Corporation, who told us how much they value FedDev's work and their investment in innovation and creating new jobs. That's why our Regional Tariff Response Initiative is now open, Mr. Speaker, for application, and why our caucus is so...
The Honourable Member for Kamloops, Thompson Nicola.
Mr. Speaker, the Public Safety Minister's #1 job is to keep Canadians safe. And he has failed at that job. In a secret recording, he said, "Don't ask me about the logic." And I agree. I don't see the logic either. Gun crimes are up 130%. Bail across the country is perceived as a joke, and these Liberals in Bill C-5 voted to lower sentences for gun crimes. Everything in this file is a mess. So why doesn't the Prime Minister fire his Public Safety Minister?
The Honourable Minister of Justice.
Mr. Speaker, when it comes to public safety in this country, we agree that there is work to do when it comes to bail reform and to tighten sentencing, which is why we will be introducing legislation that makes the criminal justice system treat serious crime with more serious consequences going forward. But a point of disagreement between the government and the opposition is the role of assault-style weapons in this country. Mr. Speaker, my constituents at home in Nova Scotia and Canadians that I meet in every province believe that it is common sense to take guns that are designed to kill people off our streets. It is remarkable that the Conservatives have a contrary view.
The honourable member for Kamloops, Thompson, Nicola.
He wants a point of disagreement. How about this, Mr. Speaker? House arrest for people who do drive-by shootings, and that minister voted for it. That is a point of disagreement, Mr. Speaker. This minister has one job, and that's to keep us safe. $742 million are going towards a program that he doesn't even believe in. How many RCMP officers could that get us? How many border security officers can that get us? This whole thing is an absolute mess. The question is this: when will the Prime Minister fire him?
The Honourable Secretary of State for Combating Crime.
Mr. Speaker, we take crime, all types of crime, very seriously. And that is why this government's second piece of legislation in this House was C2, to make sure we give our policing organizations the tools they need to crack down on organized crime, on criminals that are running our streets. But we do not need AR-15s in our country, Mr. Speaker. That rifle was designed to kill human beings. So, if I could ask the Conservatives, why are you on the side of crime?
Reminder through the Speaker, through the Chair. The Honourable Member for York Durham.
In the last election, the Prime Minister promised to hire 1,000 new border officers. Now, the Minister of Public Safety in his response today suggested we just don't understand the hiring process. Let me suggest to him that he doesn't understand how promises work. You actually have to keep them. But internal documents from the CBSA last week disclosed to this House that the Minister of Public Safety responsible for hiring border officers has hired precisely 0. His number one job is to keep Canadians safe, and he has failed. When will the Prime Minister hold this minister responsible and fire him?
The Honourable Minister of Public Safety.
Thank you, Mr. Speaker. We made a promise in the last election, Mr. Speaker. On April the 28th, Canadians gave us a mandate, and we're fulfilling that promise this afternoon, Mr. Speaker. We've launched the compensation program where in Cape Breton, as a starting point, we were piloting the ability for individual owners who have prohibited firearms to turn it in to law enforcement, who will collect it, who will inspect it, and who will then advise on the compensation, Mr. Speaker. This will be spread across Canada in the coming weeks, Mr. Speaker. I look forward to the support from the member opposite who's really
the Honourable Member for York Durham.
Mr. Speaker, the minister says he's taking this seriously, but his own response to this House tells a very different story. Not only has he failed to hire a single new border officer, he doesn't even have a plan to hire any. He has failed to keep the government's promise, failed to hire new border officers, failed to stem the flow of illegal guns across the border, and failed to keep Canadians safe, his one and only job. So when will the Prime Minister hold this minister accountable and fire him?
The Honourable Minister of Public Safety.
Mr. Speaker, we look forward to welcoming 1,000 new RCMP and 1,000 new CBSA officers to the ranks of our frontline public service, Mr. Speaker. I was in Regina, Mr. Speaker, speaking to the RCMP training facilities. They're getting prepared to be able to train the 1,000 new RCMP officers we will be onboarding over the next several years, Mr. Speaker. It is important that we continue to invest in law enforcement. That's exactly what this Prime Minister committed to. That's exactly what we'll be doing.
The Honourable Member for Calgary Nose Hill.
Over the summer, it was revealed that the Public Safety Minister lost track of 600 non-citizens with serious criminal records who were set to be deported. Over 70% of these people have been convicted of serious crimes, such as sexual assault. Right now, these people are still roaming our streets. The minister had one job, and it's to keep Canadians safe. He's failed it. Will the Prime Minister fire his Public Safety Minister?
The Honourable Minister of Public Safety.
Mr. Speaker, this year we are on target to remove over 20,000 individuals who do not meet the requirements to be in Canada, Mr. Speaker. It is a record level of removals in Canadian history, and we're working towards ensuring that this is accelerated even further. The addition of another 1,000 CBSA officers will help and aid in this process, Mr. Speaker. We will continue to make sure that Canada and our border is safe, Mr. Speaker. This is exactly what we've been working on. We will continue to invest in Canadians.
Honourable Member for Calgary Knowles Hill.
I'm not sure what on track means when there's 600 serious criminals who are non-citizens who should be deported but are on the streets. We asked these questions in May and in June. The minister had the entire summer to come up with a plan. These are people who have been convicted of crimes like sexual assault, and he lost them, and he can't find them. Why won't the Prime Minister fire his Public Safety Minister?
The Honourable Minister of Public Safety.
Mr. Speaker, the Canada Border Service Agency has been working very hard throughout this, not just the summer, Mr. Speaker, the last several years to ensure that our borders are stronger than ever. This year, we are on target to have more than 20,000 removals of those who are not eligible to be in this country, and that number is accelerating by the month, Mr. Speaker. This is the type of work that our exceptional front service officers are doing. This is the type of investment that we will be adding to this year, including adding 1,000 new CBSA officers, Mr. Speaker. Thank you.
Honourable Member for St. Albert, Sturgeon River.
Speaker, the Minister of Public Safety got caught on tape telling his tenant that he need not worry about the Liberals' $750 million gun buyback because he could simply ignore it, and then proceeded to joke that he would bail him out if he got arrested. In other words, the Minister of Public Safety effectively counseled his tenant to break the law. In the face of this serious ethical lapse, will the Prime Minister fire this minister?
The Honourable Minister of Public Safety.
Mr. Speaker, I appreciate another opportunity to talk about our compensation program that we launched today. At 12:30 today, Mr. Speaker, I, along with many of my colleagues, including the Secretary of State for Nature, who you've heard in this House, Mr. Speaker, of the enormous work that she has done over decades in advocating for this moment, Mr. Speaker. Survivors across Canada have asked for this, Mr. Speaker. It's important that we get weapons such as AR-15s off our streets. That's exactly what we've done. We'll be expanding this from Cape Breton to across Canada over the next 5 to 7 weeks, Mr. Speaker.
The Honourable Member for St. Albert, Sturgeon River.
Mr. Speaker, it doesn't end there. On tape, the minister admitted that the buyback rips off law-abiding firearms owners when he promised his frustrated tenant to personally pay the difference in value for his confiscated firearm. Counseling his tenant to break the law, promising to bail him out, and then trying to appease him by cutting a check. How many ethical lapses is it going to take before the Prime Minister fires this incompetent minister?
The Honourable Minister of Public Safety.
Mr. Speaker, I invite this House, I invite the members opposite to have a serious conversation about guns, Mr. Speaker. When you want to talk about crime, when we want to work together to ensure that our streets are safer, it needs to be a serious conversation. It cannot be hyperbole, Mr. Speaker. What we've announced today is to take off from our streets weapons that should not be in possession of Canadians, which include AR-15s, Mr. Speaker, that are lethal and that can destroy people, Mr. Speaker. This is why we brought forward this plan. We're starting in Cape Breton. We're going to be expanding it across Canada, Mr. Speaker. I invite members opposite to support this.
The Honourable Member for Elgin, St. Thomas, London South.
Mr. Speaker, the first job of the Public Safety Minister is to keep Canadians safe. This Public Safety Minister admitted to not knowing what a firearms license is. He said he doesn't know what the classifications of firearms are, and he couldn't even defend his own Liberal government's gun confiscation scheme to his tenant on the most basic questions. And this is the minister responsible for Canada's gun laws. The Public Safety Minister oversees national security, terrorism. What else does he not know about his own file? His incompetence puts Canadian lives at risk. When will the Prime Minister fire him?
The Honourable Minister of Public Safety.
Mr. Speaker, the member opposite, I'm told, understands weapons, understands firearms. I want to ask him a very simple question, Mr. Speaker. Why do we need AR-15s in our communities? Why do we need it in our neighborhoods? Why do we need it on our streets, Mr. Speaker? Can that member tell this House why we need that type of weapons on our streets, making it more harder, making it unsafe for Canadians, Mr. Speaker?
The honourable member for Avalon.
Mr. Speaker, the 2025 wildfire season has been the second worst wildfire season on record, with communities across the country, including my home province of Newfoundland and Labrador, facing devastation and thousands of Canadians forced from their homes. Can the Minister of Emergency Management give us an update on what the House and how our government supported Canadians and the wildfires response?
The Honourable Minister of Emergency Management and Community Resilience.
Mr. Speaker, I want to thank the first responders and local officials and members of the Canadian Armed Forces whose work on the front lines saved lives and protected communities. We were there for Newfoundland and Labradorians as they faced these historic wildfires. We also supported Saskatchewan, Manitoba, Ontario, and Nova Scotia. In true Canadian form, the provinces and territories stepped up to help one another when more resources were needed. While many face a long road to recovery, we'll continue to support Canadians with focus, determination, and unity.
The Honourable Member for Edmonton Gateway.
Keeping Canadians safe is the Public Safety Minister's #1 job. But the rising number of extortion cases in this country is out of control. Surrey police say that the number of cases they're investigating since June have tripled. Canadians continue to live in fear of their houses being shot at or businesses being burnt down or much, much worse. Meanwhile, the minister continues to make empty promises of additional RCMP officers, but they haven't been hired yet. This minister has clearly failed to keep Canadians safe from international gangs and extortions. When will the Prime Minister fire him?
The Honourable Secretary of State for Combating Crime.
Hear, hear.
Mr. Speaker, extortion is illegal in Canada. It carries a very stiff penalty. The Conservatives would like people to believe that it is legal to extort people. It is not. There are minimum sentences that extortion carries.
Right.
We've created a national task force that is working and monitoring all extortions and connecting police agencies across this country. Many arrests have been made. We won't stop there. We'll continue to go after extortionists. It's illegal, and they will be put behind bars.
The Honourable Member for Abbotsford South Langley.
Mr. Speaker, the #1 job of the Public Safety Minister is to keep Canadians safe, and he has failed. Extortion is up 330%, especially in my riding of Abbotsford South Langley. The minister has not yet labelled the Bishnoi Gang as a terrorist organization who are responsible for widespread violence in Canada. Designating the Bishnoi Group as a terrorist entity will arm the law enforcement with the critical tools needed to prosecute the gang activities. Politicians nationwide have been calling on this. Will this minister resign today, or will the Prime Minister finally fire him for his poor behavior?
Hear, hear.
The Honourable Secretary of State for Combating Crime.
Mr. Speaker, public safety is a top priority for this new government. National security experts independently evaluate and make recommendations on terrorist entity listings. This work is ongoing, and we hope to have a decision very soon, Mr. Speaker.
Hear, hear.
The Honourable Member for Calgary Skyview.
Mr. Speaker, extortion cases have skyrocketed by 330%. This past Saturday night, my community was targeted by Bishnoi terrorists who carried out a shooting followed by an attempt to extort the victim. This gang is actively threatening innocent Canadians, causing fear in neighborhoods like mine. Yet, this minister has failed to label them as a terrorist organization. My question to the Minister of Public and Safety is simple. Will this minister resign, or will the Prime Minister fire him today?
The Honourable Secretary of State for Combating Crime.
Mr. Speaker, it is the RCMP that first came out to expose the Bishnoi gang in this country as an organization that is actively working in our neighborhoods. It is a crime to extort Canadians. We will go after them. We've created a national task force to address this issue. Our national security experts are independently evaluating the listing of Bishnoi as a terrorist organization. I hope they will arrive at a decision soon so that we can continue to keep our community safe.
The Honourable Member for Hamilton Centre.
Mr. Speaker, Canada's new government has been elected on the promise to spend less, invest more, and make government more efficient. Can the President of Treasury Board update this House on the red tape review he has been recently launched and how it will help ensure more effective service delivery for Canadians?
Honourable President of the Treasury Board.
Thank you, Mr. Speaker. I'd like to thank my honourable colleague for this question. Canada's new government is taking bold actions and delivering results. We're eliminating red tape to improve efficiency and to deliver better and faster services to Canadians. We have received almost 500 proposals since launching our red tape review.
That's impressive.
These initiatives will make the government more efficient to build the strongest economy in the G7 and to build Canada strong.
The Honourable Member for Portneuf, Jacques Cartier. Mr. Speaker, what another fine mess this Liberal government has made of the firearms issue. Crime is up 130% under these Liberals, and the minister is targeting the wrong people by attacking honest citizens who are hunters and sports shooters. The new Minister of Public Safety says privately that the famous gun buyback is a waste of money and the budget will skyrocket, but under pressure from the PM, he must hypocritically continue the program. The minister has no legitimacy. When will the Prime Minister fire him? The Honourable Secretary of State. Thank you, Mr. Speaker. I'd like to thank my colleague for his question. Canadians want to live in a safe environment, and for 35 years they know that assault-style weapons can cause massacres in Canada. It happened to me. It happened to other Canadian citizens in Port-à-Pique and across Canada. And what we're going to do today that starts in Cape Breton, and I'd like to thank the Cape Breton team that is starting this pilot project. We are going to remove these assault-style weapons from our streets to make our country a safer one. Thank you.
The Honourable Member for Vancouver East.
The Liberal government abused their power one too many times by invoking Section 107 of the Labour Code as a backdoor to order striking workers back to work. They did it with rail, port, and postal workers. And they tried to do it with Air Canada flight attendants. QP National fought back and defied the back-to-work order. Trade unions across the country stood firmly on the side of flight attendants to say unpaid work don't fly. Will the minister respect the constitutional right of workers to free collective bargaining and repeal Section 107 of the Labour Code? Yes or no?
Honourable Minister of Jobs and Families.
Mr. Speaker, yesterday I had the privilege and honour, along with Secretary of State of Labour, to meet with the Canadian building trades unions who are standing strongly with our government as we plan to build the strongest economy in the G7. We talked about the major projects that are going to provide great jobs for tradespeople, unionized tradespeople across this country, and the importance of having unionization in this country to protect a strong middle class. And Mr. Speaker, I will tell you that this government will always act quickly to support labour rights and to support industrial peace.
The Honourable Member for Courtenay Alberni.
Canada is facing record wildfires that are destroying communities, critical infrastructure, and lives, while also creating dangerous air pollution that harms human health. Yet Canada still doesn't have a sovereign aerial firefighting fleet. In Port Alberni, Coulson Aviation is a world leader in retrofitting aircraft, such as the retired CC-130 Hercules, that could continue to protect Canadians and create high-skilled jobs here at home. Will the government commit in this budget to establishing a permanent national aerial firefighting fleet so Canada can defend our communities from climate disasters while also meeting its NATO obligations?
The Honourable Minister of Emergency Management and Community Resilience.
Mr. Speaker, we're living in a reality where natural disasters are more frequent and more severe. I'm actively working with provinces and territories, Indigenous partners and other stakeholders on how we can strengthen coordination and capacity. Throughout the summer, I met with first responders, local officials, and members of the Canadian Armed Forces to hear their first-hand experiences with wildfires this season. We'll ensure that communities have the tools they need to respond, recover, and rebuild. Thank you.
Il y a un rappel au règlement.
Point of order.
Berthier-Masquinon.
The member for Berthier-Masquinon. Thank you very much, Mr. Speaker. My point of order is about last week. You'll remember there was a point of order with the immigration minister who had said, I'll say this in another language to make sure I'm understood. And last week it was raised as a point of order. It wasn't an attack. We didn't call for an apology, but we just asked her not to use those terms and to withdraw them. That didn't happen, and that's why it's happened again today. Mr. Speaker, with all due respect to the Secretary of State for Nature, but to say to another member, I'm going to say this in the other language to make sure they understand. Well, first of all, that affects official languages. Both official languages have to be accepted and used in this place. And, Mr. Speaker, it also shows a lack of respect for the work of the interpreters who do a high-quality job. And if there's someone who doesn't hear what's said, I would strongly recommend they wear their earpiece. And that helps keep the noise down if people will just use their earpieces instead of shouting. I won't call for the Secretary of State to withdraw those remarks because it didn't work last week. But could you at least remind everyone here to have respect for the use of the language of our choice and for the work of our interpreters who do outstanding work? Thank you.
Avec plaisir, oui.
With pleasure, yes. You have to be careful when you say things like that. As I said last week, it's just a figure of speech when you say that, but perhaps it's not the best way to speak here. So that's duly noted, the point that the member for Berthier-Masquinongé has raised.
Je voudrais signaler.
I'd like to point out to members the presence in the gallery of René Degassi, Vice Premier, Minister of Finance, and President of the Treasury Board and Minister of Energy for the province of New Brunswick.
L'honorable. J'ai pas terminé. L'honorable.
I'm not finished. There's the Honorable Jean-Claude Damour, Minister of Education, Training and Labor, and for Intergovernmental Affairs, and for Immigration for the province of New Brunswick.
And the Honorable John Herron, Minister of Natural Resources for the province of New Brunswick. It being 3:16, the House will now proceed to the taking of the deferred recorded division on the motion of Mr. Scheer relating to the business of supply. Calling in the members. The question is as follows. Mr. Scheer, seconded by Mr. Small, moved that the House call on the Prime Minister to immediately repeal the oil and gas emissions cap, which is which in effect is a production cap. The 10-minute period for members voting electronically has started, and the House will now proceed to the vote for members participating in person. All those in favour of the motion will please rise.
Mr. Doherty.
Mr. Doherty.
Mr. Schmale.
Mr. Schmale.
Mr. Brock.
Mr. Brock.
Mr. Bazan.
Mr. Bazan.
Mrs. Block.
Mrs. Block.
Mrs. Thomas.
Mrs. Thomas.
Mr. Dentel.
Mr. Deltel.
Mr. Paulus.
Mr. Paulus.
Ms. Dancho.
Ms. Dancho.
Mr. Chong.
Mr. Chong.
Mrs. Stubbs.
Mrs. Stubbs.
Mr. Barlow.
Mr. Barlow.
Mr. Albus.
Mr. Albus.
Mr. D'Entremont.
Monsieur D'Entremont.
Mr. Small.
Mr. Small.
Mr. Mazer.
Mr. Mazer.
Mr. Jennis.
Mr. Jennis.
Mr. Brassard.
Mr. Brassard.
Mr. Moore.
Mr. Moore.
Mr. Beltud.
Monsieur Berthold.
Mr. Workington.
Mr. Workington.
Mrs. Cramp-Nyman.
Mrs. Cramp-Nyman.
Mrs. Roberts.
Mrs. Roberts.
Mr. Morin.
Mr. Morin.
Mr. Ross.
Mr. Ross.
Madame Vien.
Madame Vien.
Mr. Godin.
Monsieur Godin.
Mr. Martel.
Monsieur Martel.
Mr. Cooper.
Mr. Cooper.
Mr. Lloyd.
Mr. Lloyd.
Mr. Caputo.
Mr. Caputo.
Mr. Van Popta.
Mr. Van Popta.
Mr. Kelly.
Mr. Kelly.
Mr. Généreux.
Mr. Généreux.
Mr. Gould.
Monsieur Gould.
Mr. Viss.
Mr. Viss.
Mr. Tucker.
Mr. Tucker.
Mr. Steinley.
Mr. Steinley.
Mr. Lobb.
Mr. Lobb.
Mr. Baldinelli.
Mr. Baldinelli.
Mr. Davidson.
Mr. Davidson.
Mr. Malello.
Mr. Malello.
Mr. Calkins.
Mr. Calkins.
Mr. Lawrence.
Mr. Lawrence.
Mr. Muse.
Mr. Muse.
Mr. Waugh.
Mr. Waugh.
Ms. Rude.
Ms. Rude.
Mrs. Goodrich.
Mrs. Goodrich.
Mrs. Falk Battleford Sloydminster Meadow Lake.
Mrs. Falk Battleford Lloydminster Meadow Lake.
Ms. Gladue.
Ms. Gladue.
Mr. Majumdar.
Mr. Majumdar.
Mr. Ho.
Mr. Ho.
Mr. Shipley.
Mr. Shipley.
Mr. Bragdon.
Mr. Bragdon.
Mr. Redekop.
Mr. Redekop.
Mr. Tolmie.
Mr. Tolmie.
Mr. Mallet Kapiskising Timmins Mushkagawak.
Monsieur Mallet Kapiskising Timmins Mushkagawak.
Monsieur Lefebvre.
Monsieur Lefebvre.
Mr. Arnold.
Mr. Arnold.
Mrs. Gallant.
Mrs. Gallant.
Mr. Reed.
Mr. Reed.
Mr. Epp.
Mr. Epp.
Mr. Williamson.
Mr. Williamson.
Mr. Falk Provencher.
Mr. Falk Provencher.
Mr. Diot.
Mr. Diot.
Mr. Macaulay.
Mr. Macaulay.
Mr. Menegakis.
Mr. Menegakis.
Mrs. Wagenthal.
Mrs. Wagenthal.
Mr. Abuteyev.
Mr. Abuteyev.
Mr. Motz.
Mr. Motz.
Mr. Dalton.
Mr. Dalton.
Mr. Dowdle.
Mr. Dowdle.
Mr. Cram.
Mr. Cram.
Mr. Lewis Essex.
Mr. Lewis Essex.
Mr. McLean, Calgary Centre.
Mr. McLean, Calgary Centre.
Mr. Patzer.
Mr. Patzer.
Mr. Giovanni.
Mr. Giovanni.
Mrs. Anstey.
Mrs. Anstey.
Mr. Au.
Mr. Au.
Mr. Babber.
Mr. Babber.
Mr. Bailey.
Mr. Bailey.
Mr. Bélanger, Sudbury Est, Manitoulin, Nickelbelt.
Mr. Bélanger, Sudbury Est, Manitoulin, Nickelbelt.
Mr. Bexty.
Mr. Bexty.
Mr. Bonk.
Mr. Bonk.
Mrs. Borelli.
Mrs. Borelli.
Ms. Kobania.
Ms. Kobania.
Ms. Cody.
Mrs. Cody.
Mr. Davies, Niagara South.
Mr. Davies, Niagara South.
Mr. Dawson.
Mr. Dawson.
Mrs. DeRitter.
Mrs. DeRitter.
Mr. Gill, Calgary Skyview.
Mr. Gill, Calgary Skyview.
Mr. Gill, Brampton West.
Mr. Gill, Brampton West.
Mr. Gill, Calgary McKnight.
Mr. Gill, Calgary McKnight.
Mr. Gill, Windsor West.
Mr. Gill, Windsor West.
Mr. Kimmich.
Mr. Kimmich.
Mr. Gill, Abbotsford South Langley.
Mr. Gill, Abbotsford South Langley.
Mr. Groslo.
Mr. Groslo.
Mr. Guglielmin.
Mr. Guglielmin.
Mr. Gunn.
Mr. Gunn.
Mr. Hardy.
Mr. Hardy.
Mr. Holman.
Mr. Holman.
Mr. Jackson.
Mr. Jackson.
Mr. Kibble.
Mr. Kibble.
Mrs. Kirkland.
Miss Kirkland.
Mrs. Conans.
Mrs. Conans.
Ms. Cronus.
Mrs. Cronus.
Mr. Currick.
Mr. Currick.
Mr. Ma.
Mr. Ma.
Mr. Mahal.
Mr. Mahal.
Mr. Mantle.
Mr. Mantle.
Mr. McKenzie.
Mr. McKenzie.
Mr. Reynolds.
Mr. Reynolds.
Mr. Rowe.
Mr. Rowe.
Mr. Stevenson.
Mr. Stevenson.
Mr. Strauss.
Mr. Strauss.
Que tous ceux qui s'opposent à la motion veuillent.
Will all those opposed to the motion please rise?
Madame Diab.
Madame Diab.
Mr. McDonald Malpeck.
Mr. McDonald Malpeck.
Mr. McGinty.
Mr. McGinty.
Mr. Robertson.
Mr. Robertson.
Ms. Thompson.
Ms. Thompson.
Madame Michel.
Madame Michel.
Monsieur Guilbeault.
Mr. Guilbeault.
Mr. Cedar Brampton East.
Mr. Cedar Brampton East.
Ms. Olszewski.
Ms. Olszewski.
Mr. Solomon.
Mr. Solomon.
Mrs. Valdez.
Mrs. Valdez.
Monsieur Duclos.
Monsieur Duclos.
Ms. Gould.
Ms. Gould.
Madame Petitpas-Taylor.
Madame Petitpas-Taylor.
Mr. Blair.
Mr. Blair.
Ms. Chagger.
Ms. Chagger.
Mr. Osborne.
Mr. Osborne.
Mr. Fragascatos.
Mr. Fragascatos.
Mr. Fuhrer.
Mr. Fuhrer.
Ms. Sahota.
Ms. Sahota.
Mr. Bélanger, Manitou, Desnothing Mississippi, Churchill River.
Mr. Bélanger, Desnothing Mississippi, Churchill River.
Ms. McKnight.
Ms. McKnight.
Ms. Chartrand.
Ms. Chartrand.
Mr. Garrettson.
Mr. Garrettson.
Ms. Alty.
Ms. Alty.
Mr. Sarai.
Mr. Sarai.
Ms. McLean, Esquimalt Senate Sook.
Ms. McLean, Esquimalt Senate Sook.
Mr. Long.
Mr. Long.
Mr. Zaricelli.
Mr. Mr. Shelley.
Madame Chenette.
Madame Chenette.
Mr. Housefather.
Mr. Housefather.
Madame Ménard.
Madame Ménard.
Ms. Jacek.
Ms. Jacek.
Ms. Scrow.
Ms. Scrow.
Mr. Dogood.
Mr. Dogood.
Mr. Fisher.
Mr. Fisher.
Mr. Dollywall.
Mr. Dollywall.
Madame Chatel.
Madame Chatel.
Mrs. Romanato.
Mrs. Romanato.
Mr. Lewis Kitchener-Conestoga.
Mr. Lewis Kitchener-Conestoga.
Mr. Assassi.
Mr. Assassi.
Mr. Grant.
Mr. Grant.
Mr. Leitao.
Mr. Leitao.
Mr. Bardisi.
Mr. Bardisi.
Madame Kayabaga.
Madame Kayabaga.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. Kellaway.
Mr. Kellaway.
Mr. Gay.
Mr. Gay.
Mr. Hogan.
Mr. Hogan.
Mr. Ramsey.
Mr. Ramsey.
Madame Koutrakis.
Madame Koutrakis.
Ms. Chi.
Ms. Chi.
Mr. Miles.
Mr. Miles.
Mr. Biddle.
Mr. Biddle.
Mr. Chen.
Mr. Chen.
Ms. Dillon.
Ms. Dillon.
Ms. Zarowitz.
Ms. Zarowitz.
Mr. Fergus.
Mr. Fergus.
Mr. Fonseca.
Mr. Fonseca.
Monsieur Yakino.
Monsieur Yakino.
Monsieur Lozon.
Monsieur Lozon.
Mr. Maloney.
Mr. Maloney.
Mrs. McKelvey.
Mrs. McKelvey.
Mr. Gasparo.
Mr. Gasparo.
Madame Rochefort.
Madame Rochefort.
Mr. Casey.
Mr. Casey.
Madame Fortier.
Madame Fortier.
Mr. Oliphant.
Mr. Oliphant.
Mr. Baptiste.
Mr. Baptiste.
Mr. Clausen.
Mr. Clausen.
Madame Lavac.
Madame Lavac.
Mr. Turnbull.
Mr. Turnbull.
Ms. Church.
Ms. Church.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. Morrissey.
Mr. Morrissey.
Ms. Cedar Brampton South.
Ms. Cedar Brampton South.
Ms. Vandenbelt.
Ms. Vanderbilt.
Mrs. Zaid.
Mrs. Zaid.
Ms. Yip.
Ms. Yip.
Mr. Ailfson.
Mr. Ailson.
Madame Lapointe, Rivière des Mille Îles.
Madame Lapointe, Rivière des Mille Îles.
Mr. Baines.
Mr. Baines.
Mr. Coteau.
Mr. Coteau.
Ms. Hepfner.
Miss Hefner.
Madame Lapointe Sudbury.
Madame Lapointe Sudbury.
Mr. Sousa.
Mr. Sousa.
Mr. Carr.
Mr. Carr.
Ms. Akan.
Ms. Akan.
Mr. Al Saoud.
Mr. Al Saoud.
Madame Auguste.
Madame Auguste.
Mr. Chang.
Mr. Chang.
Mr. Clark.
Mr. Clark.
Mr. Connors.
Mr. Connors.
Madame Dandurand.
Madame Dandurand.
Mr. Danko.
Mr. Danko.
Mr. Deschênes-Thériault.
Mr. Deschênes-Thériault.
Ms. Fancy.
Ms. Fancy.
Mr. Fanjoy.
Mr. Fanjoy.
Mr. Greaves.
Mr. Greaves.
Ms. Harrison.
Miss Harrison.
Ms. Hurtle.
Miss Hurdle.
Monsieur Joseph.
Monsieur Joseph.
Monsieur Lavoie.
Monsieur Lavoie.
Mr. McDonald Cardigan.
Mr. McDonald Cardigan.
Mr. Mallet Bay of Quinty.
Mr. Mallet Bay of Quinty.
Ms. Miedema.
Ms. Miedema.
Madame Mingarelli.
Madame Mingarelli.
Ms. Nathan.
Ms. Nathan.
Ms. Wien.
Ms. Wien.
Mr. Tumba.
Mr. Tumba.
Ms. O'Rourke.
Ms. O'Rourke.
Ms. Royer.
Ms. Royer.
Mr. Saini.
Mr. Saini.
Mr. Sari.
Mr. Sari.
Mr. Sawatsky.
Mr. Sawatsky.
Ms. Sodi.
Ms. Sodi.
Mr. St. Pierre.
Mr. St. Pierre.
Ms. Tesser Dirksen.
Ms. Tesser Dirksen.
Mr. Villeneuve.
Mr. Villeneuve.
Mr. Watchhorn.
Monsieur Watchhorn.
Monsieur Garon.
Monsieur Garon.
Monsieur Simard.
Monsieur Simard.
Monsieur Perron.
Monsieur Perron.
Monsieur Bonin.
Monsieur Bonin.
Monsieur Sainte-Marie.
Monsieur Sainte-Marie.
Madame Larouche.
Madame Larouche.
Monsieur Beaulieu.
Monsieur Beaulieu.
Monsieur Barcelou Duval.
Monsieur Barcelot Duval.
Monsieur Blanchette Jonca.
Monsieur Blanchette Jonca.
Ms. Gazan.
Ms. Kazan.
Mr. Johns.
Mr. John.
Ms. May.
Ms. May.
La Chambre attendra.
The House will now wait for the end of the electronic voting period before proceeding.
Je désire informer la Chambre que la période de...
I wish to inform the House that the electronic voting period has ended. If members were unable to vote due to technical difficulties, they may now use the raise hand function and the chair will recognize them.
Je ne vois pas de main levée.
I do not see any hands raised.
Le bureau va maintenant...
The table will now compile the results of the vote.
Yeas pour 140, 140. Nays contre 192, 192.
Déclare la motion rejetée.
I declare the motion defeated.
There's a point of order from the honourable member.
Speaker, across the way we noticed that the honourable member from Honoré Mercier was out of his chair for the significant duration of the time that the vote was being counted. He was speaking with the leader of the Green Party. I just want to confirm if or not he intended to vote in the House or if he had done it by app, because as I think the House wants to remember that a member can't leave their seat when they're in the middle of voting if they did vote here in the House.
The honourable member for Honoré Mercier, could the honourable member for Honoré Mercier clarify where he voted?
Yeah, I did not leave the chamber, but my apologies for standing up, but my intent was to vote.
Unfortunately, the members must remain in their seat when voting in the chamber, and so on. We cannot register his vote, which he said he was in favor. Would have been in favor. I wish to inform the House that because of the ministerial statement and the deferred recorded divisions, the time provided for government orders will be extended by 11 minutes. I also wish to inform the House that the volume of earpieces will now be reset. A couple of seconds for people to leave the chamber quietly.
Orders of the day, government orders, business of supply, resuming debate on the bill of Mr. Fortin on constitutional powers of Quebec and the provinces. I'll ask the member for Jonquière to wait a moment because there are still many members leaving the House. I ask members leaving the House to please be quiet as we are resuming debate. Also, there seem to be members on the floor, which blocks the camera view. The honourable member for Jonquière. Thank you very much, Mr. Speaker. I'd like to begin by referring to what I've heard all day today from the government. The government wants us to believe that they're not trying to oppose Bill 21, but rather to oppose the notwithstanding clause, despite the fact that the former Prime Minister, Trudeau, he vocally opposed Bill 21 many times. Many government members have spoken out against Bill 21, but apparently today the Liberals are only against overuse of the notwithstanding clause. The Liberals have mostly talked about the rising cost of living. We raised many points of order to ask whether they would stick to the topic, stick to our bill, but they don't seem to be interested in talking about our bill today. Our Liberal friends reminded us many times that they have more seats than us in Quebec, but Quebecers are not being well served today. I wish they were more respectful of Quebecers today as we debate this motion, which is so important to us. There is a legal challenge to Bill 21, which is part of a long history of attempts by the Government of Canada to make Quebec just like any other province. The common thread in all of these attempts has been not recognizing Quebec's specificity. The government constantly tries to clamp down any attempt by the Government of Quebec to express its governmental independence or autonomy. This is like Groundhog Day. Every time Quebec tries to use legitimate tools to express its difference and defend its identity, the federal government is always there to stand in the way. What we've witnessed today is just that, once again. Now, let's go over some aspects of Quebec and Canada's political history. These challenges to, you remember when we were debating Bill 101. In this House, Bill 101 in Quebec, well, it was described here as Nazi legislation. Federalist parties did not support us. We asked for more powers over immigration. They refuse us. And of course, Mr. Speaker, you know about Meech, about Charlottetown, about all the times when Quebec was told straight out, no. Even when it comes to spending powers, when it comes to the fiscal imbalance, we're used to being told no by the federal government. That's why this sovereigntist movement was born, in fact. But the government is adding yet another layer now. They're no longer satisfied with just putting our autonomy under lock and key. Now they're trying to make us have a negative view of ourselves, and we constantly have to correct what they suggest about us. I'd like to talk about a situation which reminds me of what we're seeing today. Many times, Mr. Speaker, we've been told that Quebec is anti-immigration, that Quebec wants to be isolated, that we don't support difference. Even in the Trudeau era, we were accused of aggressive nationalism in Quebec. In Canadian history, there was an interesting dispute between Hubert Aquin and Pierre Elliott Trudeau. There's a book called La Revanche des Clercs. It was all very clear. Mr. Trudeau viewed Quebec as a homogenous nation, closed off. Mr. Aquin, though, claimed that Quebec had always been a multi-ethnic province. We may have a homogenous culture in Quebec, but within that culture, people come from all walks of life and many different ethnicities. Those criticisms were leveled in the past to denigrate Quebec. We see similar comments in the factum. This factum to the Attorney General claims that Quebec wants to limit freedom of the press, freedom of religion, union rights. It's even suggested that Quebec might want forced labor or might implement arbitrary executions. Between the lines, we can read that this does considerable reputational damage to Quebec. It tarnishes our reputation. We have made reasonable accommodations about Quebec's place in the Federation. And when it comes to the role of religion in the public space, Quebec is not closed off to differences. Quebec is not closed to ethnocultural minorities, but our reputation is constantly being slandered. In Quebec, we treat language minorities in the best way possible that others should emulate. We have a language minority, which represents 8% of our population, but they receive 30% of our education budgets. That would be ideal for any francophone minority group outside Quebec. Yet, we're constantly dealing with criticism leveled against our reputation. I'd like to come back to my observation that I made earlier on in my speech. Canada wants Quebec to be a province just like any other. What this is really about today is the federal government challenging Bill 21. We need that to be said. We need that on the record. The government claims that this is about the notwithstanding clause, but it is about Bill 21. That's clear. Now, back to multiculturalism in Canada. In 1963, there was the Laurent-Drouin Commission. In 1963, we were coming out of the Quiet Revolution. We were no longer called French Canadians, but Quebecers. Canada then tried to develop a collective shared identity which would include Quebec, so they launched the Laurent-Drouin Commission. The goal was for Canada to become a bicultural, bilingual country. Well, we disagreed. Canada became bilingual on paper, but biculturalism was set aside in favor of multiculturalism. That was the first time that Quebec was truly told, no, Canada will become a multicultural country. We will recognize all cultures, meaning that we will recognize none. That's what most experts and pundits, that's how they viewed it. So we were told no, once again, by Ottawa through the Laurent-Drouin Commission. My time is running out. Just a few more comments. Ottawa created its own model of interculturalism. We are debating Bill 21 and secularism, and we have our interculturalism model with three main principles that Quebecers widely support. We reject multiculturalism, we reject assimilation, and the third pillar, the importance of integration based on Quebec's fundamental values, which are what? Quebec is a French-speaking state, a French state. Quebec is a province where male-female equality, gender equality is essential. And another is that Quebec is a secular state. We heard Simone de Beauvoir quoted today saying that the notwithstanding clause could fly in the face of women's freedom to make their own choices. That's nonsense. I've never heard such nonsense in my life, Mr. Speaker.
Quebecers in the 50s and 60s had to find their freedom from religion, and they know that the religion was at the heart of society then. And I'd like to answer the questions. Happy to answer questions now, but in conclusion, stop saying that you're against the notwithstanding clause. Questions and comments. The honourable member for Joliette. Thank you, Mr. Speaker. First, I'd like to congratulate my honourable colleague for his excellent speech. I would like to quote something from the constitutional lawyer, Mr. Bluck. Defending the Constitution of Canada is defending the notwithstanding clause, and everyone has to do so. It's impossible to separate them because it is the central element of the compromise when the Constitution was created. The notwithstanding clause is not Quebec, it's not Quebecois, it is the very essential nature of Canada. Yes, exactly. After 1982, what happened? Quebec was pushed aside. If Quebec as a national minority wants to continue forward and create its own laws, it needs some type of autonomy that is political. And this political autonomy was refused constantly by the various governments, federal governments. And the notwithstanding clause is like an insurance policy that allows everyone in Quebec to create its own legislation. And even that is too much to ask for the Liberals. Questions and comments? The Honourable Parliamentary Secretary.
Speaker, and I'll get to the opportunity to address in more details the concerns that I have. But the question that I have for the member is fairly specific. Does he feel, and first of all, I would say, Mr. Speaker, this is not about the province of Quebec. The issue of notwithstanding the clause applies to all provincial and the Parliament, in fact. Does he have any concerns whatsoever in regards to using the notwithstanding clause as a preemptive measure?
Honourable Member for Jonquière. It doesn't work. Even if you look at the media, to say it doesn't necessarily apply to Quebec, well, why did you do this in a bill against, in a note against Bill 21? There's some hypocrisy on the part of the government. They're trying to arrange everything, but their objective is clear. If you looked at the government in the past, it is clearly against Bill 21, and now they're going to try and go through the notwithstanding clause and hide their real intentions, and that's unfortunate.
Questions and comments. Le député.
The Honourable Member for Montcalm. Thank you very much, Mr. Speaker. I'd like to congratulate my colleague for his very well spoken speech. And since 1982, we've seen a phenomenon called the judiciarization of the political space. It means we're always sending things to courts because they don't have the courage to deal with them on the political front. And if the Liberals are against the notwithstanding clause, they should be going back to the spirit of the 1982 Constitution, and why not reopen the debate on this? What does my colleague think of this position that I find somewhat cowardly? The Honourable Member for Jonquière. Well, cowardly is the right word. We saw all day that when the Liberals rose to speak, they said they're not against Bill 21. They said that they want to underscore the effects of the notwithstanding clause. But they're really trying to hide things. We used to have a Liberal government most of the faces I see here were here in the previous parliament in that party, and the minister rose to criticize Bill 21, and now they're trying to say they're not against Bill 21, they're just against the notwithstanding clause. Questions and comments?
Or Richmond South.
Mr. Speaker, Canadians elected us as parliamentarians to work together to solve the crises that this Liberal government has caused. The immigration crisis, the cost of living crisis, the debt crisis, the inflation crisis, the housing crisis, you name it. I just wanted to ask our colleague whether he agrees that this is just another distraction that the Liberal Prime Minister is trying to stir up for Canadians.
The Deputy Jonquière.
I remember for Jonquière, 20 seconds or less. Quebec's identity is not a distraction. Quebec's project to govern itself is not a distraction. Quebec's autonomy to make its own choices is not a distraction. The Conservatives have been doing this since the start of the day, and they should be ashamed to use that rhetoric.
Debate, reprise the débat. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And I've been here throughout the day listening to the debate. And, you know, a couple of things come to my mind right at the beginning. Is just to kind of give a bit of a background with respect to why it is I want to be able to speak to this particular motion. Because I have witnessed a lot of things that question, for me personally, why it is people are motivated to be able to speak to this legislation. I look at the Conservatives as the official opposition, and they're just as comfortable trying to shift the debate and not talk about the issue and literally accuse the government of trying to use this as some sort of a diversion strategy to prevent us from being able to deal with the many different things that have been happening since we've elected a new Prime Minister not that long ago. And I would invite the Conservative Party to bring forward such a motion in their opposition day. Let's talk about and review the last 6 months since we've had the new Prime Minister. Then we have the motivation of the Bloc Party. Let's be very clear on this. The Bloc Party is a separatist party. They want to break up Canada. Their motivation is to try to get the government to say this is all anti-Quebec. This is all about Bill C-21, even though they know it's not true. It's just not true. But it doesn't stop them from saying that, Mr. Speaker, because they are trying to be able to hype up whoever it is that they're trying to garner that support for. The province of Quebec is not the only province that has used the notwithstanding clause. We've had provinces in every region of our country use the notwithstanding clause. Not every province, but we've had a province in every different region. Atlantic Canada, Ontario, Quebec, the Prairies, and BC. And you could probably even go more in terms of those that have thought about the possibility of bringing it in. Take a look in terms of the history, Mr. Speaker. And this is where my motivation comes from. I was a relatively young man at 20 when Pierre Elliott Trudeau sat at the table and signed it off, the Constitution and the Charter of Rights, back in 1982, Mr. Speaker. At a very early age, I had a keen interest in getting involved in politics, and I was very proud of my Prime Minister and the nation of Canada. At the time, my favorite NHL team was the Montreal Habs, Mr. Speaker. And I was passionate about the football, and if the Bombers couldn't win the Grey Cup, I wanted Montreal Alouettes to win the Grey Cup. In fact, Mr. Speaker, if you take a look at my biological ancestry, you'll find that a few generations ago, my family comes from St. Ours, Quebec. 3 hours from the province, from Ottawa, in terms of a drive, Mr. Speaker. When I approach the discussion that we're having today, it's not to talk about how one province is being alienated from the federal government. I won't buy into that because it's a separatist party that is trying to shove that aspect down our throats. And I don't buy it. There is a responsibility for the Government of Canada to deal with this issue because it's coming before the Supreme Court of Canada. That's the reason why the Government of Canada has to address the issue, and there is an obligation. If we didn't do that, I would suggest to you that we were neglecting our responsibility, Mr. Speaker. And I myself would be wanting to talk to the Attorney General of Canada, saying that the Charter of Rights and Freedoms is something that we believe in as a political entity. The Liberal Party is the party that brought it into being under Pierre Elliott Trudeau, Mr. Speaker. I'm very much aware of the constitutional discussions that had taken place back then, much like I was aware of the constitutional discussions of Charlottetown Accord and Meech Lake Accord, because I was an elected member of the Manitoba Legislature, and I understand the dynamics of power play between provinces and the federal government. There's nothing new that's there, Mr. Speaker. All provinces always tend to want to look at ways in which they can represent their constituents on important issues. And we have an important issue, Mr. Speaker. That's why parliamentarians need to express their thoughts on the issue, whether you're from the Manitoba Legislature, BC, Nova Scotia, or the province of Quebec. because it has an impact on Canadians' rights and freedoms. As a member of Parliament, I have a duty to do so. And I resent the fact that I have members from the Bloc that are trying to tell me that I do not have a duty to do so, Mr. Speaker. Because they approach it through a motivation that ultimately works to the detriment of us as a nation. And that's the reason why it's out without reservation whatsoever that I talk about the issue today. Because I understand and I appreciate the multifaceted approach or a holistic approach at dealing with this critically important issue. Is the timing the best? Well, that's debatable. But at the end of the day, we have a government and a prime minister that is solely focused in terms of our economy, Canadians, the environment, and trying to bring it all together so that we can advance and continue to move straight forward. But there are still other responsibilities, and that's why we have the different ministries, Mr. Speaker, that we do have. And the primary responsibility of the Attorney General of Canada is to protect the Charter of Rights and Freedoms for all Canadians. If not that minister, then who? That is his job. And he has to do that, Mr. Speaker. So was I surprised when we hear that there's a factum that's put before the Supreme Court of Canada? Absolutely not. It'll be interesting how it is that the Conservative Party of Canada stands on this issue. Where do they stand? Are they going to be voting with the Bloc, understanding the motivation as to why it is they've brought forward this motion? Or are they going to vote in the national interest? And the national interest means everyone, young, old, French-speaking, English-speaking, whatever their ethnic background might be. It's all Canadians. We all have that role and responsibility, even members of the Bloc, I must say, Mr. Speaker. But how will the Conservative Party of Canada vote on this motion? Is the coalition between the Bloc and the Conservatives that strong that the Conservatives are going to abandon their responsibilities and vote for the motion, Mr. Speaker? We're going to find out tomorrow. And it's going to be very interesting to see where they stand on this issue. Because what I've witnessed, and I've watched all the debate on the issue, I've witnessed the Conservatives step back and not provide an opinion in terms of how it is that they will vote. Well, I and my colleagues know where we stand. We're going to be voting against the motion. And I hope that the Conservative Party will do likewise. For individuals wanting to get a good appreciation or an understanding of just the importance of the issue, Mr. Speaker, I did a quick Google search, and I want to quote something that I found from the Government of Canada website, because I think it encapsulates why this is such an important debate and why it is that the federal government has a role to play. And I quote right from the website. The Charter of Rights and Freedoms protects basic rights and freedoms that are essential to keeping Canada a free and democratic society. It is a powerful force for progress, protection, and fairness, with the power to influence our society by interpreting laws and policies. The Charter ensures that the government or anyone acting on its behalf doesn't take away or interfere with these rights or freedoms in an unreasonable way. It goes on, Mr. Speaker, to say, since 1982, the Charter has been an essential part of Canada's democracy, and it will continue to shape our identity as a nation. The Charter affirms that we are a multicultural society and that it must be read and understood with this in mind. The debate today is all about Section 33, and it provides a very specific comment in regards to Section 33. Section 33 of the Charter, also called the Notwithstanding Clause, allows Canada's Parliament, provincial and territorial legislatures to pass laws that may violate certain charter rights. A legislature may do this if they clearly state to the public that they are passing a law that violates the Charter and which rights in particular the law infringes. All levels of government must review and reenact this declaration to Canadians every 5 years, or the limits are automatically lifted. The federal Parliament has never used the Notwithstanding Clause, and I'm very proud of the fact that the federal government has never used. We have had legislation, even in my time here in Parliament, we have had legislation come to the House because the Supreme Court or Superior Court has made a decision. And as much as it might offend a lot of parliamentarians, we respect what it is that the Supreme Court or the Superior Court has said, and it has obligated us to change the law. We have one of the bills before us today that does that. We're not bringing in the Notwithstanding Clause because, my God, we're taking a hard position on this. No, we're changing and we're modifying the law so that it still reflects the interest of Canadians and deals with, hopefully, the concerns of the independent judicial system, Mr. Speaker, our Supreme Court or our Superior Court's decision, where we respect it where we can. Now, we have had a number of provinces that have made the decision not to amend a law that was ruled as being unconstitutional or goes against the Charter, I should say. And instead of doing that, they have brought in the Notwithstanding Clause. Now, my friends in the Bloc would say, well, you know what, that's provincial. Let the provinces do whatever they want. Well, we recognize this debate is not about Ottawa trying to say, well, we have control in any fashion whatsoever over the provinces. The Bloc will say that, but that's not the case, Mr. Speaker. We have a responsibility, a judiciary responsibility, to the very same people that provincial governments represent to ensure the Canadian Charter of Rights and Freedoms is being respected. And that means a part of that charter, you will see the Notwithstanding Clause. Within that Notwithstanding Clause, there is a caveat. So if you're taking away a right, you have to do it again within 5 years. And if you don't do it again within 5 years, then you ultimately have to allow that law to expire and the court decision will prevail. So what is being proposed? We're seeing more and more governments, even consideration coming from the Conservative leader, to use the Notwithstanding Clause. In the last election, he talked about using the Notwithstanding Clause on a crime bill. You know, it's not something that is focused on any level of government or any provincial government in particular. It's to get clarification from the Supreme Court of Canada to do and allow for the Supreme Court of Canada to provide an opinion. An opinion, because of its independence, that should be respected, Mr. Speaker. And that's, I think, an admirable thing for us to be doing. I would have much preferred members opposite, if you're having an opposition day motion on that, is to provide their thoughts on that issue. My thoughts, to be very, very clear, is that at the end of the day, I am concerned about two aspects of implementing or revoking or using the Notwithstanding Clause. Number one, is I want a sense of comfort for the people that I represent, that their rights and freedoms are not going to be unduly infringed upon. And the way in which I can ensure that that is the case is by realizing that the sunset clause should not automatically allow for any level of government to say, oh, you know, we brought in the notwithstanding clause 4.5 years ago, the time clock's coming up, okay, let's redo it for another 5 years. So that it becomes an automatic thing, Mr. Speaker. I think that's disrespectful for what I believe Canadians feel about our freedoms and our rights that were well established back in 1982. That is a concern that I have, and I know many of my colleagues share that concern. And I think that the federal court will hopefully take that into some consideration. The other one, in which I've actually posed questions, what about using the notwithstanding clause as a preemptive measure? That is something that we actually are starting to see more of, Mr. Speaker. All of us should be concerned about that. When you, for example, have the leader of the official opposition saying that, look, I don't care what the court system says. I don't care what the Supreme Court of Canada says, because at the end of the day, I will use the notwithstanding clause to ensure X, Y, and Z. I believe that is a highly irresponsible approach to governance, Mr. Speaker. And I don't think any of us should be supporting that sort of a proclamation, if I can maybe put it that way. So whether it's a federal leader or a provincial leader or anyone else, I would suggest to you, Mr. Speaker, that that is an inappropriate use of the notwithstanding clause. And that is my opinion, based on the many hours and hours and hours of discussions, of studies that I've put over the years, from 1982 to being an MLA back in 1988 on the Meat Lake Accord, to the debates on the Charlottetown Accord during the 90s, Mr. Speaker. I understand the importance in terms of joint responsibility, jurisdictional responsibility. I understand why it's so critically important on issues where you have shared responsibilities, that all of us have a role to play. But if you're not here to defend the Canada's Charter of Rights and Freedoms, then why are you here? I would like to think at the end of the day, through the Charter and through the Constitution, it makes up who we are as a nation. And I believe that there's an obligation on members. And that's why I started it off by talking about the motivation factor. You know what my motivation is. It's love of country. I want Canada to continue to be the best country in the world to call home. That's my goal. And that's what motivates me to come in every day. When it comes to the motivation that I've witnessed today, I don't like what I'm seeing, because I see more division trying to be sowed. I see issues that a vast majority of Canadians would not support. And that's the reason why I felt it was important today that I share my thoughts, Mr. Speaker, and I look forward to any questions that might be asked. Thank you, Mr. Speaker.
Questions et commentaires, le député de Mirabel.
Gentleman member for Mirabel. Thank you, Mr. Speaker. Before giving us this big moralizing lesson, the parliamentary secretary did something he does quite rarely. He said he was going to tell us the truth. He said that during the constitutional negotiations, he was in the Manitoba legislature, and the Constitution included a notwithstanding clause, and he said it reflected the power structure of the time. So today he's saying that now that the power dynamics have changed, he wants to use the courts instead of democracy in Parliament to ensure that Section 33, which is crystal clear in black and white, he wants that changed the way it's interpreted by the courts. Is that not a bit cowardly not to have the ability to say, look, we're going to reopen the Constitution and discuss it. Instead of saying that, he's being a sore loser and saying, I'm going to have it my way. The Honourable Parliamentary Secretary to the Government House Leader.
Mr. Speaker, at the end of the day, when you reflect in terms of the Charter of Rights and Freedoms that was signed off back in 1982, I believe the essence of what was there was to show through the notwithstanding clause that Parliament was supreme, that the legislatures were supreme in terms of the laws in which they're making and they're passing, and that was assured by the notwithstanding clause. But there was a sense of that this is a clause that people aren't going to turn to constantly. Take a look in terms of, let's say, between 1990 and 2010. How many times was the notwithstanding clause used? I suspect you will be surprised to the degree in which it was used. I don't think it was. I can't recall it offhand. Maybe members opposite can tell me if in fact it was used. Contrast that to the last number of years, Mr. Speaker, and how it's being used. That should raise some red flags.
Questions et commentaires. Questions and comments. Le député de...
The Honourable Member for Rimouski, La Matapédia. Thank you, Mr. Speaker. I listened to the one member for Winnipeg's moralizing speech, and obviously this is not the first time he's given us a lecture, nor will it be the last, but his explanation doesn't make sense. He says today we need an opinion from the Supreme Court because the role of the Attorney General is to defend the Charter. Mr. Speaker, it's been over 40 years now that the notwithstanding clause has been in existence. And if they didn't intervene before, if they never asked for a court opinion before, my question is this. Is he today saying that they didn't defend the Charter before because over the past 40 years, they never, after over 100 uses of the notwithstanding clause, they've never asked for a court opinion on this? It's as simple as that. The Honourable Parliamentary Secretary to the Government House Leader.
It's been in place for 43 years. It's going before the Supreme Court of Canada. The Attorney General of Canada, I believe, and I would like to think everyone in this chamber should support, has a role to play to defend Canada's interests. Canada's interests meaning every woman, man, child, no matter what the age, no matter what the sex, no matter what language is spoken, at the end of the day, there is a judiciary responsibility for Canada to actually be at the table. If we were not at the table, I would question whether or not the Government of Canada was doing its job, quite frankly. I believe that no one should be surprised that the federal government is doing its job in protecting the interests of Canadians. It's before the Supreme Court.
Questions et commentaires. La députée de Saanich Gulf Islands.
The Honourable Member for Saanich Gulf Islands. Thank you, Mr. Speaker. I rise today to participate in this debate.
Peg, I will put the question in English. I agree that the notwithstanding clause should be used only sparingly. I think it should go to the Supreme Court. But I also have deep respect for my colleagues from the Bloc Québécois. I have deep respect, and I felt at one point in the member's speech that he dismissed the concerns of Bloc Québécois members because of wanting to break up the country. I want to say very clearly to my own constituents and to other members in this place that what I see in the Bloc Québécois members of Parliament is a deep commitment to serve Quebec, as each of us should serve our own communities. I don't see them as destructive. I see them as constructive allies in seeking progressive values. Je pense que les députés du Bloc Québec...
I think the Bloc members are really good members.
The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, I think there are phenomenal members that advocate for their regions or their province or their municipalities. Different people come to the House of Commons for many different reasons. At the end of the day, when you talk about the national interest, having something of this nature elevated to the Supreme Court of Canada, I believe dictates that the Attorney General of Canada has to express the interests of all Canadians, Mr. Speaker. I am a very proud Manitoban. I am Canadian, I would suggest you first and foremost.
Questions et commentaires. Le député de Montcalm.
I'm a member for Montcalm. My colleague claims that it's not the substance of the issue that's at issue here. It's the use of the notwithstanding clause. I have a very simple question for him. What does he think of Bill 21?
Secrétaire parlementaire au leader à la Chambre.
Well, Mr. Speaker, in my presentation, I could have talked about the many different uses of the notwithstanding clause, and to go through and start itemizing, and then I would be criticized for provincial autonomy. I respect that the provinces do have the ability and should have the ability to access and invoke the notwithstanding clause. My primary concern in regards to this issue is the potential of just every 4.5 years, 5 years, automatically hitting the renewal button. And by doing that, I think, I'm interested in what the Supreme Court of Canada has to say on it. I think it diminishes the Canadian Charter of Rights and Freedoms.
Questions et commentaires. Le whip en chef.
The Bloc whip. Thank you, Mr. Speaker. I'm happy to have this opportunity because I love asking questions to the member for Winnipeg North. This is a reaction more than a question because I was in the hallway in the lobby and I heard him saying that it was a separatist party that was proposing this, and he's right. But we defend Quebec's interests because Canada doesn't do a good enough job of it. As the Green Party member said, perhaps the member should listen to what we have to say because we're much more constructive than destructive. We don't want to break up Canada. We want to build Quebec up. It's very different. We want to take charge and develop our own destinies as an independent nation. I'd like him to think about this as he goes to bed tonight.
Parlementaire au leader à la Chambre.
Yes, Mr. Speaker, I want to build up the prairies because I believe that it can make Canada stronger and healthier. I want the province of Quebec to be built up. I advocated, and where I take exception to the member's comments, is to try to give the false impression that the federal government doesn't do what it is that he's trying to imply. We have the 5 major projects. The Port of Montreal will benefit immensely because of the passage of C5, which, by the way, the Bloc opposed. But that particular project is going to create literally hundreds, going into thousands of jobs for people in the Montreal area, but all of Canada will benefit. We all have a responsibility to advocate the strengths of our provinces, our regions, in order to build a stronger, healthier Canada.
Questions et commentaires. Questions and comments. Le député.
The honourable member for La Pointe de l'Île. I'd like to ask my colleague a question. Why does he think no Quebec government signed the Constitution of 1982 and with the Charter as part of it? The Honourable Parliamentary Secretary.
Mr. Speaker, I have some personal thoughts on that issue, and maybe one of these days when I attempt to go and visit where my ancestors grew up in St. Ours, Quebec, maybe the member will join me at a coffee there, and we can talk about it. That's not what today's debate is about, nor is it about singling out any specific province. It is a constitutional issue, an obligation in which the Minister, Canada's Attorney General, has a fiduciary responsibility to fulfill.
Reprise de débat.
Resuming debate. The Bloc whip. Thank you very much, Mr. Speaker, and thank you to everyone here. And above all, thanks to the people who are listening to the arguments being made today. Not everyone's listening. Some have their lines drafted in advance, and they have the nerve to tell us that they're working for Quebec's interest. But it's a bit surreal. At the outset, I'd like to say that I'll be sharing my time with my esteemed colleague from La Pointe de l'Île, who will shake this place up with their speech. So I'm going to summarize because, as I said, people aren't really listening here. So the members opposite are saying that the courts are independent, but they're using our money to fight our laws that we passed legitimately with our parliament, with our National Assembly in Quebec City. And then they say, well, the courts are independent. Get real. Back off, withdraw your ridiculous factum, and stop using the courts, stop weaponizing the courts, because that's what's happening here. They're weaponizing the courts with our money. We are sick and tired. Let us manage our own affairs. Every time the Quebec nation manages itself and runs its own institutions in our own way. Today we've been talking about the Constitution Act of 1982 that was signed behind our backs on the night of the Long Knives. And half of the people here wouldn't be able to believe this could happen in a democracy, but at the same time they claim this is the best country in the world. It takes some nerve to say these things. So this isn't the first time we've raised this in Parliament. We brought a motion previously saying that the government of Quebec is fully entitled to use the notwithstanding clause. We're using a clause from the Constitution that you created and forced on us. It's always been validated, and if you don't like that clause, well, open up the Constitution. But I don't think they'll do that, Mr. Speaker. And do you know why? Because they don't have the guts. They know it's impossible to get all provinces to buy in and to sign off on that. It's not just Quebec. I'll remind you, back in the 90s, the Meech Lake Accord, there wasn't that much in the Meech Lake Accord. It was almost a humiliating minimum, and it was rejected because it was felt that it was too much. And then there was another attempt with the Charlottetown Accord, and it was even more ridiculous. Quebecers voted against it because there wasn't enough in it, and Canadians voted against it because there was too much in it for their liking. And so that's the situation with the Canadian Constitution. That's the situation with the Canadian Confederation. So today, this is an attack on secularism. That's what we're up in arms about. It's hypocritical because they're saying you're using the notwithstanding clause too often. Well, what led to all this? Well, it was the secularism bill. And the Quebec difference, the uniqueness, the distinctiveness of Quebec. It's our different way of seeing society in the world. Yes, we want to integrate people who come to Quebec. We want them to be full-fledged members of society. We don't want people breaking up into separate ghettos. We want to form a community, and we want to enrich Quebec culture with the cultures of newcomers. That's why we practice interculturalism, not multiculturalism. But they don't get it. They don't understand. It doesn't fit in their model. And so they want to crush it by any means possible. They want to crush us. That's what's so dramatic about today. The fact that the members opposite don't get it. They don't understand a thing. We are here as a constructive force, not destructive. I think we're quite constructive. We're quite nice. We're about the only people here who want to respect this Constitution that we didn't even sign.
Other political parties here want to further meddle with provinces' jurisdiction. Well, let's take a step back for a few minutes. Let's give this some thought. People should think twice before calling the Bloc Québécois troublemakers. We're here to defend Quebecers and the best interests of Quebec. That's what we're here to do. Days like today are absolutely not a waste of time. We are informing Canadians, Quebecers, and this House of the awful action that this government is taking to crush Quebec and Quebecers. This might sound shocking, but this is shocking. It's really snooty. The government thinks they know best. They say, oh, this bloc, they're separatists. The notwithstanding clause was already ruled on through the Ford ruling in '88. And it's all very clear. As long as we follow the text of the Constitution, then we are following the law. That's not how it works. Judges don't say, oh, well, you know, they've used this section 4 or 5 times. That's excessive. We're going to change it. We like it this time. We don't like it this time. No, judges apply the law. Just leave us be and let us have the law as it is and have courts apply it the right way. Now, with all this, Mr. Speaker, it shouldn't come as no surprise that we want independence for Quebec, because the situation is insane. And speaking of totally insane, have you seen the federal government's factum, Mr. Speaker, the factum that they filed? It mentions that we might have slavery and get rid of unions and forced labor. This is unreal. I can't believe I'm even saying these things in Parliament. When I read it, I said to myself, there's no way that they would actually write this. They're making a mockery of us. No, but they actually wrote that. Then Canada says, we're the best country in the world, so you should just stick with us. Now, I want to explain secularism again because some don't understand what it is. It is not discriminatory. In fact, it is the model that most respects individual differences, because when all individuals under secularism receive services from the states, they receive those services from a neutral person. Canada does things the opposite way. They prioritize the rights of the worker. They say the worker has the right to wear their visible religious signs. And everyone I serve today, maybe I'll serve 25 people. I'll offer services to 25 people, and they'll all see my religious symbols. It might not bother everyone, but it might bother some people. That's what secularism is all about. It's about protecting personal beliefs and enabling people to practice their religion at home as they wish. The government's factum is totally nuts, Mr. Speaker. It makes no sense at all. Now, 10 minutes can seem very long or can feel very quick. Sometimes 10 minutes feels very long when we listen to the parliamentary secretary there, but when we're the ones speaking, 10 minutes can fly by very quickly. Now, in 1763, through the Royal Proclamation, Canada wanted to assimilate us. Then in 1814, after the War of 1812, we were used as a gift, but then the Loyalists arrived. Later on, they separated the territory. They created democratic institutions. They said, oh, the French people, they don't even know how to do democracy. Oh, but we were excellent. We were so excellent that once again, in 1840, they tried to squash us. They took away our democratic powers, and they tried to make us pay other people's debt. Then there were Baldwin and La Fontaine to save the furniture and preserve and protect the French language. Canada didn't like that, so they wanted us to believe that we would create a confederation, but actually what it was a federation, and then slowly but surely we'll pass this measure and that measure to squash them, to make them disappear. And today is yet another measure taken to try to diminish our power, to diminish us. But that's a very negative way to build Canadian identity. Quebec wants to continue to exist, and they're trying to quash us through multiculturalism. So the bottom line is, let us make our own decisions. Thank you. Questions and comments? The Honourable Parliamentary Secretary to the Government House Leader.
That the member made reference to himself. He talked about the issue of labor and kind of ridicules the government, saying, well, why would you include that as an example? You know, if you take a look at the usage of the notwithstanding clause and who has actually used it, you will see that labor was a part of it. Does the member not recognize that having the Attorney General of Canada express an interest in terms of how the notwithstanding clauses could be used repetitively might actually affect the Charter of Rights? Is that not a serious issue?
Le whip en chef du Bloc québécois.
The Honourable Bloc Québécois Deputy Whip. Thank you, Mr. Speaker. Here is my answer. I disagree with the fact that the Attorney General of Canada would accept that Quebec might do away with individual rights, allow summary executions, and take away all legal recourse. I am speaking out against that. And this government, rather than having the courage to reopen the Constitution, and we respect the Constitution, I'd like to remind everyone that, but the government doesn't want to reopen the Constitution because they know that we would have other requests for changes. So instead, they're trying to do this through the courts, and we don't accept it, Mr. Speaker. Questions and comments, the Honourable Member for Rimouski, La Matapédia. Thank you very much, Mr. Speaker, and I thank my colleague for his speech. Today, we've heard the Liberals repeat many times that they want to defend the Charter. But the 1982 repatriation was done by Pierre Elliott Trudeau. In Quebec, our motto is Je me souviens, we remember. What do the Charter and the repatriated Constitution say? They said that we should not fear the notwithstanding clause because elected officials will always have the final word. The courts will not have the final word. How does the member for Berthier-Masquinongé feel about that historical reference? The Honourable Bloc Québécois Deputy Whip. Thank you, Mr. Speaker. My colleague invoked the Charter many times. They say they want to protect the Charter. That's all well and good, but when they applied it and adopted it, they did not ask for our opinion. They did it without us. They went around us. But had they included us, we would have told them that their charter was missing a chapter about provincial independence and collective solidarity. And I might be teaching members something today by saying that Quebec is ahead of Canada once again because we adopted our Charter of Rights and Freedoms in 1975. Before Canada did so, we also have a notwithstanding clause in our Charter because that's what the notwithstanding clause is for. It's because we can't always predict everything that is to come. The Honourable Member for Bourassa. Thank you, Mr. Speaker. I listened closely to my Bloc Québécois colleague's speech. He mentioned secularism. One of the main reasons I chose to settle in Canada, and especially in Quebec, was secularism. But there is a difference between secularism and a similar concept in which culture is forced. So here's my question. How can services be diminished if a teacher, a nurse is wearing a kippah or a burqa? Some people are allowed to wear a cross if you can't see it, but since kippahs and other signs are so visible, what's the difference though? Through the Speaker, I won't answer the question, but the Deputy Whip of the Bloc Québécois will answer. Well, I'd love to hear your answer, but I'll answer. Why does the federal government want to meddle with this? If the member chose Quebec because he liked our model, he could have run in Quebec. Here is a quick parallel that I'd like to draw. I was a high school teacher before becoming a member of Parliament, Mr. Speaker, and then I was president of the Bloc Québécois, the Parti Québécois, but when I had those political roles, I didn't wear Bloc Québécois or Parti Québécois pins or signs to school when I went to teach. That's neutrality. That is the model of neutrality for all state-provided services. Order pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Peace River Westlock, Oil and Gas Industry. The Honourable Member for Swift, Current, Grassland, Kindersley, Agriculture and Agri-Food. And the Honourable Member for Calgary Crowfoot, Natural Resources. Resuming debate, the Honourable Member for La Pointe de l'Île. Thank you, Mr. Speaker. Quebecers are deeply attached to state secularism. The first claims for this were the Patriots in 1737 and 38. They wanted freedom of conscience and a strict separation between the state and the church. Secularism was one of the drivers of the modern nation of Quebec as we know it today. Quebec has a unique history. In our history, the Catholic Church was very present and they controlled many institutions. Modern Quebec was born of questioning that model and that religious control. After our Parent Commission, we started asking Catholic teachers to no longer wear religious symbols. We didn't legislate, we just asked people to do so, and they followed the request. Then we removed religion from our school boards, the Catholic and Protestant school boards, and now secularism in Quebec applies to all religions. Legislation similar to Quebec's Act has been found constitutional and acceptable by many courts in the world, including the Europe's highest court of justice, which is viewed as being the court which built human rights as we know them. They say that being unable to wear religious symbols and signs in schools is not an affront to freedom of religion. And in countries like Austria and Denmark, they banned the full burqa in public or being fully covered. Quebec is a minority in Canada. We are a national minority. But we are not recognized as such by most of English Canada. Let's take the Official Languages Act. Starting in 1969, under Pierre Elliott Trudeau, the Official Languages Act defended the principle that English speakers are a minority in Quebec. Even though Quebecers underwent 200 years of British colonial domination and then domination by English Canada, in fact, institutions until the 60s in Quebec and for Francophones were largely underfunded. Then the Canadian government imposed on us the Official Languages Act. So rather than trying to correct the historical wrongdoing of 200 years of underfunding, the government here in Ottawa decided to exclusively support English and English schools, English in public services in areas which are under Quebec's provincial jurisdiction. There's the rub. Quebecers are part of a minority. Quebecers make up 90% of the Francophone minority in Canada. The Charter says that it wishes to protect the minority against oppression by the majority, yet they did the opposite. They followed the opposite principle for the French-speaking minority in Canada. Canada is a plurinational state. We have First Nations, the Inuit, Acadians, Francophone communities, which came from French Canada, including Quebec. There's also English Canada. That's plurinationalism. Now, we saw a very telling demonstration of that. Anglophones are not simply a minority in one province. They are part of a majority in Canada. In 1982, a constitution and a charter were imposed on us to weaken our language. That constitution remains to this day Canada's constitution because no representative of Quebec signed it. Federally appointed judges have dismantled or tried to dismantle Quebec's language charter. Some say that the Supreme Court is like the Leaning Tower of Pisa because it always leans to the same side. This is what we're experiencing. And if we don't learn from history, history repeats itself. Professor Henry Brun said that the superior judicial power is federal through appointment of judges. Robert Lickey from McGill was recently appointed by Justin Trudeau, and his appointment was confirmed by the current Prime Minister, and he stands against the French language charter. And he said that judges appointed by Ottawa are guided by the Canadian Charter of Rights and Freedoms. So Quebec's Charter of Rights and Freedoms cannot be interpreted differently from how the Canadian Charter of Rights and Freedoms is interpreted. This just goes to show that the Canadian Charter of Rights and Freedoms is in line with trying to make everything uniform and consistent. They are trying to make everything identical, and also they're trying to have a judiciary government. Let's not forget that, as we said earlier, the 1982 Constitution was passed one night just over there at the Chateau Laurier Hotel by 9 English Canadian provinces and the federal government after a long night of negotiation, which we refer to as the Night of the Long Knives, because Quebec was excluded from those negotiations on November 4th and 5th of 1981. So this notwithstanding clause did not come from Quebec. It originated from other provinces which wanted the Constitution to contain such a clause so that they could make their own decisions. The notwithstanding clause is an essential component of the democratic process. The Canadian Charter of Rights and Freedoms included a notwithstanding clause, as does Quebec's charter and also the charters of Saskatchewan and Alberta, which precede the Canadian Charter.
Even Trudeau Sr. admitted that the notwithstanding clause is a way for federal and provincial governments to ensure that elected representatives of the people, rather than the courts, would have the final say. So after the constitutional coup of 1982, René Lévesque used the notwithstanding clause for all laws in Quebec. And today, it is used in 41 laws, not just the laicity law in Quebec. Other laws, such as small claims court laws as well, include it. So it's interesting that Ottawa has never challenged the use of the notwithstanding clause for those laws, only for secularism. And for the current Prime Minister, as for Justin Trudeau, they're saying this clause is too much, and he would like to further diminish Quebec's self-determination. The Prime Minister asserts that the notwithstanding clause should never be used preemptively, so we should just be adopting laws that are shot down by various levels of courts and then the Supreme Court, and then go back and then use the notwithstanding clause. Imagine small claims court. They would use the notwithstanding clause because, well, I imagine all the cases that would be involved. So all, in short, they're denouncing the use of the courts for, we're denouncing the use of the courts for political reasons. And why are we talking about this now? Because the federal government is intervening with our money to challenge our laws. It shows that while Quebec is part of Canada, we have to fight in this unequal battle with the Canadian majority. So the only way forward for Quebec is simple, is to become an independent country. Thank you. Questions and comments? The Honourable Member for Bourassa. Thank you, Mr. Speaker. I admire the eloquent speech of the Bloc member, and I also admire the image he chose with the Leaning Tower of Pisa. Well, I'll ask a similar question. Does he not find that the Bloc is also like the Leaning Tower because it always leans towards the majority, even though they should be protecting the rights of minorities. And I've never really see him or his other colleagues talk about minorities and their problems with immigration. Can they at least explain how he could also defend the rights of minorities with these elements in mind? Thank you. Member for Pointe-à-L'Île. I'd like to thank my colleague. He has just shown that they really didn't listen to my speech because I talked about minorities. Quebec is a plurinational state, and the charter is supposed to prevent the minorities from the majority, except for the national Quebec majority. I don't think Quebec is a majority province in Canada. He cannot deny that. We're not recognized as a minority, but they want to recognize us as some type of mean majority that wants to continue to live in French. Wow, how incredible. We should learn English, anglicize our society. Quebec, no, is a minority, has a right to exist. The Quebec people has a right to exist with its language, with its values, just like the First Nations do and other minorities. Thank you. Questions and comments? The Honourable Member for Mirabel.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I'd like to denounce the insulting comments from the member for Winnipeg North earlier. He said if we were not didn't agree with the Liberals, we didn't have a place here. There are some who have values and others who don't, and he's trying to school us on democracy. And if he doesn't think the Bloc has its place here, does he not to defend the consensus of the National Assembly? And what does he tell the Quebec members that are elected on the other side that day after day, week after week, rise to vote against unanimous motions of the 125 members that represent the National Parliament of Quebec, that are a member for La Pointe-à-L'Île? What do I say to that? Well, I agree entirely, and I would continue to talk about minorities. They're important. Quebec is probably one of the states that respects its minorities the most. And the problem is that, unfortunately, we are subject to the majority in our country, and we are subject to languages such as the OLA, the Official Languages Act. And secularism is recognized as legitimate, such as the banning of religious symbols, such as those who represent the state in a position of authority. And that is one of the conclusions of the Richard Taylor conclusion that was set up by Jean Charest. And all of this debate was caused by a Supreme Court decision. So we shouldn't confuse things. Questions and comments? The Honourable Member for Bourassa. I don't want to confuse things, but I really want to be specific. I'd like to get an answer, Mr. Speaker. When I talk about minorities, I'm also a Quebecer, and I represent Quebec here. And I think I was talking about minorities within Quebec in terms of the majority. The values, what values are they talking about? Are these values are set out by the majority, or are these values based on diversity and the wealth of the people who immigrate to Quebec? And here's my question, because here we represent the province of Quebec, Mr. Speaker. Well, we do have diversity, Quebec women, people who are of ethnic origins, and also on the other side, how many people of ethnic origins will represent the Bloc? The Honourable Member. I'd like to remind my colleague, one of the first Black members that was elected to this House was with the Bloc. And one of the problems that we have is that the Anglicization of Montreal is caused by the Montreal government. So it means I'm one of the only members from the Bloc that lives in Montreal in the region, and I know a lot of people who are immigrants who run and who agree with us that we really have to fight to defend French in Quebec. And I have to interrupt the member. Resuming debate, the Honourable Member for Quebec Centre. Thank you very much, Mr. Speaker. I'll be sharing my time with the member for Bourassa. I rise today to oppose my colleague's motion, the motion of the bloc. And first, I'd like to congratulate and thank my bloc for their many perspectives on this issue. The use of Section 33 of the Canadian Charter of Rights and Freedoms, commonly known as the Notwithstanding Clause, is, of course, an important issue that affects all Canadians, including Quebecers. Like Ban Ki-moon, the former Secretary General of the United Nations, protecting the rights of minorities is protecting everyone's dignity. Quebecers and other Canadians expect their government, all governments, to protect their rights and freedoms. And with this in mind, I think it's perfectly legitimate and reasonable and responsible for the Attorney General of Canada to provide their advice in terms of the evolution of Canadian jurisprudence. Mr. Speaker, first, I think it's important to briefly review the comments made by some of the political leaders who were involved in the negotiations surrounding the Charter. This will allow us to see that for many of them, the Notwithstanding Clause was an exceptional tool of last resort. I would also like to take this opportunity to point out that the Charter is structured in a way as to allow the government and Parliament to pursue important political policies, as long as achieving these objectives does not disproportionately restrict the rights and freedoms of Canadians. So this fair balance between individual rights and collective interests contributes, in fact, to the strengthening of our democracy, the development of our society, and the well-being of all people in Canada. When a legislator invokes Section 33 of the Charter, the courts cannot strike down the law, even if it unjustifiably restricts Sections 2 and 7 to 15 of the Charter. It is therefore an extraordinary power. Nevertheless, Mr. Speaker, it must be noted that more recent provincial uses of the Notwithstanding Clause seem sometimes to deviate from the original intent of Section 33. For example, in the view of the then Attorney General of Ontario, Mr. Roy McCurty, the Notwithstanding Clause was an exceptional tool that might be necessary if a court rendered a decision that was clearly contrary to public policy. And the then Premier of Saskatchewan, Mr. Alan Bucklenny, explained in an article published in 2010 that he believed the Notwithstanding Clause might be necessary in the event that a court rendered a decision that would have a negative impact on rights that are not protected in the Charter, particularly socioeconomic rights. So, Mr. Speaker, in the eyes of many political leaders at the time, the Notwithstanding Clause was seen as an exceptional tool of last resort and to be invoked with caution. It was not designed with the intent of undermining systematically the very purpose of the Charter, which is to respect fundamental rights and freedoms, and even less so with a view to circumventing the courts before they have the opportunity to rule on the constitutionality of the law in question. Section 33 of the Charter certainly allows for the preservation of a certain form of parliamentary supremacy. At the same time, the Notwithstanding Clause must not be considered in isolation. It must be so in the light of the Constitution as a whole, of which it is an integral part. In any event, it's now been 43 years since the Charter was adopted, and the concerns that some of those involved in the repatriation of the Constitution and the enshrinement of the Charter may have had, rightly or wrongly, have largely been dispelled over time. The courts have certainly interpreted rights and freedoms, including those guaranteed in Sections 2 and 7 to 15 of the Charter, generously, as they do for Quebec's Charter of Human Rights and Freedoms. But they also have, as permitted by Section 1 of the Charter, maintained reasonable limits on these rights when a government has been able to demonstrate that the public interest justified them. And this brings me to a brief discussion on the architecture of the Charter. The Charter is not intended to unduly impede government action. The government and the Parliament have successfully advanced several major public policies for the benefit of Canadians in areas such as health, the environment, immigration, and public safety, while still respecting the rights and freedoms guaranteed by the Charter. In addition to Section 1 of the Charter, other provisions of the Charter allow for the restriction of rights and freedoms as long as the state acts responsibly. Yes, rights and freedoms are not absolute and must sometimes be balanced against social imperatives and economic imperatives. Take, for example, Section 7 of the Charter. This provision states that everyone has the right to life, liberty, and security of the person, and that the state may only infringe upon these rights in a manner consistent with the principles of fundamental justice. This means that the rights to life, liberty, and security of the person are not absolute. Limitations are permitted as long as they respect certain fundamental principles of a free and democratic society. The government, in particular, may not act in an arbitrary, excessive, or procedurally unfair manner. It would be excessive, for example, to imprison Canadians for minor offenses. On the other hand, the possibility of imprisonment for more serious crimes is entirely justified. It is this proportionate balance between individual rights on the one hand and public interest objectives on the other that the courts engage in when applying Section 7 of the Charter. This section constrains government action, but in a measured way. Mr. Speaker, this shows that the Charter is not an obstacle to government action, but a safeguard against arbitrary and discriminatory government action. It exists to prevent abuse and excess by forcing the government and Parliament to ensure that the laws to which Canadians are subject do not infringe on their rights beyond what is truly necessary to achieve important public policy objectives. This way of governing can only enrich our democracy, and this is why successive federal governments have succeeded in governing without exempting their laws from the application of the Charter. And this is a record of which Canadians can be proud. Thank you, Mr. Speaker. Questions and comments? The Honourable Member from Mirabel. Mr. Speaker, I have two elements to my question. First, my colleague from Bourassa mentioned that in his view, the Quebec Parliament, like the leading care of PISA, always leans towards the rights of minorities. What does he think of this opinion? And does it also apply to Bill 21? The member for Quebec Centre says that the use of the notwithstanding clause should be exceptional, and they will use it more than before. But the René Lévesque government, after 1982, used it systematically in each of its laws. So I'd like to know, how does my colleague define the word exceptional? The Honourable Member for Quebec Centre. Mr. Speaker, there are several questions there in that question. Well, I'll allow my colleague from Bourassa, who is very exceptional, to answer the question that pertains to him. But for the rest, it's a question of balance between our individual rights and the objectives, collective and economic objectives, social objectives of the government. The Charter is there to help independent judiciary powers to strike a fair balance between individual rights and society and economic values. Thank you. Questions and comments? The member for Bourassa. Quite simply, a question from my colleague. They do have a nice architecture and balance with respect to the angle that the Charter should take, and I congratulate him for this work. But my question is simple. Can he give us at least an idea of how this notwithstanding clause can also hamper the interests of minorities in Quebec and the freedom of expression and freedom of religion as well. And I'd also like to ask my colleague a question. When I was talking about the Leaning Tower of Pisa, and I was talking about the Bloc Québécois and not the Quebec government or the Quebec Parliament. Thank you. The Honourable Member for Quebec Centre. My colleague raised an important point. Sometimes in this House and outside of it, we try to make Quebecers uniform and just talk about one opinion. No, but there are many identities and opinions, and we can't just say one party, perhaps because of its name, speaks on behalf of all Quebecers is a bit rich. There are many parties here that represent the government of Quebec and Quebecers, and we have the duty and the rights as Liberals and Quebecers to show the diversity of opinions that exist in Quebec. Questions and comments? The Honourable Member for Rimouski-Matapédia. Thank you, Mr. Speaker. I heard my colleague's speech from Quebec Centre, and we understand he has a position, and also on the deplorable statement from the member of Bourassa. But let's go back to what he said. He talked about a balance. Let's talk about this balance. The notwithstanding clause was used over the past 43 years more than 100 times, and it has never over the past 43 years, has the government, the federal government, thought that it was necessary or justifiable to seek the Supreme Court's decision on its use. And this is the very legacy of Pierre Elliott Trudeau. And it's thanks to the notwithstanding clause that the charter was able to be established with the repatriation in 1982. So I'd like, with all this confusion, to my colleague to explain this balance, because we've had something in place for 43 years and used more than 100 times, and now they think it's necessary and useful to ask the Supreme Court to give its decision.
Quebec Centre.
The Honourable Member for Quebec Centre. Two things, briefly, Mr. Speaker. Perhaps it's overdue. Perhaps it took too long. Maybe 43 years was too long for the Supreme Court to rule on this important issue. The second thing is, it's not the Government of Canada that brought this case to the Supreme Court of Canada. It's Quebecers and Quebec organizations that are behind this appeal to the Supreme Court of Canada. The Government of Canada, it didn't make this up. It was Quebecers who, rightly or wrongly, felt that this should be taken all the way to the Supreme Court. And they want to know whether the acts enacted in Quebec or elsewhere can routinely invoke the notwithstanding clause. And when you look at the Attorney General of Canada's factum, I can see, maybe I'll be able to answer this on another occasion. Resuming debate, the Honourable Member for Bourassa.
Merci beaucoup.
Thank you very much, Mr. Speaker. I rise today to raise a fundamental issue, the question of defending rights and freedoms in the Canadian Charter. Since 1982, this Charter has not just been a legal document, but also a symbol of our identity and our democracy.
Charter not only as a law, but as a living guarantee that protects everyone, regardless of their origin, their faith, or background. La Charte comme fondement.
The Charter is at the foundation of our democracy. It has become an essential bulwark against arbitrariness, and it's a source of protection for all Canadians. Polls show that more than 80% of Canadians believe the Charter has been beneficial to our country. In Quebec, too, a large majority recognize its importance.
South Africa and New Zealand have looked to Canada's Charter when drafting their own bills of rights. Laissez-moi vous dire aussi.
Allow me also to say today, as a Quebecer, that the notwithstanding clause is a dangerous tool. Let me explain. Section 33, known as the notwithstanding clause, allows certain fundamental rights to be suspended: freedom of religion, freedom of expression, the right to equality, and the right to a fair trial. These rights go to the very heart of our democracy. Suspending these protections undermines the foundations of our society. The notwithstanding clause may appear technical, but its impact is very real.
It's allow governments to bypass the courts and silence minority voices. That is why its use must remain exceptional. La liberté de
Freedom of religion, Mr. Speaker, is a test for our democracy. Freedom of religion, guaranteed in Section 2A, protects the right to believe or not to believe, but also the right to express one's faith openly and without fear. It allows everyone, whether they go to a mosque, a church, a synagogue, or a temple, it allows them to express their faith with dignity. Restricting this freedom through the use of the notwithstanding clause sends the message that religious minorities can be marginalized according to the political choices of the majority. And that's where we need to be careful, Mr. Speaker, and draw a clear distinction between secularism and what the Bloc is proposing. They say that we are the ones who know what Quebec values are. We are going to establish what Quebec values are. It's the French language, yes, but it's also diversity. The wealth of diversity that we have, that's a Quebec value. That is Quebec culture, Mr. Speaker. I'd like to come back to freedom of religion.
It includes the rights to wear symbols of faith in public life. In Canada, multiculturalism is not an abstract principle. It is a lived reality, and religion's diversity is at its core. Monsieur le Président, il y a d'autres...
Mr. Speaker, there are other rights at stake in connection with the notwithstanding clause that it may involve freedom of expression, freedom of the press, which are essential for informing citizens and holding governments accountable. There's also the right to life, liberty, and security under Section 7, which protects against arbitrary interference by government. The right to protection against unreasonable searches, Section 8, guaranteeing respect for privacy. The right to equality, Section 15, which prohibits discrimination based on religion, sex, sexual orientation, origin, or disability.
When one group's rights are suspended, all Canadians are weakened. Democracy is not only about majority rule, it is about protecting minorities as well.
It's a question of principle, Mr. Speaker. As Martin Luther King reminded us in his letter from Birmingham jail, injustice anywhere is a threat to justice everywhere, Mr. Speaker. Our duty as legislators is to protect the Charter as a whole, without choosing which rights are most convenient to defend, depending on the circumstances.
Steadfast respect for Charter rights without resorting to Section 33 benefits all Canadians, strengthens our democracy, and uphold the rules of law. Le respect des droits et libertés, Monsieur le Président, garantit.
Respect for the rights and freedoms guaranteed by the Charter, Mr. Speaker, is not just an abstract principle. It's a concrete responsibility to all our fellow citizens. To abandon these protections is to weaken our democracy. To defend them is to strengthen the trust, diversity, and unity of our country. Mr. Speaker, Quebec chose 44 members, men, women, from diverse backgrounds, a very high number of women, and a very diverse group which represent the people of Quebec. So, Mr. Speaker, I think that here on the Liberal side, we have the right to represent Quebec culture, to represent Quebec values, and above all, to respect and defend the right to freedom of Quebecers. Questions and comments? The Honourable Member for Quebec Centre. Thank you, Mr. Speaker. And I congratulate my colleague on his enthusiasm and his passion. I have a quote to read to him, and I'd like to know what he thinks about it. Alexis de Tocqueville said that nothing is more dangerous than the appetite for the majority to oppress the minority. What does he think of that? The Honourable Member for Bourassa. That's a beautiful quote. Why? Because I think that protecting minorities is a super important principle, especially when there are fundamental rights, like when you're looking for a job, the right to a job. That's just an example, Mr. Speaker. Those in Quebec who are affected by unemployment, those who have the highest unemployment rate, are people from different ethnic backgrounds, people who, unfortunately, who don't have access to employability, unfortunately, because they wear a religious symbol, and I'm talking about women wearing veils. And so what the Bloc is proposing, will undermine the liberties and freedoms of everyone. The honourable member for Montcalm. Unlike many of his colleagues, the member for Bourassa didn't deal with the foundations of Bill 21, and I think that's brave. He's against that legislation, of course, even though it was democratically enacted by a majority in the National Assembly of Quebec. I don't know where he was in 1982, but I think what he forgot in the history of Quebec and Canada is that the minority is the people of Quebec. In 1982, our status as a language minority was usurped, and our status as a nation was usurped. So the minority he's referring to, the language minority, the Quebec language minority, is surrounded by 370 million Anglophones. Where's his minority? The honourable member for Bourassa. Thank you very much, Mr. Speaker. And as I was saying earlier, unfortunately, the Bloc, when they talk about they would have two levels of Quebecers. Before I came to Quebec, because I had the choice of going to another province, I chose Quebec. I chose to settle in Quebec because I believe in Quebec values. I believe in diversity. I believe in the French language, and that's why I chose Quebec. So there's not one Quebecer who's better than another. And that's my answer, Mr. Speaker.
Questions et commentaires.
Questions and comments?
Député de
the honourable member for La Pointe de l'Île. First of all, we never said that. We're all Quebecers. There's a diversity of opinion among Quebecers, I agree. But one example the Liberals often use, because they have a number of members from Quebec, but in 1982, when the Constitution was repatriated, there wasn't a single Quebec Liberal who voted against it, or there was one who had to resign afterwards. And so they didn't sign the Constitution, so how does he explain that? The honourable member for Bourassa. Once again, I am not going to be lectured by members opposite. To answer the question, I would just say, Mr. Speaker, that in our view, the Quebec value is the value of diversity. And when we here say that we represent Quebec, well, there's a mathematical equation. There are 44 members here representing Quebec, defending Quebec culture, defending Quebec values. And there are more of us. There are more men, more women, more diversity on our side of the House than on theirs. And we defend Quebec values and culture. Questions and comments? Honourable member for Richmond Hill.
The member mentioned some unemployment facing members in his community. So I'm just curious why this Liberal government is not addressing the unemployment crisis that are facing Canadians all across the country. We are faced with a youth unemployment crisis that economists are calling at recessionary levels. So why not address the crisis that this Liberal government has created instead of creating a national unity crisis to distract Canadians from the real problems?
The honourable member for Bourassa. In 30 seconds or less. First of all, our government is tackling unemployment, creating affordability, creating job opportunities, and creating strong communities. But first of all, perhaps there was a misunderstanding in the understanding of my message. In Quebec, a woman who wears a veil cannot teach. A woman who wears a veil, there are so many things that make it hard for her to get a job. And that's what we're defending here, the freedom of religion. Resuming debate, the honourable member for Mirabel. Thank you, Mr. Speaker. I'll be sharing my time with my colleague from Rimouski La Matapédia. Mr. Speaker, it's sad to have to rise today following the previous member after hearing that the supposedly honourable member, Mr. Speaker, in the context of a constitutional debate, to say that the Quebec was racist, not in so many words, and to say that the Bloc has systematically worked against minorities, after saying that 44 Liberal members are from Quebec, here in Ottawa, that's worth more than 125 members in the National Assembly. Mr. Speaker, this is serious. What he said was grave. He has the nerve to tell us these things, and he's basically saying that the unanimous 125 members in the National Assembly in Quebec City are worthless, meaningless. He's basically saying that the National Assembly is garbage. It's incredible, Mr. Speaker. But what's more, Mr. Speaker, for him to say that we don't represent Quebec's diversity in any way, well, I'm disgusted by that statement. Mr. Speaker, my wife was born in Algeria and she immigrated to Canada. In my house, we speak French, we speak Arabic, we have mixed origins. We are living interculturalism in my home, Mr. Speaker. And when a member opposite stands up with his contemptuous and insulting tone, pseudo-intellectual tone, tries to give us a life lesson as if everyone in the Bloc came from Saguenay and from the same sticks, Mr. Speaker, it's insulting. The notwithstanding clause has been used in 41 pieces of legislation, and in 41 cases, it was used to protect people's rights and to ensure that we're not forced to go to court to pay legal fees for the tiniest little things. Now, the member doesn't realize this because he's not towing the party line. The member for Bourassa should be different. Now, when we talk about a balance, that's understandable, but for him to say that the notwithstanding clause should be thrown out, well, I hope the Supreme Court will see it otherwise. Let's go back to 1982. That was a betrayal of history, a betrayal of a consensus and of a liberal tradition, a liberal consensus, a philosophical consensus, as conceived by Pierre Trudeau and Jean Chrétien. And he thinks it's all well and good. That's how he wins votes in his riding. He sows division. But he's hiding his interculturalism. He's saying that it's all well and good for our government in defending people's rights to go to court and say that Quebecers will be using the notwithstanding clause to reinstate a system of slavery. Now, we've seen a lot of Quebec bashing, but this is like a world record. I think we've hit a new low, but no, it's ever lower. So I would suggest that the members stop those accusations. That would never be tolerated. Now, it is true that sovereignists have in the past said some bad things and they've apologized for it. Everyone makes mistakes. Everyone can go too far. But when it comes for a Liberal, why is it tolerated? I take this as a personal insult to me, my family, and my vision of interculturalism. In a family where, in my house, there are people who left their country of origin to flee religious persecution. And you know what? Those people, like many other Quebecers, think that this should be debated in Quebec City in a civilized way. It's a call from the heart. I'm not even looking at what I've written here. I don't need to because I find it so hard and insulting what I've heard from the member opposite. Now, he was honest enough to say that his government is against the notwithstanding clause and that he was against that. The member for Winnipeg North, with his pseudo-intellectual approach, read us a bunch of articles, but at least the other member was honest and said what he thinks of the notwithstanding clause. But we know that a lot of Liberals think the same way. But now, because they can't rewrite the Constitution themselves single-handedly, they're going to ask the Supreme Court to rule in a preemptive way. But this clause was written so that it could be used preemptively. It's like saying, install an alarm system in your house, but only arm it when you want to catch somebody. So when there are debates, when things aren't going the way they like, suddenly they want the court to intervene. Now, there's been a huge debate in Quebec. This issue has been debated. The Superior Court ruled, and then the Court of Appeal, and and then it takes years and years, over 10 years, to get to the Supreme Court. And then when the Supreme Court sides with us, we'll think it's a good thing. Now, the only reality here today is that they don't like Bill 21. That's what's behind this. And they say that the notwithstanding clause, it has to be renewed every 5 years. You know, it's not permanent. So there already are safeguards around the notwithstanding clause's use. And what's completely absurd here is that the Liberals are acting as if we needed a big federal paternalistic figure to supervise us. And the member for Quebec Centre, the member for Bourassa, the member for Rosemont, La Petite Patrie, and the Bloc here, we're all Quebecers. And we have very lively debates. There are people who are uncomfortable with the debate around immigration in Quebec. But we debate things. We are capable of debating. We have civil society, we have journalists, we have a parliament. Mr. Speaker, there are some lively debates in Quebec that happen outside the federal bubble, where there are 44 Liberal members who say, we're worth more than 125 members in the National Assembly in Quebec City. And we will not hesitate when a gentleman from Winnipeg stands up to vote against Quebec, not against the Bloc. These are unanimous motions of the National Assembly we're talking about. And if a gentleman from Winnipeg says, let's vote against it, then the Quebec Liberals will follow suit. They'll vote along with the gentleman from Winnipeg. And they basically say, we represent no one here. Our presence here is pointless. Congratulations, Mr. Speaker. Congratulations on that. The notwithstanding clause is the fruit of a historic consensus. It's the result of some very deep Liberal thinking about democracy way back when. And the idea was that you can't always ultimately leave everything to the courts. That's what the notwithstanding clause is all about. And I'm sorry to use the member for Bourassa as an example, but I have to. He kind of got under my skin. So I know he doesn't believe we're going to bring back slavery. But he wins votes by calling us racists. He wins votes by suggesting that we don't care about other minorities, that we hate religion, and that we don't want women to be able to work. But I would encourage the member to think about that type of talk. When he talks about division, I would invite him to think about that type of talk.
Does everyone have to fully agree with Bill 93, Bill 101? No. And that's why we have a democracy. That's why we have elections. These are not easy issues. That's why at some point decisions need to be made. The clause is temporary. That's why we need to reuse it each time. And that's healthy. There are 44 Quebec Liberal MPs. I urge them to respect Quebec's parliament and Quebec's MNAs. They are also elected officials. They represent Quebec and Quebecers. We, the Bloc, bring to this House unanimous Quebec National Assembly motions. So it's not just us talking. We're speaking for Quebec. A reminder to the member for Mirabel, I listened very closely to comments. The member referenced papers he was holding in his hand. That's considered an accessory. We may not mention the texts we are holding in our hands or on our desks. So just a reminder, the member for Joliette. I think there was a misunderstanding. All that he wanted to say was that what he was saying was not a written text, but rather that he was responding to what had been said. I understand the member's point, but it did sound like a reference to documents. We need to remember the rules of this place. I know that the member has a lot of experience and he knows the rules. Rising on a point of order, the member for Mirabel. I wish to withdraw my papers. I thank the member for Mirabel for his understanding. Questions and comments? The member for Bourassa. Thank you, Mr. Speaker. I see that my comments may have shocked the members across the way. That was not my goal. My goal was to say that neither they nor we have exclusive say over Quebec and their interests. What I do agree with is that we need to debate. We need to debate this legislation and these issues. My colleague mentioned that things were imposed on them and there was no debate. We live in a free society, a free democratic society. Here is my question. There is a single parent in my riding. She has 3 children and she wears a hijab, but she cannot teach. What should we say to her? The Honourable Member for Mirabel. During the last election, we lost seats. That happens. We gain seats, we lose seats. It makes us humble. It humbles us, and that's my appeal to my colleague. When we arrive here and we are faced with a unanimous motion passed by the National Assembly, maybe one day a Quebec Liberal will table a National Assembly unanimous motion for this House to debate. But I've never seen that. I make a call for humility, an appeal for humility to all. Now, there is no law that has unanimous support in civil society. That's why we debate them from time to time. We pass new laws, we amend laws. We will have an election in Quebec, and I invite him to fight for what he believes in. Questions and comments, the Honourable Parliamentary Secretary to the Government House Leader.
Sensitive to when the member says that, the Quebec legislature, or Parliament, passed a motion unanimously. The passage of motions unanimously in provincial legislatures occur. In Manitoba, unanimous resolutions are passed. Is the member conceding that if any legislature in the province unanimously passes a motion, that should become national policy? Do I not represent Manitobans equally to the same degree as when I was actually an MLA for just under 20 years? I would argue that I do. And we have a national interest and you have provincial interests, and sometimes they might be a little different. Would he not agree that we are not in a position as members of Parliament to agree with every unanimous motion that passes every different provincial or territorial legislature?
Député de Mirabel.
The Honourable Member for Mirabel. If we were debating those motions, we might use our time more intelligently. I'd like my colleague to table in this House documents, journals, and debates the day when the nation of Manitoba was recognized. Well, that never occurred, whereas Quebec was recognized here as a nation. That's my first comment. Next, when the National Assembly passes unanimous motions and we bring them here, it's not because we want provincial politics to become federal politics. We need to be careful with these terms also. We do so because we want Quebec's will respected. The Parliamentary Secretary just doesn't seem to understand Quebec's situation and reality. Questions and comments. The Honourable Member for Joliette-Madawan. Thank you, Mr. Speaker. I sincerely congratulate my colleague on his passionate speech. Can he speak to notwithstanding clauses, which we could also call parliamentary sovereignty clauses. For instance, in the case of Bill 21, the Court of Appeal accepted preemptively invoking the notwithstanding clause. With the Ford ruling from the Supreme Court, what's unique is that it's requested that jurisprudence be reversed in this case, but it's all very clear. 15 seconds or less, the member from Mirabel. The Liberal Party, they're not Trumpists, but they're populist. They lack respect for parliamentary institutions, for democratic institutions, for the law, for constitution, for jurisprudence, and I think that must stop. Resume debate. The honourable member for Rimouski-Matapédia. Mr. Speaker, Ottawa invokes national unity when it's in their best interest, but as soon as Quebec asserts its differences and its choices, Ottawa becomes very paternalistic. We were called in as partners when there was an external threat from the United States, but then all of a sudden, Ottawa turned right back to doing what it usually does, undermining Quebec's institutions. Today, our debate is not about Bill 21. It is about the very core of our democracy. Ottawa wants to take away the notwithstanding clause, or at least make it useless. We tabled a motion in 2023. It said that the House call upon the government to let provinces decide for themselves how and when to use the notwithstanding clause. That motion did not call on the government to express its views on secularism or to support Bill 21. That motion in 2023 that we tabled it to call for respect for the notwithstanding clause and for provinces, but the Greens and other parties, they voted against it. Now, in the 1988 Ford ruling, the Supreme Court held that the National Assembly had the full right to invoke the notwithstanding clause and that they could do so preemptively without waiting for a ruling to be struck. The courts cannot judge the use of it. They can only judge how it's used, so certain modalities. It's very clear, and the courts were clear, that the notwithstanding clause belongs to provinces to use as they see fit. The notwithstanding clause is not a partisan whim. There is clear consensus since the Bouchard-Taylor Commission. All surveys and polls show that Quebecers, a clear majority of Quebecers, support this. This expresses the democratic will of the people of Quebec. Ottawa seeks to undermine our choices by attacking the tool which allows us to protect our choices, the notwithstanding clause. The factum filed at the Supreme Court on September 17th claims that using the notwithstanding clause could lead to bringing back slavery, banning newspapers, summary executions. Mr. Speaker, those are not real arguments. That's crazy. That's what the government thinks of Quebec and its elected officials, that they would pass crazy laws without Ottawa's supervision. The notwithstanding clause is what made it such that provinces agreed to the 1982 Constitution. Pierre Elliott Trudeau, then Liberal Prime Minister, had to include it to get provinces' support. It says in the Constitution that the people and elected officials will have the final say, not judges. The notwithstanding clause allows provinces to make their own decisions. But if a government uses the clause too often, then they'll pay the price come election time. Now, these same Liberals are trying to rip up what they implemented in 1982. Now, this government is carrying on the destructive and centralizing action of the Justin Trudeau Liberals. This is important for our language, for our identity, and for our society. Here are a few examples. Small claims court, access to justice for all, made possible by the Notwithstanding Clause. Also, the Employment Equity Act. Also, the Youth Courts Act. The protection of youth is guaranteed thanks to the Notwithstanding Clause. The Notwithstanding Clause is democracy in action, democracy at work. Make no mistake, this is not just Quebec which wants this. 5 provinces, Manitoba, Alberta, Saskatchewan, Ontario, and British Columbia, will make the same arguments before the Supreme Court. The Liberals are not just attacking Bill 21. They are taking aim at the parliamentary sovereignty of all provinces, and they're against secularism. Secularism isn't some crazy Quebecois whim. In France, Germany, Austria, Denmark, state secularism is legislated when it comes to visible religious signs. When it comes to secularism, Quebec is normal. Quebec is in line with other nations. Canada is the lone wolf and has been for a long time. It's always the same old story, repatriating the Constitution without us, the Meech and Charlottetown Accords, the legal challenge of Bill 101. Today, Bill 21, and soon Bill 96. Every time Quebec tries to take action, Ottawa puts roadblocks in our way. Here's a simple question. Who decides for Quebec? The National Assembly of Quebec and its MNAs elected by Quebecers, or the Supreme Court with Ottawa-appointed judges following a constitution that we never signed? Ottawa appoints judges. Quebec chooses its elected officials. As long as we are shackled, our goals will be fragile and open to being challenged. A clear solution would be national independence, not against Canada, but for Quebec. Independence is the peaceful expression of a people who wish to make their own decisions by themselves, for themselves. Lucien Bouchard said, Quebec is tired of always being told no. Every time we are told no, we will tell ourselves yes, yes to our destiny and future as a nation, Mr. Speaker.
The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And throughout the day, what I have found that we really need to look at in a very serious fashion is if we want to try to promote and encourage healthy debate on the issue, that we should be looking at it from a perspective that it's not all about Quebec. The Notwithstanding Clause is something, whether it's the Parliament of Canada, any other provincial or territorial jurisdiction. The Bloc insists to wanting to make it about Quebec when I believe it's not about Quebec. There are rights that are within the Canada Rights Charter of Rights and Freedoms, Mr. Speaker, that concern all Canadians, no matter what region of the nation it might be in. And I think that's where we should be focusing the debate. Should a province or the federal government be able to use the Notwithstanding Clause consistently as one is about to expire to extend, thereby marginalizing the potential effect of the Canada Rights and Freedoms?
The Honourable Member for Rimouski, La Matapédia. Thank you very much, Mr. Speaker. Of course, my colleague's question, well, he's on the wrong track because in my speech, I mentioned that this also involves other provinces. Other provinces throughout Canadian history have invoked the Notwithstanding Clause. And he should read the ruling which says that using the Notwithstanding Clause is not dangerous. And throughout history, the clause has been invoked in the case of over 100 laws since it was created 43 years ago. Now the government has tabled a factum, filed it with the Supreme Court because they're trying to attack our Bill 21. Here's the truth that the member doesn't want to say. The Liberal government is scared of losing political points. They don't want to lose political points by directly attacking Bill 21 head on. So they're doing it indirectly through the Supreme Court. So they can say, well, we are not challenging Bill 21. The court is. Questions and comments? The Honourable Member for Joliette-Manawan. Thank you, Mr. Speaker. And I thank my colleague. André Binet is a constitutional lawyer who wrote that the notwithstanding clause appeared in the Canadian Declaration of Rights passed by the John Diefenbaker government in 1960. He defends individual freedoms, but also strongly admires British institutions and parliamentary sovereignty, which comes from the original revolution 100 years before the French Revolution. What does my friend and colleague think of that? The Honourable Member for Rimouski-Lamatypédia. Thank you, Mr. Speaker. I thank my colleague for his questions. Here is even more proof. Canada, through its Diefenbaker Charter, had a notwithstanding clause. That was in the 60s, Mr. Speaker. The person who implemented the Charter integrated into it the clause. They disagree with Quebec's model today. They disagree with our language, our interculturalism model. They disagree with secularism. So now they're saying, well, let's change the rules. Let's go through the back door. Let's do this through the courts so that the courts can say that our bill is wrong. Let them grow a spine, show a bit of courage. If they want to reopen the Constitution, we're ready to do so, even though we never signed it. Questions and comments? The Honourable Member for Bourassa.
Thank you very much, Mr. Speaker. We've talked a lot about minorities, and we talk a lot about the court and the 125 elected officials in Quebec. But right now, what's happened, we have a minority in Quebec, and they have imposed this law on them. But they are the ones that are turning to the courts. And my question is simple. Do these people have the right to challenge this and to turn to the Canadian government to challenge it? The Honourable Member for Rimouski-Lamatypédia, 30 seconds. Mr. Speaker, I understand that my colleague from Bourassa is openly against this Secularism Act, and I'd like to read the answer. Secularism does not threaten religious minorities. It protects them all in the same way. This clause is set out in the Constitution, and the real danger is not secularism. It's the federal government that wants to prevent Quebec and the provinces from exerting its democratic rights. And I'd like to remind the member, secularism in Western law is put forward. It's only in Canada that's doing the opposite, and I'd like to remind him to listen to my speech. I named all of the countries that integrate principles of secularism.
Parliamentary Secretary to the Minister of Industry.
Thank you, Mr. Speaker. I'm very pleased to participate in this debate. I'll be sharing my time with the member for Ajax.
I appreciate the opportunity to speak to this block motion. I'll present my story a bit. As a child of the Charter and in our caucus, and I think on the other side, we have several members who are newly elected and who are children of the Charter. In my case, I'm someone who was born from immigrant parents from Egypt and England, and they came to Newfoundland in 1974, and then they lived in New Brunswick, and I'm the only and first child in my family to be born in Canada.
As part of that, being a child of the Charter and some of the values, I was 6 years old when the Charter was proclaimed. A lot of us on this side of the House were not party to the debates that were described in this House, but we were experienced the effects of that. And in particular, in my case, in my family's case, we enjoyed the language protections that were afforded in the Constitution based on previous fights, in particular the government of Louis Robichaud that brought forward in the 1960s establishing the equality of French and English in New Brunswick. And so being a child of the Charter, and there is other of my colleagues on this side of the House who had this benefit, I had the chance to go to an English language school with French language schools fully protected later through the Charter. But there was an effect that came from the Charter being in our lives. And one of the things that was important, that combined with the official languages of New Brunswick, was that in English language schools there was a priority on French language education and French immersion. Les étudiants francophones,
Francophone students, and particularly students who were Acadian, had their own schools who were properly protected by the Charter. But as Anglophones, where I lived, it was half Anglophone and half Anglophone, half Francophone. We had Anglophone school, and where French and the experience of the French fact in New Brunswick and in Canada was recognized.
Like some of my other colleagues on this side of the House, I think we took it upon ourselves to enjoy the fruits of this of the Charter, and to see ourselves reflected in this kind of new reality, this new set of values that was being experienced in Canada, a Canada of equal rights, a Canada where the march for rights continued year after year. We experienced this despite the fights that were happening and despite the very real wounds that were experienced in the fight of 1982 and in the fights previously. A number of us on this side of the House, and my colleague who's going to be speaking, I believe, came of age around the same time, and perhaps politically came of age around the same time. We experienced in the 80s, nous avons vu.
We saw on TV or at demonstrations and protests with our own leaders that the fight continued.
Or the Charlottetown Accord, we experienced these decades of constitutional challenges. Pour moi, je suis...
Well, for my part, I came to Quebec in 1993 to study at McGill, which was an interesting fact because we were able to study classes in French but answer in English. And that is when I took a class with Mr. Gustave Gagnon, and we read the briefs and the discoveries of Guy Rocher, and I noted that the member for Belleuil-Chambly did a very good speech about Mr. Rocher recently.
And I think, those of us on this side of the House who try to reach across the aisle, in that time I got a real understanding, I believe, or I was able to get a better understanding of what this constitutional battle was about. And the fact that, yes, we had Bill 101 that resulted in real gains on behalf of Quebecers, that we had this use of the notwithstanding clause that became sort of a serialized use of notwithstanding clause. And I remember in my engagements with this issue that this was a surprising thing to me, that as someone who understood the Charter in a certain context and that the notwithstanding clause had a certain role, it was a surprise to me that it was being used in this way. But at the same time, à la même temps que...
While the notwithstanding clause was being used by the Quebec government, and particularly a liberal provincial government, the Charter and the Constitution continued to evolve.
Became one of those ways in which we could achieve this balance of parliamentary supremacy and the protection of rights. But despite the use of Section 1, there was an evolution, and there was an evolution towards more and more rights protection. There was an evolution towards the understanding of minority rights protections in particular. And in particular, the equality rights under Section 7, we discovered through the Charter interpretation through a variety of courts that this was about a slow expansion of rights to recognize groups that had not been previously explicitly enumerated in Section 7. Et je veux remarquer que
And I'd like to note that the expansion of rights through this legal interpretation was often because of protests, social movements that came from Quebec.
Movements in Quebec were key parts of the ways in which our understanding of the rights grew under Section 7 of the Constitution. And I'm thinking of collective bargaining rights, I'm thinking of rights, gender and sexual rights, all kinds of rights under some of the other freedoms that we understand, particularly under Section 7 and under Section 2. Those fights were fights that were led by Quebec social movements. And so again, when we have this understanding of this charter, notwithstanding, I think, the very important historical basis on which the Bloc, I think, has raised their concerns about the original implementation of the charter, we had this dialogue among different groups in Canada that allowed for us to discover and see the emergence of rights. And I think this is something that, in a very strict space of constitutional interpretation, which the deputy for the member from Quebec Centre, I think, explained very well. So where are we now? So we're now in a situation where we have a constitutional issue that's before the Supreme Court with lots of interest. 13 appellants, I understand, and more than 60 interveners. We have the use of the notwithstanding clause in a more aggressive fashion in a number of provinces, and including preemptively. You know, it doesn't take a lot necessarily to rise some members of this House, on this side of the aisle anyway, to attend a protest, but the use of the notwithstanding clause on Bill 124 in Ontario, which had a severe limit on collective bargaining rights, led me and perhaps led me to the lawn of Queen's Park to say that this was wrong. And the progress that we are making in terms of the rights that are guaranteed under the Charter faces a risk under the serial use of the notwithstanding clause. I'll be opposing this motion because on this side of the House, I believe we are the party of the Charter. We are the party for standing for Canada. I believe that if the shoe was on the other foot and the Government of Canada passed a law that said that tried to limit some of the rights that were felt to be in existence in Quebec, and that this Parliament threatened to or used the notwithstanding clause in that process, I would hope that the Government of Quebec would indeed present its litigation and not withdraw its memo as it is being asked for us by the Bloc. I believe that this Charter, I believe that this party on this side stands in the interest of continuing to advance rights, and that is why I'll be opposing this motion. Thank you.
Questions and comments. Question et commentaire.
Honourable Member for Joliette. Thank you, Mr. Speaker. I would sincerely like to congratulate the Honourable Parliamentary Secretary for his speech, which was presented in French, which I think was the first for him in this House, so I tip my hat to him. I also have the pleasure to sit with him at the industry committee, where we do very constructive work, in my view. And I really appreciated his experience that he explained for today's debate. I found this very interesting. But I would like to hear his reaction in terms of what Mr. Benoit Pelletier said, who is the constitutional professor at who lives in Quebec, who defends the importance of the notwithstanding clause. He said that this clause allows legislators to have, on some occasions, the last word about various political and societal issues, rather than leaving it up to the courts. What does the Honourable Parliamentary Secretary think of this? Thank you, Mr. Speaker. I appreciate the member for Joliette's comments. In my opinion, I think it's included in the factum that the Justice Minister tabled. What are the limits and the parameters that are reasonable with respect to the notwithstanding clause?
Clause is in the Charter. It is in the Constitution. I think the appropriate question is, what are the appropriate limits of this? And if you take the understanding of the Charter and the Constitution as a living tree, je sais pas si utiliser en...
I'm not sure if you use that in French, a living tree. The Constitution is a living tree. I get the feeling that the use of the notwithstanding clause serially that could threaten collective rights that we fought for. I have to interrupt the honourable member for another question.
Elgin St. Thomas, London South.
Thank you, Mr. Speaker, and I appreciate my honourable colleague opposite's thoughtful engagement on this issue. However, I have to point out the glaring question, which is that I have spoken to thousands and thousands of constituents, and not one single person has raised this issue as being their top priority. Now, the number of people that have said they are fed up with the way that crime has run rampant after the last 10 years of Liberal government is astronomical. The number of people that say they can't afford the cost of groceries and they want the government to get serious about that. The number of people who talk about the need to get serious about immigration and rein in what has become a reckless and dangerous approach to public policy. So I wonder, Mr. Speaker, why the Liberal government has decided to engage in this distraction, engaging in division, generating a national unity crisis and bordering on a constitutional crisis instead of tackling the issues Canadians are truly seeking them to act on.
The Honourable Parliamentary Secretary.
I thank the member for Elgin St. Thomas, London South, for the question. I think when you stand for rights, you have to stand for them when it's unpopular. You have to stand for rights when no one else is looking. And it may be the case that in the members of the residents of the honourable members' riding are not plugged into this issue, and that may be the case with the case for the residents of most of the ridings on this side of the aisle as well. The question is, are we going to be defending those rights? The question is this use of notwithstanding clause going to be normalized in a way that is concerning? And I think on this side of the House we have some concerns with that.
Questions and comments. The honourable member for Compton. 30 seconds. Thank you, Mr. Speaker. My colleague was cut off, even though he was making distinction between the use of the notwithstanding clause and the use of it preemptively. So I wanted to allow him to complete his thoughts on that. The Honourable Parliamentary Secretary. Thank you. That's exactly it. The preemptive use of the notwithstanding clause, like we saw in all democracies,
in a way that stops being exceptional, that's when the real concerns about what's happening in democracy are likely.
Resuming debate. La prise du débat. The Honourable Parliamentary Secretary to the Minister of Housing and Infrastructure.
Thank you, Mr. Speaker. I rise today to speak in response to a motion calling on the government to fully withdraw from litigation involving Bill 21. In effect, the motion would have this House agree that the Government of Canada, the government of all Canadians from coast to coast to coast, should not participate in one of the single most important constitutional appeals in recent memory before our Supreme Court. This appeal concerns Quebec legislation directly, certainly, but the legal issues it raises, in which the Attorney General of Canada addressed, are of overarching interest and concern the role of the importance of the Charter in our modern system of governance. At issue in the Supreme Court is what it means when Section 33 of the Charter is used by Parliament or a provincial legislature. Section 33 of the Charter, known as the Notwithstanding Clause, has never been used at the federal level. Today, I want to speak further about some of the less well understood ways that governing under the Charter supports good governance and better policies and laws. I do this to highlight the thoughtful and considered practices that may be at risk if the use of Section 33 is allowed to become more routine and less taboo. The main point I want to make today is that the Charter imposes an essential discipline on government policy development and lawmaking, a discipline that would be lost if resorting to Section 33 were to become normalized. Let me explain. The Charter is part of the Constitution, and the Constitution is the supreme law of the land. This means that every law and action of the government must be consistent with the Charter. As a country founded upon principles that include the rule of law, governments must take to heart the need to ensure that the actions they take and the laws they propose respect the Charter. Undoubtedly, governments prior to 1982 were mindful of the values fundamental to a free and democratic Canada, which were ultimately to be entrenched in the rights and freedoms guaranteed in the Charter. But after 1982, respecting those values became a matter of constitutional imperative. To be clear, respecting rights and freedoms does not mean never limiting them. The rights and freedoms guaranteed in the Charter are not absolute. The Charter expressly provides for limits in its all-important Section 1, which guarantees the rights and freedoms subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. What are these reasonable limits that can be imposed on Canadian rights and freedoms? In essence, the standard boils down to a deceptively simple set of questions. Is the government's objective sufficiently important to justify limiting a right? Is the limit a rational way to achieve that objective? In trying to achieve that objective, does the law use the option that causes the least harm to the right being limited? Finally, if the answer to each of these questions is yes, is the overall harm to the exercise or enjoyment of the right worth it when weighted against the benefits of the right's limiting measure? If so, then in Canada, we can consider such a limit to be reasonable. And assuming that a government is well armed with supporting evidence, logic, and reason, demonstrably justifiable as well. When potential impacts on Charter rights and freedoms are identified in the policy development process, governments need to carefully evaluate whether any limits on rights and freedoms are reasonable and can be demonstrably justified in Canada's free and democratic society. As I outlined, this requires asking a series of questions that ultimately go to the reasonableness of what is being considered. Let's take that first question, whether the government's objective in proposing a new law is sufficiently important to justify limiting a right or freedom. This can prevent governments from proposing trivial or merely symbolic laws that would limit rights and freedoms. The second question asks whether the proposed way of achieving the government's objective is rational, or in other words, is it the right tool for the job? This prevents reliance on, for example, common sense that may not, in fact, be well-founded or well-informed. Saying, for example, that public safety will be enhanced by doing a particular thing does not make it so, especially if the weight of evidence demonstrates that it is not the case. If we're being honest, the evidence-based solutions to some problems are counterintuitive, and governing with an attitude of respect for Charter rights and freedoms helps us to realize this and come up with better, more effective approaches. The third question asks whether there is another effective way to achieve important objectives while doing less harm to a right or freedom. Satisfying this standard means doing the homework on the different options available to advance a goal and choosing the reasonable one that does the least harm to Canada's fundamental values and Canadians whose rights and freedoms may be limited. Finally, the last question asks whether the benefits of a proposed law in furthering an important objective outweigh the harms to the exercise or enjoyment of the right or freedom. This is the ultimate cost-benefit assessment, and it is a fundamental one. This element of Section 1 standard prevents laws with marginal benefits that have real impact on Canadians' rights and freedoms. It does not tolerate laws that are dismissive of the rights and freedoms of people who may be unpopular, such as those charged or being punished for a crime, or laws that fail to properly value the negative effects on members of a minority group who have limited political power and weak or fleeting public sympathy. I think everyone can agree that the questions the Charter requires us to ask when considering a new law are good and proper ones. These questions and the answers to them are posed and assessed through the policy development process, from the initial discussion within the Department of Options to highlight a problem, through to Cabinet's consideration of the options, through to the drafting of a bill, and finally, in the most important step of Parliament, debating and enacting a bill. Weak answers to any of these questions should raise alarm bells and lead to heightened scrutiny and a consideration of alternatives. Having good answers to the questions that the Charter requires asks us leads to more thoughtful and considered policy, to better laws for all people in Canada. The absence of good answers and the weakness of arguments and evidence leads to poorly developed law, and that when that happens, the government should be held accountable for their choices. But if Section 33 is in play and the Charter of Rights and Freedom doesn't need to be respected, a government, for example, will be able to say without consequence that a law pursues a purpose that it really does not. A government will be able to assert that a law will have benefits without any evidence to support that assertion. A government can ignore more rights-respecting approaches to lawmaking, and a government can discount the interests of a minority or non-popular group who pose no threat to them at the ballot box. This is what we have to worry about if this use of Section 33 becomes normalized in Canada. Instead of thoughtfully considered, well-reasoned, logical and evidence-based laws that limit rights and freedoms and that are subject to strong checks and balances in the form of judicial review, like is happening before the courts, the use of Section 33 does away with this disciplined approach to lawmaking. The use of Section 33 can amount to a raw assertion of power over the rights and freedoms of people in Canada that is directly opposed to the way in which federal governance has worked for over 40 years. Despite Canada being one of the best countries in the world in which we live, we are far from perfect. We have made grievous mistakes in the past. Biases, blind spots, and prejudices are inherent in human beings and the institutions that we create and operate. This is as true of governments and parliaments as it is of any other institution in Canada. These all-too-human tendencies allowed us to think at one time that it was right and good and in the public interest to do several horrible things, including impose a head tax on Chinese immigrants, force generations of Indigenous children into residential schools. In 1939, churn away Jewish refugees from Germany on the MS St. Louis, and also intern Japanese Canadians during and after the Second World War. As a nation, we have come to regret these decisions, and we have apologized for them. The discipline that the Charter imposes on government decision-making and lawmaking helps to avoid tragedies like these from ever happening again in Canada. What new decisions will we come to regret in the future? If the use of Section 33 becomes normalized, we may have more regrets. For the sake of all Canadians, we should not find out. We should all commit to governing while respecting all rights and freedoms guaranteed in the Charter. We should commit to resisting the temptation to resort to the unnecessary and extraordinary powers of Section 33. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. L'honorable député.
The honourable member for Rimouski-Lambert-Tapédia. Thank you, Mr. Speaker. I listened to my colleague's speech, and the Liberals' central argument today turns around the Charter. They want to defend the Charter. It's the Charter, the Charter, the Charter. But the Charter is not a buffet. You don't get to just pick and choose. The Charter includes Section 33, which is the notwithstanding clause, and that is what allows for, that's what, how they arrived at got people to buy into the Charter. The Liberals, when they don't like something, they want to just ignore that part of the Charter. And they don't like what the Quebec legislation is all about. If you're going to defend the Charter, you have to defend the entire Charter. They're just picking and choosing. They're leaving parts out. So I'd like my colleague to explain, how can you defend the Charter when you don't want to actually fully recognize Section 33 of it?
Thank you, Mr. Speaker. We know that the notwithstanding clause can be challenged, and certainly we've seen that in Ontario. It has been tried in courts, and in some cases it has been overruled, or in other cases it has been ruled as justified. What we have before the Supreme Court is an assessment of the use of the notwithstanding clause and whether or not it does infringe upon the Charter of Rights and Freedoms. I think that it is important that this judgment is done before the Supreme Court that answers those four questions that I lined out. Have we done our due diligence? Is it being applied in a way that is respectful of the rights and freedoms of Canadians? And by that, I mean the rights and freedoms of all Canadians.
Questions and comments? L'honorable député de Compton.
The honourable member for Compton-Stanstead. I'd like to thank my colleague for her very interesting speech on the Charter of Rights and Freedoms, which is fundamental, and also the use of the notwithstanding clause. I'd like, if possible, for her to elaborate on the use of the notwithstanding clause and the preventive use of that clause, which is what is at issue right now. Thank you, Mr. Speaker.
Honorable Secretary Parlementaire.
Thank you, Mr. Speaker. I think using it preemptively, it's not giving due justice to the Charter of Rights and Freedoms. I think it's important that the laws are passed and that citizens can challenge them when they need to. And certainly that is the case. There are many citizens that are challenging Bill 21 that are saying that it is not respecting their rights and freedoms. They have the right to be heard in court. And I think it's important that we recognize that there was a great T-shirt I saw, and I always think of it. It says that equal rights for others does not mean fewer rights for you. It's not pie. And I think we have to keep that in mind. It is possible to protect the rights of Quebec.
I do have to interrupt the member. Question and commentaire.
Questions and comments. Now, a member for Joliette. Thank you, Mr. Speaker. Following the reasoning that the Honourable Parliamentary Secretary just set out, and which the government has defended in court, today in Le Devoir, the editorial said that if that reasoning were to be applied, it would entail rewriting the Constitution and giving judges the last word. And it goes on to say that following that logic, the courts would create a new criterion for assessing use of the notwithstanding clause and to judge its use on a case-by-case basis. So once again, that is taking the debate away from elected officials and putting it into the hands of the courts, which is what the federal government is trying to do here when it comes to the notwithstanding clause. And that is in Section 33 of the Constitution. Thank you.
Honourable Parliamentary Secretary, in a minute or less.
Thank you, Mr. Speaker. The Liberal Party is the party of the Charter, and our government is, people expect us to do our job, and that is defending the Charter. The Supreme Court decision will determine how federal and provincial governments can use the notwithstanding clause in the future. And because the case is before the courts, it's important for us to pay close attention to that decision. Resuming debate, the Honourable Member for Montcalm, and there's about 16 minutes left for his speech. Thank you, Mr. Speaker. In a very collegial way, I'd like to propose to my colleagues that they read a book that really enlightened me on what we're talking about right now in this whole debate. And I think there's a lot of misunderstanding of things. The book is called, and you might want to write this down, The Canadian Charter of Rights and Freedoms and the Legalization of Politics in Canada. It's not written by a blockist, nor by a separatist, or a sovereignist, whatever you want to call them. It's written by Michael Mandel, a professor of constitutional law at York University in Toronto. And it might help people understand, if they are proactive, the debate that we might have to have yet again over other pieces of legislation that may also come before the Supreme Court. Mr. Speaker, I'd like to say at the outset that I am a sovereignist, I'm an independentist, and because of that, I'm a Democrat. Because the ideal, the democratic ideal, lies in sovereignty, ultimately, and essentially. Canada, the federal government is using our money to fund groups to challenge Bill 21 in the Supreme Court. And the member for Bourassa had the guts to say that he opposed Bill 21, but everyone else has hid behind technicalities about the use of the notwithstanding clause. And we'll come back to that later. But I would point out that when it comes to law, legitimacy underpins legality, not the other way around. In the history of humanity, laws have been enacted and they were not legitimate. For example, segregationist laws. So to understand today's debate, you need to take a bit of a sociological look at law. Because when we talk about the Constitution and the Charter, people act like it's cast in stone and must never change, and it's the most faithful reflection of Canadian and Quebec realities. But the fact is, laws are not immutable. They change over time as people change in free and democratic societies. Otherwise, it becomes a democracy ruled by judges. It becomes a dictatorship or a straitjacket. So, before addressing the Liberal government's claim that there's a misuse of the notwithstanding clause here, let me take a bit of a look back through history to understand the context in which Bill 21 emerged. Mr. Speaker, when a human community established in one place that has one language, one history, one culture, a legacy, when that community becomes aware of its uniqueness, when they have a desire to continue to exist through history, when they join forces, well, then you have the existence of a nation. Mr. Speaker, the people of Quebec form a nation. And just because the House symbolically recognized and reluctantly the existence of Quebec as a nation, that's not why there's any legal meaning to this. That's not in the Constitution of Canada, because the Constitution has provisions that allow Quebec to exist historically, but that's fundamental. So Quebec is not just a distinct society. This was debated twice, and the rest of Canada said, no, you're not even a distinct society. I'd like to remind colleagues, and this has been said many times, never has any Quebec premier signed on to the Canadian Constitution, whether they were a federalist or a sovereignist. I just wanted to remind members of that, remind the Liberal members who are lecturing us and saying that they're a majority, that there's more of them than there are of us here in the House. The Honourable Member for Mirabel. If they want to chat, shouldn't they go somewhere else? I'd like to thank the Honourable Member. I think the problem is solved. The Honourable Member for Montcalm can continue. So no, as I was saying, no Quebec Premier has ever signed the Constitution of Canada, regardless of their political stripes, because that act usurped Quebec's status as a minority. So that usurped us of our status as a nation. Pierre Elliott Trudeau had a fantasy of establishing a bilingual and bicultural country, but that failed in the abyss of multiculturalism that does not promote interculturalism. And I'd also like to quote a multiculturalist theorist, Kimlicka, who said that this model, multiculturalism, does not fit a minority nation like Quebec. If Quebec was not guaranteed the substantive powers that it got, and if the English Canadian majority's decisions were to be imposed on Quebec, Quebec never would have joined the Confederation or would have seceded a long time ago. Well, we're the nasty separatists that with our majority, our language majority in Quebec, Apparently, we're the ones running roughshod over rights and freedoms. Well, let's be reasonable. This is all a bit rich. And one thing is sure. All the independentists and the whole movement all throughout history we have shown how attached we are to the very foundations of democracy. We didn't take up bazookas when we lost in 95. We continued to pay taxes to Ottawa. We continued to respect democracy, the parliamentary democracy in Canada. To wit, we're trying to get our viewpoints across in this place. And as long as we pay taxes, we have the right to be represented here. Mr. Speaker, I'm a child of the Quiet Revolution, and that was a period, an effervescent period in sociological terms, an unprecedented period. We moved from a society where institutions were run by the church to a secular state, a neutral state, neutral government. And when you look at conflicts around the world, every time religion was intertwined with politics, it didn't go well. There was polarization and war. It leads to intolerance and conflict. And that is why Quebec decided to separate the church from the state, to separate religion from government. Quebec is a French-speaking nation surrounded by 370 million Anglophones. We came up with our own model, of our own social model based on cultural convergence, established on 3 principles. In Quebec, intercultural relations are based on a common understanding. This is how we exist together. We share our various roots. In Quebec, everything happens in French. There's a separation between church and state, as I said, and we believe in gender equality. These things all go together.
I don't know of a single religion which does not make women subordinate to or lesser than men. If anyone can name such a religion, please feel free to rise and do so. Mr. Speaker, the issue we are witnessing in this debate is that judicialization of politics, and people misunderstand that. Parliament is expert at that. Parliament always waits for the courts to weigh in before they change legislation. The Supreme Court, their mandate is to interpret our laws using Section 1 of the CCRF. One can violate a charter right in limited, reasonable contexts, and that's part of our democratic society. The Liberals are not weighing in on Bill 21, but the courts will. The courts will determine whether Bill 21 violates freedom of religion and freedom of conscience. The Canadian Constitution was rammed down Quebecers' throats. When that occurred, Jean Chrétien bragged. I have a book at home. I should have brought it to quote from it. Jean Chrétien boasted about the clause saying that parliaments must be above the courts. So if the Supreme Court says your law unreasonably violates a charter right, well, then it's possible to use the notwithstanding clause to invoke it for 5 years. Then maybe you can amend the law so that it is in line with the court's recommendations 5 years later. But this is an attempt to devalue and undermine provincial parliaments. Now, the government could change the Constitution. I'm not aware of any notwithstanding clauses which were renewed time and time and time again, because parliaments debate and so we say either improve the law or reopen the Constitution. But this devalues political power. The Charter the Canadian Charter set out the relationship between Canadian politicians and the courts. Let's take, for example, medical assistance in dying. Judges forced the Parliament of Canada to legislate because we were way too far behind as representatives of the people. We were not doing what the people wanted us to do. Thus, the court found that we were infringing on people's right to choose. Now, across the way, they preach to us about rights and freedoms. Well, Quebec has just passed a law on advance requests for MAID in the case of Alzheimer's disease. 97% of Quebecers want us to go in that direction, but the 44 Quebec Liberal MPs, none of them rose to tell us that it was awful of us to not match the criminal code in Quebec's code. That's just an example, just one. This is a legalistic view which undermines the role of parliaments. In today's debate, we witnessed Liberals who lacked courage. Only one Liberal showed courage today. What we are asking for today is pretty simple. We want the government to withdraw its ridiculous factum. The factum claims that if the notwithstanding clause is used too much, unions will be abolished. I'd like to see a member make that argument, and let's see if they get reelected. They suggest that we could shut down churches, shut down newspapers. A church, you can have a church, you can have a Jewish school. That's all fine. We don't prevent people from having their religions. They just have to pay for the school or the church themselves. The state won't pay for it because of that separation. State secularism is a humanistic principle. This is why we call on the government to withdraw its factum. It being 6:26, it is my duty to take forthwith any question necessary to put the business of supply. The question is as follows. Mr. Fortin, seconded by Ms. Normandin, moves that the House A call on the government to fully withdraw from the legal challenge of Quebec's Act, respecting the laicity of the state before the Supreme Court. B, call on the government to withdraw its factum filed on September 17, 2025, with the Supreme Court contesting Quebec's right to invoke the notwithstanding clause. And C, denounce the government's willingness to use the Supreme Court to take constitutional powers away from Quebec and the provinces. If a member present wishes that the motion carry or be carried on division, or if a member of a recognized party participating in person wishes to request a recorded division, I invite them to rise and indicate that to the Speaker. The Honourable Member for Montcalm. Mr. Speaker, I request a recorded division. Pursuant to Standing Order 45, the division stands deferred until Wednesday, September 24th, at the expiry of the time provided for oral questions. Mr. Speaker, I thank the opposition member for the question. We Canadians believe in our ability to build. We can offer our children and grandchildren a great future. There were times in our history, during times of uncertainty, when we rose to the challenge. Today, we must again rise to the challenge because this is not only about oil, this is about Canada's economic independence. We can play an important role in the global energy future.
We need to build more projects of national importance. We're not ruling out new and expanded pipelines. Our efforts to advance major projects are about how we strengthen our economy, how we create certainty for investors, and how we build the resilience we need against unjustified trade actions. Canada has always risen to the occasion when faced with the challenges, drawing strength from our unity, resilience, and ambition. The new Major Project Office is our commitment to lead and to build the energy sector, acting as a single point of contact to prioritize and streamline nation-building projects that will secure Canada's place as an energy superpower. This unwavering focus is rapidly turning into action. Among the first set of projects that has been referred to the Major Projects Office for consideration, the LNG Canada Phase 2 project stands out as a transformative opportunity. Located in Kitimat, British Columbia, this proposed expansion will double the facility capacity, allowing us to export 28 million tons of liquefied natural gas each year. Canadian LNG is produced to the highest environmental and labor standards and will diversify our markets, strengthen global energy security, and reduce emissions by offering cleaner energy alternatives to the world. With its operation projected to emit 60% less greenhouse gases than the global average. LNG Canada exemplified how we can deliver energy responsibility while generating more jobs for Canadians. Grâce au Bureau des grands projets,
Thanks to the Major Projects Office, we are ensuring that major energy projects like LNG Canada Phase 2 will have the regulatory certainty they need to advance quickly and successfully. We will collaborate with other governments, Indigenous communities, and the private sector. In doing so, we are building the necessary partnerships to work toward a strong, lasting, and sovereign economy. We won't just build, we will build quickly and with determination. We will pave the way for many projects. We have legal obligations toward Indigenous peoples, and those are non-negotiable. Thank you, Mr. Speaker.
Mr. Speaker, the honourable member talks about LNG Canada, for example. I'm interested to know what roadblocks did C5 pull out of the way for LNG Canada? LNG Canada was well on its way to being built already. C5 has not created a new project in LNG Canada. And certainty for business, Mr. Speaker, the member talked about certainty for business. C5 gives no certainty for business. C5, all it does is say, you better go and lobby the federal government, go lobby the cabinet to get your particular project on the books. And then maybe if they say yes, what certainty for business looks like, Mr. Speaker, is a clear set of guidelines that if your project fulfills these types of things, you will be able to build it in Canada. You don't have to go to the cabinet and request special permission to build your particular project. Mr. Speaker, this government is a sham. It pays lip service to energy superpower and does nothing to get out of the way to make these projects happen in Canada. Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary.
Mr. Speaker, I'd also like to remind the honourable member and the House that our government, alongside the BC government, approved the Sealyssum LNG project just last week. As the Prime Minister said, we're diversifying our trade partners, we're developing new industries, we're strengthening economic activity across Canada to build the strongest economy in the G7. That is visionary leadership, looks like, and I'm here to say we're moving forward to make Canada an energy superpower. Thank you, Mr. President.
The honourable member for Swift Current, Kindersley, Grasslands.
Thank you very much, Mr. Speaker. Before I get the chance to follow up on the Ag Minister's non-answer to my question from previous time, this month my home province of Saskatchewan celebrates its 120th anniversary of joining Confederation. From humble beginnings out on the wild frontier, we have seen a lot of growth since then. Farmers have played an essential part in that every step of the way. We continue to be the breadbasket of the world, and we will always be proud of the people who get up early, stay out in the field for late nights, and work all year round to feed Canada and feed the world. Thank you to the farmers and for the producers for everything that you do. Mr. Speaker, it's been a long time since we've had an Ag Minister from Saskatchewan or from Western Canada who has first-hand experience of what prairie farmers are facing in their industry. So I just want to take a few moments to go over some of the key statistics that Saskatchewan producers and Canadian producers, what they mean for the world. So 22% is what Canada contributes for global canola meal. 21% of Canadian canola oil exports, or the global exports, are Canadian. 17% of canola seed exports are Canadian. 37% of exports for lentils are Canadian across the world. 27% of the global dry pea exports are from Canada. Now, from Saskatchewan, when you look at Canada at large, 87% of Canada's lentils come from Saskatchewan. 85% of our chickpeas come from Saskatchewan. 55% of Canada's canola is grown in Saskatchewan. This is why, Mr. Speaker, that I brought up the issue of tariffs on canola oil, canola meal, canola crush, and also on our peas that are being, yellow peas in particular, that are being tariffed by China. It's extremely important, Mr. Speaker, that the government understands how important agriculture is, not just to the Saskatchewan economy, but to the general economy as a whole. 1 in 8 jobs in Canada come from the agriculture sector. And with numbers like this, it underscores just how important agriculture is to Saskatchewan. Now, Mr. Speaker, as a representative for Southwest and West Central Saskatchewan, we are right at the heart, or right near the heart of what's called the Palliser Triangle in Canada, which is supposed to be an area that was uninhabitable for man. And yet, within that very region, the farmers of Saskatchewan and Alberta have been able to essentially feed the world when you look at these kind of numbers that we're producing when you talk about all kinds of various crops. So it's important for the government to understand just how important the export markets are. And with China being one of the major export markets with 100% and 76% tariffs on various products from China, as well as we've seen, we've had an up and down trade relationship with India. There are other markets around the world that have been on again, off again for us. It's important that those export markets remain available to our producers. And, Mr. Speaker, when we see the Prime Minister talk about how amazing he's going to be for our relationships with China and these other countries because he's got all this fantastic experience, at the end of the day, he's been in power now for over 6 months, and these tariffs still exist, and some of these tariffs were recently introduced. They're not even like they've been on for a long time. They're recently introduced, and the Prime Minister hasn't done anything with it. We know that with China, the only way that this is going to be solved is that the Prime Minister, it's going to be Prime Minister of our country to the leader of China. That's the only way that we're going to be able to get this resolved. The Prime Minister hasn't gone to China. Instead, he's been going off to Europe and other countries to do these well, more or less fake trade or these fake announcements of things that we already have in place with these countries. So I'm just wondering, Mr. Speaker, if this time the Parliamentary Secretary can tell the producers of Saskatchewan very clearly when these tariffs will be removed.
Hear, hear. The Honourable Parliamentary Secretary to the Minister of Agriculture and Agri-Food.
Thank you, Mr. Speaker. I'd like to thank the colleague for bringing once again this important question up, and I agree entirely with him. Our agricultural sectors are a pillar of our economy, and they feed not only our country but also a large part of the planet. It's an economic engine, like my colleague said, not only in terms of jobs but also in terms of our GDP. And I also add my voice to his to thank all of our farmers and canola producers.
That canola producers are facing the unfair tariff that China has imposed on canola products. And I just want to say that canola in Canada is one of the best in the world, and we should be very proud of that. We are responding to support the sector, and I want to mention a few things. I would like to remind the member that canola producers are front and center in the Prime Minister's recent announcement of measures to help them with the impact of tariffs. Those measures include the increase of the interest-free limit for canola advance payments under the Advance Payment Program to $500,000, Mr. Speaker, for the year 25 and 26. This change is expected to provide an additional interest savings up to $35 million, Mr. Speaker, to more than 6,000 producers of canola. In response to the canola sector call for domestic market, Mr. Speaker, the Prime Minister also announced more than $370 million to support the stability and resilience of Canadian producers of biofuel and renewable diesel producers. As part of this announcement, the Prime Minister also made a commitment to make targeted amendment to the Clean Fuel Regulation. Taken together, these efforts will support Canadian farmers through increased demand for feedstock used to produce these renewable fuels, such as the canola. And we heard at committee some of the sectors saying that it is indeed a growing the market, the domestic market economy for canola producers is really welcome. And he also announced a new funding of $75 million over 5 years to the Agri-Marketing Program to support diversification of agricultural exports into new high-growth markets such as Africa, Middle East, and also Indo-Pacific. So with this change, Mr. Speaker, we are standing up to support our canola farmer, and of course we will continue to negotiate with China so that they withdraw their unfair tariffs on our sector. Thank you, Mr. Speaker.
Member for Swift Current, Grasslands, Kindersley.
Thank you very much, Mr. Speaker. Now, Kevin Hirsch, who is actually a producer from Southwest Saskatchewan, he writes into the Western Producer on a regular basis, and his latest article that he wrote was on net farm profitability. And his whole point of his article is just showing with current prices, with input costs and the way things are, what the most profitable, what the biggest loss crops are. And right at the very bottom of that list is actually yellow peas. And yellow peas are the subject of these tariffs from China. So, and you go just back a year, yellow peas were actually, did quite well, and now they're down at the bottom of the list. So now you add this trade irritant with China, which is going to further exasperate the yellow pea growers. And that's that's one of the crops that actually grows quite well in Southwest Saskatchewan. And we're seeing very minimal returns on canola now with the price point the way that it is. We add this other trade irritant here. I mean, we need the Prime Minister to take it seriously, and the relief steps they're taking just don't cut it.
Parliamentary Secretary to the Minister of Agriculture and Agri-Food.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. Speaker.
The committee this week, the pea producers, and the situation is really dire there as well. China's tariffs imposed on the sector is really difficult. They will also be able to benefit from the support of the Strategic Response Funds of $5 billion to affected sector. It's not only the canola, it's of course the pea sector as well. And I would add also China has unjustified tariff also on pork industry. So we wanted a resolution that that China withdraw those tariffs. There's diplomatic effort at all levels. When the condition will be right, the Prime Minister will meet his counterpart. We need to have a diplomatic solution and free those tariffs from the sector. Thank you, Mr. Speaker.
The honourable member for Calgary Crowfoot.
Well, Mr. Speaker, when the Liberal government was first elected in 2015, it killed 16 major resource projects and chased $176 billion out of the Canadian economy. This resulted in thousands of lost jobs in my city alone and Bill C-69 continues to make it impossible to build the pipelines needed to unleash our resources and to restore our economic independence. So I asked in June, I asked him then, will the Prime Minister commit on that day to cancelling Justin Trudeau's No More Pipelines Bill C-69? And the response from the new minister was to say, we support new pipelines if there's a national consensus in favor of them. With our country facing American tariffs, we must strengthen our energy and natural resource sectors. There's no question that that energy is Canada's power, will help build the strongest economy in the G7, create jobs for Canadians, give the best cards to our negotiators on the negotiating table. Canada's new government will win this trade war. That was the response. And there's a lot to unpack in that response. To start with, so he said that if there's a national consensus, well, they don't even have a consensus in their own caucus about pipelines. How are they going to have a consensus? The word consensus means every single person agrees. And that is not a reasonable bar for this government or any government to set for whether or not there will be something as critical to our economy as pipelines to be built. But talked about the strongest economy in the G7. Well, Mr. Speaker, Canada is a country within the G7 has arguably actually probably not even arguably, it's a fact, the weakest right now economy in the G7. We have declining per capita GDP as we speak, and over the last number of years, while this government has been in power, Canadians have been getting poorer. Per capita GDP declining. This is a decline in the living standards of Canadians that this government has presided over. And they're talking about jobs and talking about the importance of energy. Well, Mr. Speaker, this government has spent literally 10 years chasing capital out of Canada, chasing jobs out of Canada, doing everything it can to strangle the energy industry in Canada. And so, Mr. Speaker, it is hard to take these sort of mixed words that they have now about claiming to support energy at face value, when their response, for example, is to bring in a bill, C5, which is where it gives the government the power to interfere politically, to decide and pick and choose when they want to dispense with the rule of their own laws and not apply the laws that they created that are preventing private investors from building infrastructure in this country. They could just do as I asked in my question, or what we've been calling for the last 10 years. Get rid of Bill C-69. Get rid of Bill C-48. Get rid of the emissions cap. Get rid of the industrial carbon tax. Get rid of the EV mandates. Repeal the so-called clean fuel standard that they brought in. Rein in their spending. Bring in a balanced budget, restore the public finances of this country, establish conditions upon which private investment can once again flourish in this country, and get Canadians back working in the energy industry so that we can supply clean, reliable energy to the world.
Parliamentary Secretary to the Minister of Energy and Natural Resources.
Mr. Speaker, I'd like to thank my colleague for the questions, but also remind my honourable colleague that thanks to the One Canadian Economy Act, voted, which I believe with his support, we're getting projects off the ground faster. We're making Canada strong by strengthening our economy while protecting our land, our water, and our people as we grow. This government's action shows exactly what kind of country we want to be. One that builds, works shoulder to shoulder across governments, protects our environment, and respects Indigenous rights every step of the way. Let me say that what I believe every member of this House knows. Canada is a nation built on ingenuity, resilience, and the courage to seize new opportunities in the face of global challenges. At this transformative juncture, as the world adjusts to dramatic realignment in trade, energy security, and technology, Canadians expect their government to move boldly and responsibly, not only to protect our interests, but to build prosperity for all. Recent months have demonstrated just how vital Canada's energy sector is, not only here at home, but on the global stage. Faced with punitive tariffs abroad, shifting geopolitics, and a new competition, the stakes for Canada's energy future have never been higher. Our allies are calling for energy that they can trust, reliable, secure, and low-carbon sources of energy that underpins economic sovereignty and security. Today, I'm proud to say that Canada has what it takes to rise to this challenge. Across conventional sources and in renewable and clean energies that promises growth and innovation for generations to come. Monsieur le Président, notre gouvernement...
Mr. Speaker, our government is determined in strengthening Canada's position as an energy superpower. It is in our collective capacity to master our destiny, to build lasting prosperity, and to support our allies who depend on our resources. Sovereignty, security, prosperity, these are not just words, they are the values that guide all of our decisions. We are focused and not wrapped up in red tape, and this means we want to protect our economy and our environment, and so it really benefits Canadians and our energy sector. This attracts investments worldwide and countries that want to buy our energy that is responsibly produced. Cooperation is at the heart of our changes with greater flexibility and this one project, one examination approach, which means that it will eliminate obstacles. For companies and communities, this means that decisions will be made more rapidly and fairly, as clearly indicated by the Prime Minister. It is one of the biggest objectives of our new government and the intention of the Large Project Bureau.
This parliamentary secretary, it's as if he has no background information at all over the track record of this government that he speaks for. He speaks for a government he said in his response just now that our allies are calling for Canadian energy. Indeed, they are, Mr. Speaker. They have been for 10 years. And this government, the government that this parliamentary secretary speaks for, loudly told our allies that there was no business case for Canadian LNG. That is what the Prime Minister of Canada, then Prime Minister of Canada, had to say. That is the government that has been in power for 10 years, and it's as if there's some kind of out-of-body experience where these Liberals aren't aware of who's been running the government for the past 10 years and been chasing away investment, including investment in LNG that would supply the world with reliable Canadian energy.
The Honourable Parliamentary Secretary and Minister of Natural Resources and Energy.
Mr. Speaker, we in this new government are working side by side with Indigenous people, provinces, territories, and proponents to build rapidly and build the right way. That's why with the Building Canada Act, we're creating a process that truly reflects what Canadians want and what Canadians value: efficiency, common sense, and a commitment to build Canada strong. It's also what investors around the world want: a commitment to do what's right as we rapidly develop, produce, and sell our natural resources. We're quickly advancing major projects while keeping our commitment to protect the environment and respect the rights of Indigenous people. Thank you, Mr. President.
Order. The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 2:00 p.m. pursuant to Standing Order 24-1.
you.